ಶ್ರೀರಾಮ್ ಸರ್, ಮೊನ್ನೆ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಮಾಡಿದ್ರಲ್ಲ ಬೆಳಗಾಂದ, ಇದು ರಿಂಗ್ ರೋಡ್ ಅದ್ರ ಕಾಪಿ ಐತಾ ನಿಮ್ಮ ಇಲ್ಲ ತರ್ಲ ಇಲ್ವಾ?
The tax matter, my lord, 230, my lord. The expert order has been passed. A bank account has
138 and 8.
230.
One matter, my lord. Into total 6 matter, my lord. GMRAC. Blood, I think DC without the DC, without further notification, my lords, passed an means notification, my lord, for preparation of tower.
ಕೊಡಿ ಅಲ್ಲಿ ಸರ್ವ್ ಮಾಡಿ, ನೀವು ಇಷ್ಟು ಜನ ಮಾತಾಡಿದ್ರೆ ಇದು ಅರ್ಧ ಗಂಟೆ ಇದೆ. ಕೊಡಿ ಎಲ್ಲ ಯಾರ್ಯಾರಿಗೆ ಸರ್ವ್ ಮಾಡಬೇಕು ಸರ್ವ್ ಮಾಡಿ.
ಎಲ್ಲ ಆಗಿದೆ ಸ್ವಾಮಿ, ಎಲ್ಲ ಆಗಿದೆ.
ಸೈಡ್ ಇಲ್ಲ ಅಂದ್ರೆ
ಇಲ್ಲ ಅಲ್ಲಿ ಏನಾಗ್ತದೆ
138 of an act. 138 on act. Issued NBW against.
ಅದು 2
ಕೊಟ್ಬಿಡ್ರಪ್ಪ ಎಲ್ಲ.
My lord, one matter for 230, my lord.
230 ಕೊಟ್ಬಿಡಿ ಅಂತ ಹೇಳಿ ಆಯ್ತು. ಅದೇ ಇದು ಮೆಮೋ will be 1 hour.
My lord's permission.
My lord, one matter for 230.
Serial number 1 and 2. Serial number 1 or 2. I am for respond. It may be allowed.
Yes. Here who is on the VC?
My lords, if I could make a submission.
My lord, 230, my lord, today.
6 matter. Serial number 12, list 2, my lords.
Yes, adjournment, please wait.
My lords, no, it's a kind request. It will be taken up at 2:30, my lords, for the reason that the urgency being that an
Please
order has
wait,
been passed.
madam, when we call the matters.
My lord, one memo for 230, my lord.
Yav memo, Mr. Shiprasad?
My colleague, Miss Vinuta is there, my lord.
Nimda? ಮತ್ತೆ ಹೇಳ್ಬೇಕಲ್ಲ ಏನಾದ್ರು.
Please, my lord.
My lord, for 230.
Yes, all 230 allowed.
My lord.
Petition dismissed, memo allowed.
My lord. My lord, may I mention, my lord?
My
lord, one matter today date was given, my lord, not listed. I have filed the affidavit, my lord. Matter may kindly be disposed. Not to file equity.
Thursday thought.
Please.
ಮತ್ತೆ ಇನ್ನೊಂದು ಮೆಮೋ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
List 1 adjournments.
Adjournment ಮಾಡ್ಬೇಕಾ? ಯಾವ್ದು ಆಗತ್ತೋ ಒಂದು ಮಾಡ್ಕೊಂಡು ಹೋಗೋದು ಅಷ್ಟೇ. Why waste time ಅಂತ. ಶುರು ಮಾಡಿ. List 2 ಮಾಡಿ first.
List number 2, total number 6 matters.
Silver 9.
ಒಂದೊಂದು
Silver 9.
ಹಂಗ್ ಬಿಟ್ರೆ ಆಗಲ್ಲ.
I am Mullah.
Yes. Yes. Yes, Mr. Mullah. Yes. Any urgency or adjournment?
Adjournment.
Adjournment.
Lord, I am for the respondent. Filed an earlier for
ಅದಕ್ಕೆ adjournment. ಇಲ್ಲಾಂದ್ರೆ
the date was fixed today, my lord. Please.
One, at the request of counsel for the petitioner, released on 6th. ಗೊತ್ತಿಲ್ಲ ಅಲ್ಲಿ ಹೆಂಗ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. ಆಮೇಲೆ
Interim order may kindly be extended.
interim order earlier granted is extended till next date.
2, Srihash Nilopan.
My lord, adjourn.
2, at the request of counsel for the petitioner, 6th.
3, VM Shilwan.
6th.
4, H.N. Gulreddy.
Yes.
H.N. Gulreddy.
Election matter, my lord. Election matter, adjournment. Maybe adjournment.
Interim order there. 4, 6th.
5,
6th.
Praveen H. Reddy. 5,
If 10 days time is granted to make payment of process fee, if needful is done, registry is directed to issue notice to the unserved respondent, written up by 29th April.
6, A.C. Chaklabi.
Please, I am for the respondent contesting. They have come up for the against the rejection of nomination. After the declaration of results, my lords, they have come up before this honorable court. And there is an interim order. So kindly, this matter will be taken up today.
6th interim order. Yeah, no, it will be taken up from
All
6th
the
interim order earlier granted.
please.
7, Umme Salma.
Your Lordship, it's a matter of parole, Your Lordship.
Parole.
Yes, Your Lordship. 302.
Got instructions, Mr.
Your Lordship, it's
Yes.
a third time. It's coming third time, Your Lordship.
In this case, my lords, the first time parole is for the first time.
Michael ಮಾತಾಡಿ ಅವ್ರು ಕೇಳಿಸ್ಬೇಕು ಬರೀ ನಮ್ಗೆ ಅಲ್ಲ.
Sorry.
ಇನ್ನೊಂದು ಮೈಕ್ ಇದೆ ಅಲ್ಲಿ.
Okay.
ಅವ್ನು ಓಡಿಸ್ಬಿಟ್ಟು. Yes.
Sorry. This case, my lords, 302. My lords, trial court has granted, my lords, the sentence for death. In the appeal, it is modified. He was not released for once also, my lords.
11 years is undergone.
Idare. Please. 30 days, my lords.
In parole for what reason?
Medical, Your Lordship. Medical of mother, Your Lordship.
Medical of mother. ಎಲ್ಲಿ?
Page number 16, Your Lordship. Annexure D. All three brothers are in JC, Your Lordship. First time we are seeking for parole, Your Lordship.
All
Only
three
mother
are
is outside. Only mother is outside, Your Lordship.
And AGA accepts notice for respond number 1 and 2. Petitioner is before this court seeking for the following reliefs. The petitioner was convicted. Details ಇಲ್ಲ.
Page, Your Lordship, page number 15, custody certificate, Your Lordship.
Was convicted in SC number 114 of 2014 for offences under 324, 302 and 506 for death by the trial court. Subsequently, the appellate court commuted the same to life imprisonment. The petitioner has been in custody from
For 11 years, 2 months.
ಯಾವಾಗ ಹೇಳ್ಬೇಕು ನೀವು
Hmm.
for a period of 11 years, 2 months and 9 days.
9 days.
The petitioner is before this court contending that his mother is suffering from uncontrolled hypertension and diabetes with pedal edema and being in a semi-conscious state, as regards which a medical certificate has been produced. The petitioner is seeking for 30 days parole.
Your Lordship, 90 days, Your Lordship. He will be considered.
Seeking for 90 days parole to take care of his mother. Learn AGA upon instructions submit that the conduct of the petitioner.
Allah, there is no remission, my lords, in the jail. Remission ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ the conduct
Conduct
is
ಹೆಂಗಿದೆ?
Good, Your
blank
Lordship.
ಕೊಟ್ಟಿದ್ದಾರೆ, ಇನ್ನೂ ಬರ್ದೇ ಇಲ್ಲ.
Custody.
ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ಏನೂ ಬರ್ದೇ ಇಲ್ಲ.
Custody
ಏನು ಬರ್ದಿಲ್ಲ.
certificate 15. Good.
ಅದನ್ನೇ ಹೇಳ್ಬೇಕು ಅವರು.
ಇಲ್ಲ, they have not mentioned anything, my lords, but the certificate produced by them, it is shown as good. Certificate given to me,
Of the petitioner has been good and there is no remission which has been granted or permissible. On inquiry as to whether the petitioner had been released on parole on any earlier occasion, he submits that the petitioner has not been so released. Taking these facts into account and taking into account the medical certificate which has been produced, I am the considered opinion that as of now, the petitioner can be released on parole for a period of 30 days to
Your
take
Lordship,
care of
60 days. Your Lordship, at least 60 days, Your Lordship.
any extension and or further application for parole would be considered on the basis of the conduct of the petitioner during this time. In that view of the matter, I pass the following order. Writ petition is allowed. Respondent number 2 is directed to release the petitioner's son having a CTP number 4 being the convicted prisoner.
4251.
N number other?
4251, Your Lordship.
What is the number called?
CTP number, CTP
CTP number 4251 to be released on parole for a period of 30 days, commencing from 27th February 2025, as the usual conditions.
With liberty, Your Lordship.
Yes, they're all conditions.
8,
God
Satish
bless you.
MS. Satish MS.
We've taken up next week notes.
The request of counsel for the petition released on 5th.
Please.
9, KH Bagi.
So taken up 27th, my lords.
In 27th. In
Please, election matter, my lords. Already election has, my lords, election has been done, my lords. Only that counting is there, my lords. They have to count and declare it.
Subject to election petition.
Please. Lords, they are says the only.
I'm responding in this case.
As per this judgment of this lords. Lord 13D, but is my here, my lords, Savarda Cooperative Society. So the parameters are the same, lords.
Yes.
Parameters.
I'm responding in this case. That this society is not covered under that act, lordship. The society is covered under the Savarda Act, lordship. But
Any difference in apa?
the difference is there, lordship. Can you see, rule of 5D, lordship. There's no mandatory person, lordship, as per the Cooperative Society Act 13 to D, lordship. Therefore, all the what are the condition is imposed in that 5B, lordship, all is complied, lordship. The original file is there, lordship. Election original file.
New Year.
Society, lordship. It's one of 5.
So why are you objecting so much?
Also, now he claiming that is the
Why
getting.
is the society objecting so much?
I am election chief executive officer, lordship. He is saying that I have not complied, follow the rules and regulations, lordship.
If they want to do it, we are remitting them, we are remanding them to the election petition. I'll mark on that. They'll produce proof. Can we decide on that now?
That's true, lordship. What their contention is that I am not issued the mandatory notice, lordship. But all the petitioners are not ineligible on the ground that.
Then he'll decide madbeka, election petition will decide madta. They'll raise that issue there. Evidence will be laid. If required, you can also lead evidence.
That's we admitted, lordship, in this part, that point. But the petition itself is wrongly intimated to the court, lordship. He is disqualified on the ground that notice is not issued, lordship. But it's not so, lordship. They are they are some of the petitioners are defaulter, lordship.
But this is a common order being passed by the court.
That's why I want to hear the matter.
Petitioner is before this court. Really order ಮಾಡಿರೋದು.
Lords, the given judgment.
Petitioner is before this court seeking for the following relief. During the pendency of the home matter, elections have been held and results are to be declared. The division bench of this court, in its order dated 7 June 2020, single judge of a coordinate bench of this court in its order dated 7 June 2022, in WP number 8502 of 2022, has held in similar matters that the counting is required to be completed, results announced, and liberty was reserved to avail the remedy of filing an election petition if aggrieved by the results.
Yes.
I am of the custody opinion that the said order would also be applicable to the present matter. Hence, I pass the following order. Writ petition is disposed. The returning officer is directed to announce the result within, after counting of the votes within.
Any date, my submission only, lordship. The what is making submission under Cooperative Society Act, lordship, that is not applicable to
Within 3 days from date of receipt of a copy of this order, all contentions and allegations of the petitioner are left open to be agitated in a proceedings in an election petition, if and so filed. Any defenses of any of the officers and or other and or the elected members would also be agitated in said election petition.
Can declare, my lords, or Friday or Saturday, whatever date may be.
3 days until either.
Please, sorry.
Pending IA does not survive.
Vishwanath Pichigatti.
Number 3, my lord, airport authority.
has constructed the wall by encroaching my private property, my lord. KIDB has confirmed that they have not acquired my land. Acquisition proceeding survey has also confirmed that there is an encroachment of over my land. Airport authority, my lord. 7 guntas have been.
Initially, I was directed, my lord, to appear on behalf.
Pilwa. CGP R3 Avinash Angdi. Shri Avinash Angdi submits that he does not appear for respond number 3.
Mrutyunjay Hallikeri.
In Shri Mutunjay Alikeri, the panel counsel for respond number 3 is directed to accept notice for respond number 3. Counsel for the petitioner to serve 2 sets of the petition along with annexure on the said counsel. Registry is direct print the name of Shri Alikeri as that appearing for respond number 3 and delete the name of Shri Avinash M. Angdi. Released on 5th March.
Lord, may I request for Friday, my lord?
Ian, give them the copies.
Please.
11, Sunil Desai.
Yes.
So request on 27th, Your Lordship.
Why? Today or after in March? We are not going to be having it in 27, 28. At the request of counsel for the petitioner, 5th March.
12, Naveen GS.
My lords, I appear for the petitioner. My lords, we are challenging the order which has been passed under section 74(9) of the CGST Act. My lords, no grounds have been put up as to why such an order has been passed. And further, my lords, it's only for the extension of the time periods, which is why the order has been passed, my lords. And my lords, and the reason that this 31st March 2025 is the last date up till when we can take the benefit of the amnesty scheme, my lords.
31st March.
31st March, my lords. And my lords, there's a apprehension that my bank account would be attached, my lords.
They also filed an appeal, my lords, challenging the order. Appeal is also filed by them.
Appeal is also
filed. Only in order to evade the, my lords, the payment of tax. Unless, my lords, until the, my lords, the officer find out they have not declared what is declared, they have.
Give us the appeal memo.
My lords,
they have mentioned in the appeal petition itself.
If you have filed appeal, why are you before us?
my lords, for the reason, my lords, my appeal has not been taken up, my lords. The reason, if my appeal is not taken up before 31st March, my lords, I'll be left remedialist. My lords, also the fact we have already paid the tax, my lords.
March is 1 month away, madam.
My lords, my only thing is the appeal is not being taken up, and my lords, I have already paid the tax.
Why
My
is it
lords,
not being taken up?
my lords,
Before whom have you filed the appeal?
They have deposited, my lords.
My lords, if I could make one submission, my lords. My lords, we have already paid the tax, my lords. It's only on the interest and penalty, which is why the section 74 has been invoked.
Don't
My lords,
replace the High Court for the appellate authority. You have filed an appeal. The appellate, before whom have you filed it? Designation of the officer is against. Before whom is it filed? Who is the appellate
Para
authority?
7 dalli avare ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. Para 7 of writ petition. They themselves have stated that under section 107 GST Act before the appellate authority challenging the adjudication order dated so and so.
Who is the appellate authority? Appellate authority yaru andre our direction
Joint Commissioner. Joint Commissioner.
Joint Commissioner of Commercial Taxes Hubli,
Please,
na?
please.
The apprehension on part of the learned
it
counsel
could
for
be
the
taken up at 2:30, my lords. It needs
We'll
consideration.
direct them, we'll have it in March. If they don't take it up, we'll consider it.
My lords, kindly, my lords, they should not proceed. My lords, the request that no prescriptive action will be taken against me, my lords.
Yes. The apprehension of the petitioner is that despite the petitioner having filed an appeal under section 107 of the CGST Act, the appeal not having been taken up, coercive steps are likely to be taken against the petitioner. The appeal having been filed before the Joint Commissioner, Commercial Taxes. When did you file it?
My lords, dated
28 August 24.
20.
Adjudication order 28/5. When was the appeal filed?
28 August 28/8.
28/8/24.
24.
Why is it still pending? Not taken up.
My lord, it's not been taken up, which is the reason
Not
why
been
we've
taken
come
up
up with this wonderful.
for consideration. It is rather shocking that an appeal filed is pending to be taken up for consideration for nearly 6 months now. In that view of the matter, the Joint Commissioner is directed to take up the appeal on merits at the earliest. Until orders are passed, respondents are restrained from taking any coercive steps against the petitioner. Relist on 17th March.
Grateful, my lords.
13, Chenugul Reddy.
Kindly next week, Your Lordship. Next.
At the request of counsel for the petitioner, 5th March.
14, Anirudh Nayak.
My lords, this case is a service tax demand which is based on income tax data where the principal bench has in a batch matter disposed of these cases by remanding the matter back to the adjudicating authority for reconsideration.
Yeah, who is for the respondent?
Mr. Girish Mulmani, he is online.
Yes, Mr. Girish. Same order would apply? The Union of India arrow.
Yes, my lords.
Girish Mulmani. Union of India. Mata? MB Kanvi for respondent number 1. Girish Mulmani for respondent number 2 and 3. Petitioner is before this court seeking for the following relief. The submission of the counsel to the petitioner is that the list in the above matter is covered by judgment of the coordinate bench of this court, dated 3rd July 2024 in WP number 1154 of 2023. Learned counsel for the respondent 2 and 3 also confirm the said submission.
The last 2 pages.
In that view of the matter, I pass the following. In terms of the observation made in the order dated 3rd July 2024 in WP number 1154 of 2023, the above matter is relegated to the officers to be designated in terms of the observation made in para 8 of the said order at the same stage. Like in column 1, column 2, column 3.
Setting aside, because there were orders in original, there were show cause
column 1,
notices.
column 2, column 3.
No, wherever there were orders in original, they have set aside.
Where do you come in this?
I come in the order in original, my lords. Annexure C needs to be set aside, matter be sent back for re-adjudication.
Order in original has been passed, madam.
I'll just hand over a subsequent order which may make it simpler, my lords.
This is covered by the decision in 3rd July 2024 in WP number 1154 of 2023, wherein it is held as under. In view of the above, the present petition is also disposed in terms of the aforesaid judgment of the coordinate bench of this court. Accordingly, the impugned order at annexure
C
dated ಬೇಗ ಹೇಳಬೇಕು.
Sorry, 29/7/2022.
29/7/2022.
Page number 30.
Is squashed.
My lords, may I just make one mention? Serial number 33 and 34 also same.
Then it comes.
Great.
15.
ಯಾವುದು? As and ಅಲ್ಲೇ ಇದೆ ಆ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದೆ. Para 13. Para 13.
Lordship, kindly have it done 27th, Your Lordship. In this matter, senior counsel has been.
Not 27th. First week of March or second?
No, Your Lordship. Court is given the date to Lordship. The
Court is not sitting on 27th and 28th.
Lordship, government also filed the objection, Your Lordship.
ಮತ್ತೆ ಇವತ್ತು 27th ಇಲ್ಲಿ ಬಂದ್ರೆ ಏಪ್ರಿಲ್ಗೆ ಹಾಕ್ತೀವಿ. ಕೇಳಲ್ಲ ಅಂತೀವಿ.
Yes, Your Lordship. Please.
15 relist on 27th.
Please.
But not before this page.
16, Santosh Kolkar.
Yes.
In this case,
Really?
I have offered the land for a petroleum outlet dealership as per the advertisements.
Of lots.
In spite of considering the same.
Who is HPCL? CV Angli, na? CV Angli is directed to accept no. Already there.
You filed a.
Yes, Mr. Angdi.
CBND.
None appears for the respondent. Relist on the 5th.
17.
The interim order may kindly get.
Interim order.
Sunanda P. Patil.
Yes.
It may kindly be next week, my lord. Interim order may kindly be extended.
Notice agidya.
Notice. I have served the notice, copy of the writ petition on the counsel appearing before the trial court, your lordship, and none appeared before this honorable court, my lord.
Then we'll have to issue notice.
Please, ma'am.
Issue notice to respond number 1 to 5
Emergent notice.
returnable by 22nd April. Interim order earlier granted is extended till next date.
18. Ipapa Vandodati.
None appears, released on 11th March.
19. Vasudev Naidu.
Sorry. Shri M.B. Kanvi is directed to accept notice for respond number 1 to 4. Counsel for the petitioner to serve 2 sets of the petition along with the annexures on the said counsel. Released on 11th March.
20. VM Shilwant.
My lord, sir, we have preferred and writ appeal. The interim protection has been granted by the division bench, my lord. There's a direction not to precipitate until the next date of hearing. It's on
Only there.
10th March.
At the request of the counsel for the
My lord, kindly have it on 12th, my lord. I am the respondent number 8, party in person, my lord, in this case.
Yes,
Kindly have
12th,
it on 12th, my lord.
12th March.
21. AI Mullah.
May kindly be adjourned. Other side has also no objection. Muhammad Ali advocate.
Released on 12th March.
22. Srinivas Nayak.
Request for a week's time.
Counsel for the petition
Yes.
seeks fund is granted 2
There's
weeks
an
time to
interim
comply with office objection. Released on 14th March.
23. VP Odvi. Exit
Order 23 awaiting service released on 14th March. 24 to
My lord, submission for 24, my lord. There is urgency of the matter to be heard, my lord, because it is 2008 matter where we had
we
challenged.
can't be taking up that court and this court in 2 days.
Kindly have it on 27th, my lord. Even last time it was adjournment was taken without even informing us.
Madam, 27th we are telling you the court is not going to be sitting.
28th at least, my lord.
We are not going to be taking it up.
Please, my lord.
So what is the point in your asking all these dates? When
Any-
you are told something, please listen to it. 24th, released on 6th March.
Please, my lord.
26.
25 to 33, 6th March.
One submission.
26 ದಲ್ಲಿ
32, my lords, there is a specific, I'm mentioning 32, my lords. 32, there is a specific order to list it in fresh matters list, my lord, on the last occasion.
So,
That may be, my lord, clarified.
Whatever
It
it
is still listed in B group, my lords.
33.
I'm sorry, serial number 33.
Yes.
It's the same
Same matter.
Same
Okay.
as.
Till 32, 6th March. 34 to same, huh?
4 same, my lord.
35 to 40,
39, interim order express.
7th March. 41 to 48.
43, your lordship.
47.
43, they don't have any.
43, my lord, I have no objection to allow it.
43.
Serial number 36. It will be taken after 2 weeks. Serial number 36.
ಹಿಂಗೆಲ್ಲ ಇದು ಮಾಡೋದು 25 6th March 26th 6th March
Lordship, serial, serial number
26th
26.
6 ಏನಾದ್ರು ಇದೆಯಾ
Lordship, serial number 26, Lordship, in that respond number, Jagdish Patil sir Hesrali, Vinay Kaujulgi's name may be shown.
26 registry that delete the name of Shri Jagdish Patil as that appearance and print the name of Shri Vinay S. Kaujulgi as that appearing to respond.
Rendered infectious or counsel is expired. Sir. Very important
The
petitioner.
counsel for the petitioner is stated to have expired. Issue notice to the petitioners returnable by 24th April
My lord, 48.
2026. Court notice. 27, 6th March, 28, 11th March, 29,
29.
11th March,
30.
11th March,
31. Gopal Patil.
same 11th,
32. Girish
11th.
Advard.
11th, my lords.
11th, 33, 23 Shivraj Badoli ಅಂತಿದೆ.
ಇಲ್ಲ, but Girish Ulmani ಅವ್ರಿಗೆ we have given a copy last time.
Shri Girish Ulmani submit that he would be appearing for respond number 2. Registry is directed to correct the appearance and delete the name of Shri Shivraj Badoli as that appearing for R1 and R2. Shri MB Kanvi is directed to accept notice for respond number 1. Petitioner is before this court seeking for the following reliefs. Agli yavadappa idu?
14.
CL number 14, same order.
My lords, 34 also same.
34. Shri MB Kanvi is directed to accept notice for respond number 1 and 2. Shri Girish Ulmani accepts notice for respond number 3 and 4. Registry is directed to delete the name of Shri Shivraj S. Badoli as that appearing for R1 to R4. How are you?
Illa, we had given them the notice, but then he denied. Then
can you put like that? Before this court, same as CL number 14.
Deeply
Annexure
C in serial number 34 and annexure G in serial number 33.
33 annexure G, 34 annexure C. Question.
Deeply obliged.
35 Bhushan Kulkarni.
2 weeks time is granted to the respective councils to comply with their office objections. Relist on 11th March.
36 Harmat Latour.
Relist on 17th March.
11th March. 37 HM Darigon.
6th Malay, seeking mandamus.
March.
38 also 6.
38.
6th
March.
39 PG Mogali.
Relist on 11th March, interim order extended.
40 PG Mogali.
Same order.
41 Jayant Itigi.
17th March.
42 Dinesh Kulkarni.
42 months. For R3 I have filed a wakalas. My name is not Shivraj Badoli.
Shri Shivraj Badoli submit that he has entered appearance for respond number 3. Registry is direct print his name as such. Copies bandidiya?
Yeah, but notice.
Relist on 17th March.
43 Surita P. Kalsur.
In this case, I have no objection to allow the writ petition, and I request your lordship kindly direct the family court to dispose of the petition.
How year the matter?
2021.
23 your lordships.
It's only diverse petition.
There are so many divorce. Nimgena, you can't take that order.
They filed IA number 12 under order 6.
Test filing is in family court.
Yes, yes. They filed application under order 16 rule 6 for summoning the document from the institution. That IA may be allowed. Yes.
Petitioner is before this court seeking for the following reliefs. Respondent had filed a proceedings under section 13(1)(1)(a) of the Hindu Marriage Act in MC number 497 of 2023. The petitioner, husband, had filed an application under order 16 rule 6 for
summoning the document
of the Code of Civil Procedure for summoning of certain documents from the employer
institution where
of
The petitioner who was earlier working your lordships.
of the petitioner wife. The said application came to be dismissed vide order dated 8/1/2025.
Serial number 21.
Since the application had been filed at the stage of arguments. ಆಗೋಗಿದೆಯಲ್ಲ ಈಗ.
argument ಇದೆ stay ತಗೊಂಡಿದ್ದಾರೆ.
Final arguments.
21.
It is challenging the same, the petitioner is before this court. Learned counsel for respondent husband submits that due to the order of stay which had been passed, the proceedings before the trial court have been stopped. As such, the petitioner respondent has no objection for allowing the application, allowing the writ petition, and thereby allowing the application order 16 rule 6. His submission is placed on record. In that view of the matter, I pass
Affidavit
the
is also
following
filed your lordship. Affidavit is
for safer side.
An affidavit of respondent has also been filed in this
Please.
regard. In that view of the matter, I pass the following order. Writ petition allowed, a certiorari is issued, the order dated 8/1/25 passed by the first additional principal judge family court Hubballi in MC number 497 of 2023 in IA number 12. Filed under order 16 rule 6 is set aside. Consequently, IA number 12 is allowed. the formal order of summons is directed to be issued by a trial court in terms of the above order.
Okay. Obliged.
44,
ಏನ್ ಮಾಡೋದು ಅದಕ್ಕೆ ಏನ್ ಮಾಡೋದು ಅದಿಲ್ಲ ಅಂದ್ರೆ ಬರ್ಕೊಂಡು
44, DB Kariga,
May please, my lords.
17th
Please, oblige, my lords.
45,
17th
Interim order.
interim order
46, Prakash Udikeri,
18th
47, Nagrasi Kolluri,
I will have it on. After
notice
2 weeks.
ಹೋಗ್ಬೇಕಾ R4 ಗೆ
After 2 weeks.
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು impleading application ಇದೆ
I'm proximal.
issue notice on the impleading application returnable by 22nd April.
Please.
48, PS Nilopant,
On short date, Your Lordship.
Released on 7th March, interim order earlier granted is extended till next date.
Please.
Permitted to withdraw the
117.
17, madam.
ಯಾಕೆ ಕಂಪ್ಯೂಟರ್ ಕರೆದ್ರ ಕಂಪ್ಯೂಟರ್ ಕರೆದ್ರ 117. Petitioner is before this court seeking for the following leave. The memo dated 25/2/2025 has been filed, signed by petition number 1 and 2, as also the counsel for the petition, which reads as under. Accepting the said memo, petition is dismissed as withdrawn. ಏನಪ್ಪ ಯಾಕೆ
102 ಅಲೋ ಮಾಡಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅದು ನೋಡಲ್ಲ
ಸ್ಪೀಡಲ್ಲಿ ಹೋಗೋದು ಸ್ಟಾಪ್ ಆಗೋದು
my lord, serial number 102, my lord. I pray to allow, I'm for the respondent on instructions, my lord. I pray to allow the writ petition, my lord, because in the FDP proceedings, instead of appointing Tahsildar, Taluka surveyor.
Later.
Please.
list 1, MM Swami,
Let's serial number 115. I undertake to file wakalat for the appellant.
ಅದು ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ ಇವಾಗ ಸುಮ್ಮನೆ ಅದಕ್ಕೆ ಆರ್ಡರ್ ಬೇಡ.
Yes.
1, MM Swami,
This matter, my lord, the orders, my lord, page number 6, Roman number 3, my lord. The respondent is restrained from the causing any change in the mutation entries standing in the name of the petitioner, my lord. Because, my lord, the name is standing in the name of the vendor, my lord. I filed application for mutation entries, my lord. It is not carried out, my lord. So I am seeking direction to mutate my entries, my lord. That is only. Everything is correct, irrespective.
ನಿಮ್ಮ ಹೆಸರು ಇಲ್ವಾ ಅಲ್ಲಿ?
ಇಲ್ಲ. They are not carried out. I filed application for that before Tahsildar, my lord.
Lord Counsel, the matter has been moved for being spoken to. Lord Counsel for the petitioner submits that there is error in para 3, para Roman 3 of the operative portion of the order. Having heard the learned counsel for the petitioner, it is clear that there is an error in that view of the matter. Roman para 3 is directed to be substituted with the following. Respond number 2 is directed to effect the mutation in the name of the petitioner in terms of the application filed by the petitioner within a period of 30 days from the date of receipt of a copy of this order.
Yes. Please, my lord.
2, HM Darigon,
One of the member filed an application for impleading. File objection, but after disposal the writ petition.
When you on the ground, you also.
7 days notice, ಏನಿದು?
My lord, for that, the lordship has cost annexure A. But the date which has been mentioned in annexure A at page 11.
ಎಲ್ಲಿದೆ 12 to
15 to 25.
Yes, my lord. Here, my lord, at the, in the operative portion of that notice, my lord, may I read?
Yes.
ಯರಗಟ್ಟಿ ತಾಲೂಕಿನ ಮದ್ಲೂರು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷ ಸ್ಥಾನಕ್ಕೆ ಮಂಡಿಸಲಾದ ಅವಿಶ್ವಾಸ ಗೊತ್ತುವಳಿ ಅಂಗೀಕೃತವಾಗಿ ತೆರೆದ ವಾದ ಸ್ಥಾನಕ್ಕೆ ಚುನಾವಣೆ ಜರುಗಿಸುವ ಕುರಿತು ಈ ಕಚೇರಿಯಿಂದ ದಿನಾಂಕ 21/2/25ರಂದು ಸಭೆ ನಿಗದಿಪಡಿಸಿ ದಿನಾಂಕ 12/2/25ರಂದು ತಿಳುವಳಿಕೆ ಪತ್ರ ಜಾರಿ ಮಾಡಿದ್ದು. The holding of election that was date fixed on 12/2/2025. ಸದರಿ ತಿಳುವಳಿಕೆ ಪತ್ರದಲ್ಲಿ ಜಾರಿ ಮಾಡಿದ ದಿನಾಂಕವನ್ನು 12/2/25ರ ಬದಲಾಗಿ 21/2/25 ಅಂತ ತಪ್ಪಾಗಿ ನಮೂದಿಸಿದ್ದು. ಸದರಿ ದಿನಾಂಕವನ್ನು ಈ ತಿದ್ದುಪಡಿ ಪ್ರತಿನಿಧಿಕ 21/2/25ರ ಬದಲಾಗಿ 12/2ರಂತೆ ತಿದ್ದಿ ಓದಿಕೊಳ್ಳುವುದು. ಸೊ ದಿಸ್ ಇಸ್ ಆನ್ ಸಭೆಯ ತಿಳುವಳಿಕೆ ಪತ್ರದ ತಿದ್ದುಪಡಿ ಪತ್ರ. It is not the original ಸಭೆ notice. ಸಭೆ notice was fixed on 12/2 by fixing the date to hold elections on 21/2. And the same was served to the petitioners on the that is on 12 itself.
Then you'll have to review.
This was not brought to the notice of this one. The honorable court was.
CCMS will work all emergency.
Out.
So file a review.
Already I filed an impleading application because I am the aggrieved person. Because of this order, the election has been cancelled, Your Worship. Now they cannot hold the election also.
So anyway, hold a fresh election.
Yes, Your Worship, but date has to be fixed. But such a type of Your Worship that the petitioner.
In this writ petition also not given
petitioner, by making a Your Worship as if it's a corrigendum has been mentioned as the election notice. In the pleading salvo, it has been mentioned as the election notice. Never acts as a corrigendum.
There is no provision under the the act the given corrigendum and notice issued on 12/2/2000. How can you issue 15/2/2025 after 3 days? Notice also not at all properly communicated to the members. The for a moment kindly see produce photographs. Not taken any signature of the members in the register.
ದಿನಾಂಕ 12/2/2025ರಂದು ತಿಳುವಳಿಕೆ ಪತ್ರ ಜಾರಿ ಮಾಡಿದ್ದು ಇರುತ್ತದೆ. ಆ ತಿಳುವಳಿಕೆ ಪತ್ರದಲ್ಲಿ ಯಾವ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದು?
21/2.
ಮತ್ತೆ ಯಾಕೆ ತಿದ್ದುಪಡಿ ಏನಕ್ಕೆ ಬಂತು? ಸದರ ತಿಳುವಳಿಕೆ
ಮೇಲ್ಗಡೆ 15
mistake 21/2 ನೇ
ಬರೆದಿದ್ರು. The notice which was issued, Sabhe
notice. Yes, just pass on.
The entire next page, the proceedings along with the forms and everything which has been signed on 12/2. ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ 21 ಅಂತ ಇರೋದನ್ನ that has been rectified by this annexure A. Next page ನಲ್ಲಿ at the bottom 12/2.
When was it served?
My lord, it was served on
12/2 itself.
12/2 itself. I have the photographs of for having served to all the.
Anyway, now 21/2 is over.
Allala agide.
But such type
20th the lordships was pleased to allow the petition by quashing. So election did not. This was not brought to the notice. So yes, on 21st, my lord, we have moved this application for being spoken to by the impleading applicant.
So ಇದು CCMS ಅಲ್ಲಿ ಬರ್ಲಿಲ್ವಾ ನಿಮಗೆ?
ಇಲ್ಲ 2:30 ಗಂತೆ ಮೂವ್ ಮಾಡಿದ್ರು ಅವರು. 2:30 end of the list. It was listed at the end of the list.
So this honorable court liberty to the issue the
Allah, that cannot be.
Always that liberty will be there, but such type of the petitioner.
No.
By making
you do this?
Submission before the court that as if it is
received this.
And
this for a moment kindly see received by the mother, not a member. The mother and also mode of
member of the family ಕೊಡಬಹುದು ಅದೆಲ್ಲ ಆಯ್ತು. ನೀವು ಯಾಕೆ ಸಪ್ರೆಸ್ ಮಾಡಿದ್ರಿ? That it has been received.
Communicated 15 to how can you issue 15/2/2025?
Mr. Dharwad, then what we'll be doing is we'll issue notice, ask them to get all the papers, then we'll consider your petition. 2:30 bad in mele. We believe the counsel who is making a submission.
Man, that impression
So your client is misleading you and you are misleading us.
15/2/2025 notice and that impression. At that impression move the matter
But ella 2:30 nimminda cancel.
Sorry 15/2
memo, we won't take any memo. Let it go, let him get instructions and then we'll consider.
Sorry
Being extended
the
by
subsequent
the court should not be misused.
There are 3 notice issued by the the
Learned counsel for the learned AGA has moved the matter for being spoken to.
I have moved by impleading applicant.
Impleading applicant.
impleading application.
It was not put up.
Moved the matter for being spoken to. He submits that the petitioner has deliberately misled this court by suppressing the notice which had already been issued and treating the corrigendum and contending that the corrigendum which had been issued is the notice, resulting in this court passing orders in favor of the petitioner and further resulting in the election not being held on the date which was so fixed. A memo along with the original notice is also filed.
Please, along with the register also for having served, maintained.
The inspection, the original register
Yes,
has also been made available for inspection,
please.
which clearly and categorically establishes that a notice had been earlier issued on 12/2/2025, fixing the date of the meeting as 21/2/2025. The said notice having been served on the petitioner on 12/2/2025, on the mother of the petitioner on 12/2/2025 itself. Therefore, there was a clear 7-day notice which had been issued by the authorities concerned. This aspect has been completely suppressed by the petitioner in criminal proceedings, 340 has been completely suppressed by the petitioner, resulting in the petitioner misleading this court. Hence, the additional registrar judicial is directed to initiate necessary proceedings. 340 ಇವಾಗ ಯಾವುದು section?
CRPC, now the new section.
New section is
379.
4 petitioners are there.
again all the
Yes,
petitioners.
sir. Corresponding.
379.
Initiate necessary proceeding against the petitioner in terms of section 340 of the earlier Code of Criminal Procedure 1973 and now 379 of the Bharatiya Nagrik Suraksha Sanhita 2023. The said proceedings to be initiated within 10 days from today.
Date of the election, your Lordship, because nowadays unnecessary.
Needless to say,
Yes,
the
sir.
assistant commissioner, ಇವಾಗ ಯಾರು?
Hello, CEO of the taluk.
CEO of the Gram Panchayat can fix, would be free to fix the meeting for holding of the election in terms of the applicable law.
Please.
ಈ ಆರ್ಡರ್ ಏನು ಮಾಡಕ್ಕಾಗಲ್ವಲ್ಲ, ರೀಕಾಲ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ರೀಕಾಲ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. This order shall be read along with the earlier order dated 20th February 2025.
Please. But along with the memo, I'll produce the document.
Yes.
Three, Sriharsh, will open.
Yes, Mr. Patil, what did you decide?
My Lord, may I pass on a document? This document, if your lordship is pleased to see,
Yes.
clearly goes to show their collusion. This petition is filed by defendant number 3 in the suit, against whom the suit is filed regarding purchasing the property of the trust. And he files the suit before the 3 and 7 application to appoint the present respondents as the trustees. Three and 7 petition, my lord, he files in page number,
Vittal Gopal Rao.
yes, my lord. He is defendant number 3 in the impugned suit. Against him, we have got the serious, all the allegations. And in this petition, my lord, your lordship may please to find that managing committee members which he proposes in his application before the
Simna Ramchandran Naik as the chairman, Prahlad
Sigami as secretary, the present petitioners before this honorable court now.
Itzel Gopal Rao Pagad will be a trustee. Balwant,
So they want to come on as a trustee, which will defeat the very purpose of this suit itself. And that is why the other, though the chairman was named as somebody else in the plaint, they have preferred this petition before this honorable court, claiming that they have become the chairman and the secretary who are colluding with them. And I am there to safeguard the interest of the trust and the trust property. That's all. I am not, if they safeguard, I am supporting them.
yes, but the trust is also a defendant.
Yes. Yes.
He's also a defendant.
He is a defendant, defendant number 3. If your lordship is pleased to
The
produce,
defendants being together, you can't have any problem with.
but
Only if the plaintiffs and the defendants are colluding, you can have a problem.
now,
Litigation is only against co-defendant.
now that this trust defendant number 1, the persons who is trying to claim that they become the chairman and secretary of this trust, who don't want me to participate in the suit, they are in collusion with the person who is against whom the main allegation is there in the suit.
They are co-defendants.
Yes.
So collusion, they may be together. You can't have any issue. The issue will be only if the plaintiffs are colluding
Plaintiffs
with.
are also not coming before this honorable, and plaintiffs have filed objection in the trial court. These people have not filed the objections also. Trial court, considering this, we are safeguarding the interest, they have allowed me to come on record as one of
Yes,
the
but
defendant.
If we allow one devotee to come as an impleading applicant in a suit, illira ella temple.
Allah, we have to safeguard.
Everything, everybody is fighting out personally.
No, we are not personally.
We saw the allegation in another
Public,
matter which
public trust, and we are to safeguard the interest of the public also.
Yes, but as a devotee, there can be thousands of devotees, Mr.
Because we are the persons who are notified. He has purchased this property. This defendant number, the allegation is defendant number 3 being when he was a trustee.
On the basis of one person, we cannot change the law.
No, my lord.
All will have to be what will be applicable to
Yes,
all. As a devotee, you cannot come. If you want to file a separate proceedings, you are entitled to file a separate proceedings.
Even the
You can file for a scheme suit under 92. You can do all those things.
that is separate, my lord. In this case, even the suit filed is by 2 of the devotees only. Your lordship may please to see.
Suit is filed by devotee. Na?
Devotees only.
By trustees, alwa.
Allah.
Then why do you come as respondent? You should come as plaintiff.
Para 3 of the plaintiff has been the devotee of the said DT since the time of his ancestors and is also belonging to the so and so.
Is a member of the family of respondent number 3 to 6. He is a devotee and a member of respondent number 3 to 6. Family members have.
So hereditary trust.
The allegation was that the family has deceived the trust. And because he is a family member and his prestige is affected, he has come. Not as a devotee, but as because his family name is spoiled.
And he is also.
He has not come for the temple.
Allah, only my submission is that, my lord, if I come there as a defendant, what harm is going to cause to the defendant 1 and 2?
Is it a
who are
the principle of law?
No, we will support them.
We have rejected these kind of applications. So many matters, you know it.
No, there are.
Devotee ಬರ್ಬೇಕು ಅಂದ್ರೆ 100 ಜನ devotee ಬರ್ತಾರೆ ಆಮೇಲೆ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
My lord, it is a public trust. And
yes, so your remedy is under 92. Please find
92
that.
is regarding this, my lord. As far as the suit is concerned, remedy will not be 92. Civil court only will have the jurisdiction.
What kind of a decree can be passed in this? These plaintiffs are not even the owners of the property.
Yes. No.
It's only their family name has got spoiled and bandirado. It's not even on behalf of the temple or the trust.
That's why, my lord.
They are not even trustee. So what will you do there?
No. That's why they should not collude each other and take away the suit and defeat the interest of the very trust itself. I will be there as one of the watchdogs there.
You can't be like that. Everybody will want to be a watchdog. That cannot be.
Because if they do, otherwise, if they collude and compromise the suit.
What right do they have to compromise? He has come that his family name is spoiled.
And no, my lord, the main purpose is the property which is purchased by one of the trustee defendant number 3. He being the trustee, he himself has purchased the property of the trust.
Yes.
That your lordship may see the plaint prayer B. Prayer is.
Plaintiff heard the rumors that the prestigious family of the plaintiff has deceived the trust and the committee at large and now shamelessly participate in Vittal Devasthan activities. The plaintiff, being annoyed of such rumors, inquired into the matter with other devotees by name so and so. The plaintiff came to know that an illegal sale deed was executed in the name of defendant number 4. He also came to know that prior to sale deed permission so and so. He is annoyed by the allegations.
Allegation, not allegation.
They also don't have any right.
No, if your lordship is pleased to peruse para 7. Page 23. In fact, the suit property was leased to one primary school, etc. The school authority was paying rental to the Devasthan. The defendant number 3 to 6 are the persons in occupation of their own property bearing so and so, which is adjoining the property. Father of defendant number 3 to 6 being one of the known devotees, entrusted care and custody. As such, the suit property was used as store of Vittal Devasthan. Apart from this, the family members of the defendant number 3 on his family members were using the suit property for their convenience. Further submitted that not residing, etc. my lord. And then para 9. That defendant number 3 was trustee of the Devasthan, managed to sell the property in favor of defendant number 4 for his own benefits. Further, all these illegal and unethical activities led to the dissatisfaction among the devotees of Devasthan, and lot of rumors spread over since 6 months. As such, defendant number 3 to 6, with an intention to assert their right title, entered partial partition among themselves, wherein they got divided the property. That the defendant number 3 was trustee in the year 94, and at present also he is a trustee, Defendant number one is one of the trustees in the year 1994, and now he is the chairman. The plaintiff came to know the facts, etc. My lord, plaintiff constrained to issue legal notice, and then prayer may please be seen.
10 is more important. The cause, the reason is that.
Yes, this fact was affected badly, reputation of family earned by the family immemorial. Plaintiff was constrained to issue legal notice, who did not respond satisfactorily, gave an evasive reply. Therefore, petitioner is constrained to file the present suit before this honorable court. The prayer may please be seen. Prayer is that property is to be reverted back to the trust.
So if you want to challenge the sale deed, you can challenge it independently. You are coming as a respondent.
No, already there is one suit challenging that.
You are coming as a respondent, Mr. Patel. Defendant, sorry.
Yes, my lord.
What will you as a defendant do?
No, the defendant also, we can say, if
You don't come as plaintiff.
my interest is let them not collude themselves, having filed a suit also.
If you are the plaintiff, at least we understand.
If that liberty is given to me to get myself impleaded as a plaintiff, I will be.
But not as a defendant. What will
Yes,
you do?
I may be permitted to implead myself as a plaintiff, my lord. I will
represent it.
Yes, or I may be, I will file application for transposing.
Lord, there is way back in the year 84 itself, it is stated that the devotee in any manner can join as a Lord party to the suit between the committees.
If the trust is doing activities contrary, then yes, they can always police them. But defendant is so point and the he wants to file best is 90. That is your call, not for us to
Lord,
advise.
sir, even he can seek some interim reliefs in section 92 also.
No, 92.
It is for you to advise your respective client
Your
and
lordships.
advise you on what to do.
Allah,
We can only say it is wrong.
92, your lordship also held that such injunction of these suits will not be maintainable. 92 ದಲ್ಲಿ only those A to ಇದೆ ಅಂತ ಬರ್ತದೆ, those only suits.
Relating to trust, ಇದು ಬರತ್ ಅಲ್ಲಿ ಬೇರೆ ಅದ. It was against third party, which you had argued before us was recovery of possession against a tenant. I think ನೀವು ಮಾಡಿದ್ದು. Inna one which you relied upon was where recovery of money.
ಅದಕ್ಕೆ
It was
92.
different.
But here I may be permitted to come as a plaintiff. I am satisfied.
How can we without
I will get myself transposed. Now my application is allowed. I can file application and get myself transposed as a plaintiff also. On all probability,
Plaint itself is filed by two devotees.
They are the family members. Subsequently say that there is a partition.
But they are seeking to protect the interest of the trust and the deity, because their family name is got spoiled because of your client's activities and our allegation.
He'll become a totally stranger, my lord.
It is not a private trust. The Bombay Public Trust registration agide. Charity Commissioner the permission ತಗೊಂಡಿದ್ದೀರಾ?
Relief sought, my lord, is, your lordship may kindly see, the relief is with a declare sale deed so and so. Decree for possession may
the
also
trust.
be passed directing defendant number 3 to hand over possession of suit property trust. Consequential relief of injunction may also be passed against defendant number 3 to 6 and in favor of the plaintiff restraining the said defendants or anybody acting on their behalf from disturbing the possession and enjoyment of suit property by defendant committee of Kittu.
Trust. Defendant number 1 is trust.
Yes, my lord. Lord, his application is based on any interest. His application is based on only apprehension, my lord. He is seeking.
Even the plaintiffs are there for that reason only.
And he will not even incidentally be affected by virtue of this.
You have not made a statement that you will not compromise. We asked you so many times. You have not come forward to say you are not compromising.
And I submitted, my lord. Even last occasion I submit that we are not going to enter into compromise.
You are not colluded with them.
No, my lord.
They are not colluding.
No, my lord. The plaintiff have seriously opposed the application.
What about prosecuting the suit?
Please, my lord.
What about prosecuting the suit?
and they are not appear in this writ petition. They remained absent here.
Only for the purpose that they remained absent, he cannot be impleaded in the suit. my lord, your lordship, the consequences would be 100 of applications will be filed either by the plaintiff side or by the defendant side. So it will entirely ruin the nature of the suit itself, my lord. Yes, my lord.
Order one rule.
Because, my lord, the very nature of the proceedings will be changed, my lord.
No, that is.
Minimum 100 applications will be filed after the, my lord, this order, my lord.
No, when public trust and public property is there, my lord, actually even the plaintiff should have filed a representative suit. Order one rule late, they should have called for others to come.
Nothing prevents you from filing that.
No, my lord.
But your coming on record is the problem.
No, they should have issued notice and called us. And instead of that, I myself is persuading myself to come on record
Not
to
as a
safeguard the
plaintiff,
interest
but-
of the.
Mr.
Allah, at least I may.
Reserve your rights to initiate such proceedings as may be available under law, not like this as a
Allah, if
devotee.
my rights as to get myself impleaded as a plaintiff may please be.
You file separate proceedings.
Allah, separate.
It's not a representative suit.
Separate proceedings adre, one suit is already pending.
ಯಾವ
Mattond
suit?
This suit is for the
Club
same
ಆಗತ್ತೆ.
relief, there cannot be number of suits.
Club ಆಗತ್ತೆ ಅಷ್ಟೇ.
Allah, but it's
But not
already.
To come as a
20,
devotee
21 suit.
will open a Pandora's box. It will create lot of trouble.
The order one rule 10 doesn't debar me from coming out there. Your lordship may please to see.
Yes.
If order one rule, rule subclause 2, the court may at any stage of the proceedings either upon or without the application of either party and on such terms as may appear to the court to be just, order that the name of any party improperly joined, whether they as plaintiff or defendant, be struck out, and that the name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved in the suit be added. And 4, my lord, where defendant is added, the plaintiff shall, unless the court otherwise directs, be amended in such manner. So now the court has come to the conclusion, the trial court has come to the conclusion that I am there to aid that. And that order, there cannot be, they find fault with the order passed by the trial court. Page 17, my lord.
This cannot be, Mr. Patel.
No, my lord, it is specifically said, if the proposed defendant is joined,
We'll reserve your right to file such proceedings as you want. You do it in your name. Not as a devotee coming in any suit. That will open a Pandora's box.
Because there are, to that trust, there is no members. It is a public trust. Intar member antu illa sir alli.
ಅದು ಹೇಳಿ ಆಯ್ತು ಅದು ಎಷ್ಟೋ ಸತಿ ನೋಡಿ. Petitioner is before this court seeking for the following reliefs. Respond number 1 and 2 herein.
That is also my objection. Adu ondide sir. Respond number 1 and 2 are not the chairman and defendants are chairman and secretary.
ಇಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 and 2 had filed the suit. ಅದರಲ್ಲಿ ಏನು objection ಇದೆ?
ಅದಿದೆ ಅಲ್ಲ ಏನ್ the present writ petitioners who are
we'll take note of that. We are now on respond 1 and 2. Respond number 1 and 2 had filed a suit in OS number 28 of 2021 seeking for the following reliefs. Page 25 and 26. In the said suit, alleging that there's collusion between the plaintiffs and the defendants, the petitioner filed an application under Order 1, Rule 10(2) of the Code of Civil Procedure to come on record, petitioner, respond number 7, filed an
Defendant-
application under Order 1, Rule 10(2) of the Code of Civil Procedure to come on record as a party defendant in the said suit. In the said application, it was alleged that the plaintiffs and the defendants were colluding with each other. The written statement which had been filed was tailored to suit the requirements and support defendant number 3 and 4 therein, who had allegedly misappropriated monies and usurped the properties of the trust, and had in fact gone on to have a partition of the property of the trust. It is in that background that respondent number 7 herein contended that there is a possibility of the plaintiffs entering into a compromise with the respondents, and or that the plaintiff would withdraw the suit. Thus, the entire reliefs which have been sought for, which was in the interest of the trust stroke temple, would be rendered nugatory. The said application came to be opposed by the plaintiffs, contending that defendant number 7 does not have any independent right over the property, over the trust. The plaintiffs being family members of the trustees were trying to protect the interest of the trust. They denied, denial illa. They contended that merely on account of respondent number 7 being a devotee would not be ground for allowing the application to be impleaded. The trial court, while the impugned order dated 18/12/2023, allowed the application and permitted respondent number 7 to come on record as defendant number 7 on the ground that respondent number 7 was trying to protect the property of the trust. If respondent number 7 is joined in the suit cannot be bad for impleading the party. And further went on to hold that the devotees have a right to protect the interest of the religious entity. It is challenging said order that the petitioner is before this court. Shri S. Nilapant, learned counsel for the petitioner, would submit that respondent number 7 is a third party. The dispute is between the family members of the trustees, and is in that background that the suit had been filed. The petitioner herein is the trust by itself, represented by its current president and secretary. The trust will, the reliefs which have been sought for in the suit are for the benefit of the trust. If the plaintiffs succeed in the suit, it is the trust who will be benefited by the said order. The trust is not in any manner entering into any compromise with either the petitioners, plaintiffs, or the other defendants. The trust is making all efforts to secure the property belonging to the trust. And the stand of the trust is that the property belongs to the trust exclusively and not to either the plaintiffs or the other defendants.
Please.
And as such, the trust would protect the interest of the trust by itself. And there's no requirement for respondent number 7 to support the trust. Lastly, he submits that if a devotee were to be permitted to be impleaded in any suit, there being large number of litigation before the courts as regards various temples, mutts, and institutions, there would be a floodgate of applications filed by devotees who would seek to come on record, then those aspects could not be adjudicated. The petitioner trust being bestowed with the obligation and duty to protect the interest of the trust, the petitioners would be so doing. And the petitioner trust is also seeking to get the property for the use and benefit of the trust and the devotees. Shri K.L. Patil, learned counsel for respondent number 7, would submit that there's a collusion between the plaintiffs and the defendants, inasmuch as now, when the suit was filed, the trust was represented by its chairman Shri Krishna Tamoji Kotbagi, and now the trust is represented by its president,
Claims to be the president.
Narsimha Ramchandra Nayak, and secretary Prahlad Narsimha Shigavi, who are also the trustees along with Vittal Gopal Rao Pagad,
Who are claiming as a trustee, they filed their
who
application.
also claims to be trustee along with Vittal Gopal Rao Pagad, as regards which miscellaneous number 242 of 23 had been filed under section 3 and 7 of the Charitable and Religious Trust Act 1920. There's the fact that the chairman and secretary of the trust before this court and defendant number 3, against whom all the allegations have been made, is also a trustee. In a petition filed by defendant number 3 in miscellaneous number 242 of 2023, contending that the president and chairman and secretary have been appointed in terms of resolution passed, would indicate clear collusion between the chairman and secretary before this court and defendant number 3, against whom all the allegations have been made in OS number 28 of 2021. And it is for that reason that respondent number 7 seeks to come on record to guard the properties of the trust so that there's no collusion between the parties to usurp the property of the trust. He submits that an exception would be required to be made in the present case, taking into consideration the collusion between the parties on record, namely the trustees. And if respondent number 7 is not brought on record, grave loss, harm, and injury would be caused to the properties of the trust and the affairs of the trust. Respondent number 1 and 2, who are the plaintiffs before the trial court, those served are chosen to be unrepresented. Respondent number 3 to 6, who are defendant number 3 to 6 before the trial court, are represented by a counsel. Where is Mr. Matpati? Aurenant.
Matpati.
ಪ್ರಶಾಂತ್ ಮೊನ್ನೆ ಹೇಳಿದ್ರು they are supporting you ಅಂತ. You want to still say that. Supports the case of the petitioners and submits that the impleading, the order of impleading is bad in law and this court is required to intercede. Heard Shri Harsh A. Nilopan, learned counsel for the petitioner, Shri K.L. Patil, learned counsel for Respond number 7, Shri Prashant Matpati for respond number 3 to 6, peruse papers.
One more submission that the present petitioners are not the authorized persons to file this return.
Ali, Shri K.L. Patil. The last submission of Shri K.L. Patil is that the devotees do not recognize the persons who are represented as president and secretary of the trust to be the president and secretary of the trust. They have been set up by defendant number 3, and as such the devotees have no confidence in the so-called president and secretary.
They claim that the president which is made in the suit, he has resigned and there is no such resignation.
That we can.
They mentioned in
the
that
meeting
in the writ
minutes.
petition, they claim that.
The suit as filed was by 2 devotees and family members of the trustees, contending that on account of the action of defendant number 3 therein, in selling the property, in purchasing the property in the name of defendant number 4, using the funds of the trust, the reputation of the family has adversely suffered. It is further contended that the interest of the trust has suffered on account of the actions of defendant number 3. And in that background, the sale deed executed in favor of defendant number 4 is sought to be set aside and the possessions ought to be recovered in the name of the trust for the trust to administer the property and for injunction restraining defendant number 3 and his other trustees from interfering with the possession of the trust. Respond number 7 also claims to be a devotee but not a family member of the trustees, who is now alleging that the family members who are the trustees are seeking to collude with each other and enter into a compromise to the detriment of the trust. And it is in that background that Shri K.L. Patil has submitted that defendant number 7 wants to come on record as a guard dog to guard the properties of the trust.
Even order 1 rule 8 also permits me.
His submission is
Order
that
1 rule 8 is specifically, so other ones are where one person may sue or defend on behalf of this, all are in same interest. Order 1 rule 8, where there are numerous persons having the same interest in one suit. Your lordship's got it. Where there are numerous persons having the same interest in one suit, one or more of such persons may, with the permission of the court, sue or be sued.
You even file Mandila 1 rule 8.
That representative suit.
You have not filed an application 1 rule 8. That's why we told you have other options. We can't say what.
But even to number of persons, if they are devotees.
Now that you have pointed out, we can say this is one of the options. On principle, allowing one devotee to come will create havoc.
That is what even rule 8
You
provides.
file a separate suit. That you can do. You are not defending the suit. You want the suit to be allowed. Please understand the basic.
As a defendant also, I can support the cause of the plaintiff.
Collusion. That cannot be. Party who has to come on record has to come in the right rank, not otherwise. You may be right on merits, but the procedure followed is completely wrong. Come on record as defendant number 7 as a guard dog to guard the properties of the trust. In my considered opinion, coming on record as a defendant does not serve any purpose. Since even according to the defendant number 7, the submission is that the property belongs to the trust and the relief sought for by the plaintiff is proper and correct. And those reliefs are required to be granted. A person coming on record as defendant cannot, seeking to come on record as a defendant by way of an impleading application, cannot contend after coming on record that the suit has to be allowed by having chosen to come on record as a defendant. the rights that are sought to be agitated by the impleading applicant are to be agitated on his own or in representative capacity in proceedings which may be provided for, which are provided for. Defendant number 7 cannot seek to come on record. A third person cannot seek to come on record as a defendant to contend that the plaint has to be decreed. Furthermore, as rightly contended by Sri Shriyarsh Nilopant, in a dispute between trustees, a devotee cannot come on record, which in my considered opinion would have to be accepted, since if devotees were permitted to come on record in any suit, it would open floodgates, inasmuch as there could be thousands of devotees who would only seek to come on record to frustrate the proceedings and or protract the proceedings, thus taking away the crux of the matter requiring to be decided by a court of law. If at all there are any independent rights which are required to be agitated by a devotee, there are suitable avenues available for such devotee to agitate those rights. And the considered opinion that this court is not expressing any opinion on the correctness of the suit or the correctness of the claim of the impleading applicant. The manner in which the impleading applicant has sought to come on record as a defendant to support the claim of the plaintiff cannot be sustained. In that view of the matter, I pass the following order. Writ petition is allowed. A certiorari is issued. The impugned order dated 18/12/23 in OS number 28 of 21, passed by so-and-so on IA number 8, allowing the said IA number 8 is set aside. Consequently, IA number 8 filed an order 1 Rule 10(2) of the Code of Civil Procedure is dismissed. Liberty is reserved to respondent number 7 to agitate any rights that respondent number 7 has in appropriate forum under appropriate law provided. This court has not expressed any opinion on the merits of the matter and or the contentions.
He is at liberty to challenge that same liberty to file suit to
All
challenge.
liberty is reserved to agitate such rights as provided. Restricted ಮಾಡ್ತಾ ಇಲ್ಲ.
Because there is one sentence your lordship mentioned in the order. If such things are allowed, it goes a long way.
To come on record in an existing suit between trustees.
But independently they can clarify.
Independent. Such independent proceedings as a permit. Independent and that.
Four, Nayan Kumar.
Petitioner has made a representation to the Dharwad commissioner. In the representation, she is seeking to purchase the land abutting to her house. It's an open space owned by the corporation, bearing.
AG accepts notice
For R1.
for respondent number 1, Sri Gurudev Gachinmat is directed to accept notice for respondent number 2. Counsel for the petition served to.
My lord, they have served a copy of the
Next
objection.
is on the said counsel, released on 6th March.
Five, Sunita P. Kalsur.
Your lordships, during the course of the day, I'll comply. I have the typed copies, your lordships.
Sirja work ಆಗ್ತಾ ಇದೆಯಾ ಇಲ್ವಾ? ಆಗ್ತಾ ಇದೆಯಾ? Yes, madam.
Your lordships, Annexure B and Annexure E series, I'm having a typed copies. During the course of the day, I shall comply, your lordships. From ಇಲ್ಲ Saturday ಇಂದ I'm going, but the matter.
ಇಲ್ಲಿ ಏನು objection ತೋರಿಸಿಲ್ಲ.
The IA is being dismissed for production of legible copies, your lordships. I have the copies with me.
On the last occasion, senior counsel appeared and other
Not
matters.
this-
ಇಲ್ಲ
not this
ಇದಲ್ಲ.
matter.
ಅದು ಬೇರೆ, ಅದು ಡಾಕ್ಯುಮೆಂಟೇ ಸಬ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರು, ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ಇದು ಮಾಡಿದ್ರು. ಯಾವ್ದೋ document quashing ಕೇಳ್ಬಿಟ್ಟು you have substituted quashing document.
ಇಲ್ಲ ಕ್ವಾಶಿಂಗ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲ ಸ್ವಾಮಿ.
Madam, you have done that. That's why we were harsh on you. Otherwise, we would not have been. Why would we be? Counsel for the petitioner seeks for and is granted.
Your lordships, today I'll comply, your lordship. The file will not
ಏನ್
come in.
ಮಾಡ್ಬೇಕು ಇವಾಗ?
Kindly pass over, I'll comply the office.
Pass over ಅಂತ ಹೇಳಿ ಮತ್ತೆ.
Please.
8 Srinivas C.
Am I audible to the court? I appear for the petitioner in this case. I appear for the petitioner in this case, my lord.
To hear us.
Am I audible, my lord?
ಏನಪ್ಪ ಇಲ್ಲ ಅವ್ರು ಕೇಳಿಸ್ತಾರೆ, ನಮ್ಮ ವಾಯ್ಸ್ ಅಲ್ಲಿ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಅವ್ರಿಗೆ. They are not responding.
Some voice ಇವಾಗ ಕೇಳ್ತಾ ಇದೆ.
ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? Yes. ನಿಮ್ಮ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇತ್ತು ಮುಂಚೆನು.
ಹೌದಾ? ಯಾಕೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿತ್ತು.
Yes, please.
ಅದಕ್ಕೆ now, my lord, the petitioner before your lordship had filed a suit for partition. Lord, the respondent sole defendant was the father of the first petitioner and husband of the second petitioner. Lord, during the pendency, an application was filed, Lord, by defendants 2 to 5 under Order 1, Rule 10. In the meantime, my lord, I filed a writ petition on the challenging, my lord, certain issues not having been framed properly in the suit. In the said writ petition, they filed one more application under Order 1, Rule 10, my lord. And this honorable court, kindly see page 63, my lord.
63.
Yes, my lord.
Yes.
This honorable court, my lord, after taking into consideration the rival contentions, my lords were pleased to pass an order in para 6, my lord. May I read that para, my lord?
Yes, please.
Hence, the interim order of stay granted by this court is modified. The trial court is directed to conduct the proceedings in OS to the extent of holding an inquiry under Order 22, Rule 5 in respect of the application filed under Order 22, Rule 4 and give the finding thereon within 6 months.
Yes.
No such application under 22(4) was filed. It was only Rule 10, my lord, one Rule 10. But misrepresentation was made before your lordship saying 22(4) was being filed. And that is the reason why my lords were pleased to direct the trial court to hold an inquiry.
There is one Rule 10 application filed.
ಹೌದು 22(4) ಹಾಕ್ಲೇ ಇಲ್ಲ ಅವರು.
ಇದು
ಅದಾದ್ಮೇಲೆ
ಮೂರನೇ ರಿಟ್ ಪಿಟಿಷನ್ how many times is this coming to the high court?
Yes. ಹೌದು, because on 2 occasions, my lord, there is a misrepresentation. Now, my lord, after 3 years, they filed proper applications under 22(4), 22(9) and Section 5 of the Limitation Act. Again, making a false statement in the affidavit, saying recently I came to know that 22(4) is not filed. Though, my lord, on earlier occasions, 3 years ago, my lords were pleased to pass an order directing to hold an inquiry. They kept quiet. No such application was filed. And now they file an application, my lord, under 22(4). The trial court initially rejected such application. Again, it was remanded back to comply with the earlier order. Now, my lord, the present order, which your lordship will kindly see at page 161.
So this had been, what had happened, this application had been allowed, is it?
Allowed.
First time it was rejected. Then again, the direction was issued to consider, and now it is allowed.
Where is the order passed by this court?
Annexure L, 150.
May I request your lordship to see ತಾವು ಹಿಂದೆ ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ 22(4) ಪ್ರಕಾರ ಮಾಡ್ಲೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ರಿಮಾಂಡ್ ಮಾಡಿದ್ದನ್ನು ತಿರ್ಗಾ ರೀಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಬರ್ದಿದ್ದೀರಾ. At 159 is my lord's order. Now, my lord, I would request my lords to see page 129, my lord. This is an order made on IAS 36 to 38. At 129, if your lordship would see, at 128, Annexure K2.
Yes.
Is an application under Section 5 of the Limitation Act. Along with this, 22(4) and 22(9) were filed. In that affidavit, if your lordship would kindly go to page 130, para 6, my lord. This IA is filed on 31/10. Kindly note this date, my lord.
Yes.
31/10/2023. The first order your lordships made was in October 2021.
Yes.
After 2 years, at para 6, your lordship will see the reason given for condonation of delay. I further submit. May I read that para 6, my lord?
Yes, please.
I further submit that in the last week of September, I met my advocate in his office, and on perusing the papers of the court preceding of the above case, I came to know no application under 22(4) of CPC is filed on our behalf in the above case, and the order passed earlier in IA number 20 is only in respect of necessary parties. Having made a misrepresentation before your lordships on 2 occasions, and with my direction by this court, my lord, to go and hold an inquiry under 22(4), which was never filed. Now they come and say that, my lord, after 3 years, that we are 2 years, that we came to know recently no such application is filed, and they make an application. They are already on record under Order 1, Rule 10, both in my earlier writ petition as well as in the trial court, IA number 20. They are on record representing. Now the present order, my lord, the learned judge goes to the extent of saying they are the legal heirs. Kindly see at page 171, my lord. 2 times misrepresentation is made to the court, and it is made to believe that such applications are filed, which led to this court, my lord, to direct the trial court to hold an inquiry on 22(5). Where are the applications? On both occasions, no such applications were filed. Only now, belatedly, and the trial court says, first time trial court rejected these applications, 36 to 38. Again, your lordships directed them. It is pursuant to that particular order. Now, my lord, at para 19, thus applicants number 2 to 4 are permitted to come on record as legal heirs. Miller, admittedly, they are the, my lord, children, 3 of them and the wife, of a void marriage, because the first wife is still subsisting. She has filed the suit against the husband for purposes of partition of her share. Number 2, my lord, under Hindu Marriage Act, the legitimacy is given to those children to get share only in that of the husband's father's property. Now, being a legal heir, my lord, they even go and say we have a right on ancestral property. The plaint contains, my lord, the ancestral properties. They can't be legal heirs at all. They're already on record on 2 occasions. To sum up my submissions, my lord, they are on record in the trial court on IA 20. They are on record on an application in a writ petition filed by me against certain issues not having been properly framed. They are brought on record. These are the 2 things that they are already on record.
At least now is the inquiry held on 22 Rule 5.
Inquiry is held, my lord. All evidence is totally completed. I have to be cross-examined. Suit is at that stage. Now they come forward.
Inquiry on 22 Rule 5, not on the suit.
No, inquiry on 22(5) was held.
Held. Matilello ಕಾಣಿಸ್ತಾ ಇಲ್ಲ ಇದು order ಅಲ್ಲಿ.
At a time when there is no such application filed. ಇದರಲ್ಲಿ ತಾವು ದಯವಿಟ್ಟು ನೋಡಿದ್ರೆ ಇಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ರೀಸನ್ಸ್ 165 ಅಂತ ಇದೆ ಪೇಜ್. They also
applicants prove that they are legal heirs. They prove their legal heirs ಅಂತ ಹೇಳಿದ್ದಾರೆ. Where is the inquiry?
ಅದೇ ಪ್ಯಾರಾಗ್ರಾಫ್ 12.
12.
ಪ್ಯಾರಾ 11 ಇಂದ ತಾವು ದಯವಿಟ್ಟು ನೋಡಿ at page 167.
Para 11 ಅಲ್ಲಿ ಇದೆ.
Defendants of these IAs have let evidence and also got marked documents as directed. Rajeshwari Nanjangowda examined herself by way of affidavit so and so for inquiry on IA 36 to 38, wherein she contended that she is the defendant number 1, quote, and she is a legal representative and she has deposed that there is a will also left behind by the defendant 1, and they may be permitted to come on record as legal heirs of Nagendrappa. She reiterated contents of the IA 36. She has got marked as many as 48 documents. Among these documents, she got marked copy of the voters list, wedding card, study certificate of so and so, etc. The husband himself says no wedding took place. We were living together. And kindly come to me, Lord, para 13, cross-examination. PW1 admitted that after the death of Nagendrappa, Lalitamma is drawing pension and Ashok is only son of Nagendrappa and Lalitamma. That is the petitioner. To the question that only the name of Lalitamma is entered in the service register, that is the so-called second wife, she explained that even the names of Ashwini, her daughters, my lord, are also mentioned, including Dr. Ashok. As already discussed, Exhibit P44, which is application for purposes of pension, shows that the defendant number 1 has shown Ashok and the daughters and children. It is also admitted by PW1 that there is no other document during the lifetime of Nagendrappa to show that Ratnamma is his wife. It is denied that Lalitamma had not got her marriage dissolved with Nagendrappa. It is submitted PW1 that she has not prayed to delete their names as defendants 2 to 5. It is also admitted by PW1 that they have not filed application to declare them as legal heirs of the deceased Nagendrappa, and application is filed to dismiss the case. PW1 specifically denied that Nagendrappa had only wife Lalitamma and only son Ashok. This evidence is led only for the limited purposes of 36 to 38. Evident from the records, my lord, then at this stage, no doubt the applicants are already on record as defendants 2 to 5. PW1 also has produced copy of the application filed for pension, etc. Then, my lord, paragraph at the last 6-7 lines. For that, a complete adjudication is necessary. At this stage, applicants 2 to 4 established that they are also the children of Nagendrappa, the deceased defendant number 1. There is no prima facie material at this stage to hold that applicant 1's Ratnamma is the wife of the deceased defendant number 1. Thus, there is no reason to dismiss the claim of applicants 2 to 4, IA 36 to 38 allowed. No doubt the stipulated time for bringing legal heirs had already expired, and it is to be noted that since defendant 1 died, LRs have to be permitted to come on record. In this regard, it is beneficial to rely on the judgment of so and so, so and so. Therefore, at every stage, how could they make this honorable court believe that there is an application under 22(4) and to hold an inquiry? The learned judge, just previous to this page, the learned judge had dismissed those 3 applications. Thereafter, once again, when he was asked to pass a fresh order, he allows these applications. There is no consideration as to why there is a delay of nearly 2 years, 22(5).
More importantly, the delay is one thing, the aspect of whether when there are 2 wives, who is the first, who is the second wife, and what is the status?
No, I am the first wife is admitted by my husband himself in his written statement.
Admit agidya?
Houdu, she is my wife and son antare, but he is staying separately with her. The second wife did not marry her, but he has got 3 daughters from the second wife.
That you can make use of. Revana Siddhappa will be there. She won't be entitled for anything. It will be only the children out of the self-acquired property of the deceased husband.
That is out of 1/3 that, my lord, in the trial it will come out.
Yes.
But to pay their legal heirs, my lord, the conduct, as I, my lord, repeat, pardon me, 3 things, my lord, and I will close my case. One is to make believe this court that there are such applications filed, and direction to the trial court to hold an inquiry under 22(5). Obviously on 22(4) and 9, which were never filed. On 2 occasions, my lord, they were brought on record.
That you are right on the manner in which the matter has been conducted, subject to what Mr. Ukeri says. But otherwise, in terms of the application being allowed,
my lord, my respectful submission, sorry for interruption, is that they are already on record on IA number 20 in the trial court as impleaded applicants. They came on record in my writ petition on an earlier occasion. If they are already on record, calling themselves as representing the estate of my husband and my father, they're all redundant proceedings dragging on unnecessarily and misdirecting the court also.
and that is why we will make those observations, subject to what Mr. Kerry argues. Let us hear him.
And the limitation also, a lot of false affidavit is filed. And it is for my lord to appreciate whether such conduct is permissible, and more than anything else to do even substantial justice when the parties are already on record by way of an impleadment, calling themselves as representing the estate. There is the need for all these, my lord, subsequent order, and then, my lord, calling themselves as legal heirs at a belated stage. I'm grateful.
In the application will be disposed of, the court is observers, defendant number 1 who is second, applicant number 2 to 4 are permitted to come on record.
22 rule for application ಹಾಕಿದೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ 2 ಸತಿ.
ಅಲ್ಲ my lord, kindly see.
Finally ಅದು application ಹಾಕಿರೋದು.
Kindly see, my lord, by earlier disposal by writ by this honorable court, my lords. Here, my lordship may.
ಯಾವತ್ತು application ಹಾಕಿದೆ ಹೇಳಿ ನೀವು?
My lord. 23.
31/10/23, my lord.
31/10/23.
Yes, my lord.
So when the matter came up before this court in 21.
Yes.
So many times.
Yes, my lord. But it is.
You did not bring it to notice of this court that you have not filed an application.
No, yes,
in fact, you went on to contend that you filed.
After considering all these aspects, my lords may pass an order on to September 24. Considering my late application is filed before the court, and also, my lords, considering myself and court as well as opponent are commit such mistakes, but not brought notice to the court. By considering all this aspect and call for the records from the court, my lords, after going through the records from the court, my lords will pass in final order on 26 September 2024, and said that the inquiry is to be conducted under order 36 to 30, I number 36 to 38. Accordingly, my lord, the last occasion the court has rightly passed after recording the evidence, my lords, full-fledged trial in respect of only I number 36 to 38. The documents which is, my lords, exhibit P1 to 48, going to show that these are the children of deceased Nagendrappa. By considering this aspect, the court has rightly ordered passing the order, my lords, only children are brought on record, not the wife. Now they are taken contention that, my lords, the court itself is said in its order itself, only 2 to 4 are permitted to come on record as in laws of dependent one A, B, C. Their rank only partly allowed by applications.
But there is no
And
this one,
exclusion
no
of-
finding. Only thing which is missing here and not considered properly is that since they are second wife, they would only be entitled to the share in the.
That is after trial, my lords, court can take.
That will make an
it's only.
observation. That will make an observation. ಕೆಲವು ಮತ್ತೆ ಇದು ರಿಮೈಂಡ್ ಆದ್ರೆ ಮತ್ತೆ ಇನ್ನೊಂದು 6 ತಿಂಗಳು ಮತ್ತೆ ನೀವು ಆಟ ಆಡ್ಕೊಂಡು ಬರ್ತೀರಾ.
ಅಲ್ಲ ನಾನು ಆಟ ಇಲ್ಲ ನಮ್ದೇನು ಆಟ ಇಲ್ಲ. ನಾನು ಸಿನ್ಸ್ ಪರ್ಸಿಸ್ಟಿಂಗ್ 2013
ನೀವೇ ಮಾಡ್ತಾ ಇರೋದು ಇದು. The whole this one is because of you that it's come 3 times.
Yes, madam.
Enquiry ಅಂದ್ರೆ ಆಮೇಲೆ ಅಲ್ಲಿ ಹೋಗಿ ಮೆಮೊ ನೋ ನೀಡ್ ಆಫ್ ಎನ್ಕ್ವೈರಿ. ಆಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿದ್ಮೇಲೆ ಸರಿಯಾಗಿ ಮಾಡಿಲ್ಲ ಅಂತ ಬಂದ್ರಿ. ಮತ್ತೆ ಇನ್ನೊಂದ್ಸತಿ ಎನ್ಕ್ವೈರಿ ಕಳಿದ್ವಿ. ಮತ್ತೆ ಅವಾಗ್ಲೂ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ.
This court has made observation. I number 36
observed
to
everything.
38.
Everything is there in Annex L.
36 to 38. That objection, that
Only not to delay the matter, we had passed the order. You still continue to delay like this, knowing that you won't succeed, and you are in possession of the property. That is the whole purpose.
I am persisting, continuous assisting the court to dispose of matter earlier. Now the court has taken matters.
Your conduct reflects otherwise, Mr. Okeri. Your conduct reflects completely contrary to that. You've been delaying the matter from 21 till now 4 years only on this application.
Now it is cross-examination, dependent on 4 is came to an end.
We will observe it, and though Mr. Rao is right, but accepting his submission will only delay the matter further.
Plus whether the second wife is entitled or not, that is be trial matters that they argue the matter on that aspect.
Petitioner is before this court seeking for the following reliefs. The petitioner is aggrieved. The petitioner is a plaintiff in OS number 15 of 2023 filed for partition in separate possession. IA number 36 was filed under Order 21 Rule 4 by 4 persons to come on record as legal heirs of the deceased defendant, even though they were already on record as defendants claiming to represent the estate of the original defendant number 1 on his expiry. IA number 37 was filed under Order 22 Rule 9 to set aside the order of abatement, and IA 38 was filed under Section 5 of the Limitation Act for condition of delay, if any, without mentioning what delay has been caused. The said applications have been allowed by way of the impugned order dated 26 September 2024. The plaintiffs, the petitioner plaintiffs are before this court. Shri DLN Rao, Learned Senior Counsel, would submit that the respondents have been given to suppressing material facts and suggesting false facts, thereby misleading this court and the trial court on several occasions. Once earlier, when the matter had come up before this court on 25/10/2021, as regard the consideration of an application in Order 1 Rule 10, this court was informed that there was an application actually filed under Order 22 Rule 4. And as said, this court directed an inquiry in terms of Order 22 Rule 5, while order dated 25/10/2021. His submission is that as on that date, there was no application filed under Order 22 Rule 4. There was only an application filed under Order 1 Rule 10. Subsequent thereto, when the matter was taken up before the trial court in pursuance of directions dated 25/10/21, the trial court, while its order dated 23rd May 2022, filed the application and Order 1 Rule 10(2) and permitted them to come on record as defendant number 2 to 5. Before the trial court, the impleading applicants had indicated that there was no need to hold an inquiry since the application under 22 Rule 5, since the application under Order 1 Rule 10 had been filed. This order thereafter came to be challenged before this court. This order was placed on record of this court in WP number 100178 of 2021, wherein the order dated 25/10/21 had been passed. And this court taking into consideration that no inquiry had been held placed on record so and so. Subsequently, the said order came to be challenged in WP number 107253 of 2023. And this court, taking into account that no inquiry had been conducted in terms of Order 22 Rule 5, had directed the trial court to conduct such an inquiry. Thereafter, it is only thereafter that the aforesaid IA number 36 to 38 came to be filed on 31/10/2023. In the meanwhile, the said application came to be rejected, which was challenged before this court in WP number 107253 of 2023. This court, taking note of the fact that the earlier order on 1 Rule 10(2) had not been passed after holding an inquiry and Order 22 Rule 5, and the orders on IA number 36 to 38 had also been passed without holding an inquiry and Order 22 Rule 5, set aside the order of dismissal of IS 36 to 38 and remitted the matter to the trial court for holding the inquiry in terms of Order 22 Rule 5 as for the first time directed on 25/10/2021. It is now after holding the inquiry that the impugned order dated 26 September 2024 has been passed, by virtue of which it is only the children who have been brought on record, the mother has been excluded. The submission of Shri D.L.N. Rao and senior counsel appearing for the petitioner is that even in this order, there is no finding as regards the legitimacy or otherwise of the children. The inquiry contemplated under Order 22 Rule 5 ought to have resulted in a finding by the trial court as regards the said aspect. His submission is that the plaintiff number 1, plaintiff number 2 is the first wife. Plaintiff number 1 is the son of the first wife, and Sri Nagendrappa. The impleading applicants and/or the applicants under Order 22 Rule 5 were the second wife and children through Nagendrappa. Though the trial court has considered the applicants number 2 to 4 to be the children, the legitimacy or otherwise has not been adverted to. And as such, he submits that without such a finding, the suit cannot proceed. Shri M.C. Ukkeri, learned counsel for the respondents, would submit 2 to 4 ashtena.
Yes.
1 again. ಒಂದನೇ ನೋಟಿಸ್ ತಗೊಂಡ್ತೀರಾ ಏನು?
ಇಲ್ಲ, ಡೆತ್ ಆಗಿದ್ದಾರೆ ಅವರು.
ರತ್ನಮ್ಮ ಡೆತ್ ಆಗಿದೆ.
ರತ್ನಮಲ್ಲ, ಇವ್ರು ತೋದಿನ ನೋಟಿಸ್.
Who has appeared for
Yes,
respondent number 2 to 4, children accepts notice for respondent number 1 wife. Respondent number 1 Ratnamma, the mother.
Yes, mother.
He submits that it is on account of the finding that Ratnamma is the second wife that she has not been brought on record. This finding would be sufficient for the court to decide the matter at the final stage by applying the decision of the Honorable Apex Court in Revanasiddhappa versus so and so.
Yes, correct.
2024 SCC. So and so.
23.
His submission
23
is
volume 10,
2023 volume 10,
page 1, my lord.
page 1.
Page 1. Correct.
His submission is that the applicants number 2 to 4 on inquiry have been found to be the children of Ratnamma and Nagendrappa in as much as their names have been entered into in the service records. The name of the father and mother have been entered into in the marriage, in the education records. And it is, and in regard to that aspect, the finding being proper and correct, the determination of the share and entitlement would have to be taken into consideration at the final stage, at the stage of passing the judgment. Heard so and so. Though there is substance in the submission made by Sri DLN Rao and senior counsel as regard the suppression resorted to by the applicants on 2 earlier occasions, in as much as without filing an application in order 22 rule 4, it was contended that there was such an application filed. Subsequently, when a direction was issued for inquiry and order 22 rule 5, the applicants made a submission before the trial court that no inquiry was required since the application was 1 under order 1 rule 10(2). And thereafter the application and order under 22 rule 5 had been filed. I am of the considered opinion that in regard to those aspects, the conduct of the applicants is to be deprecated and suitable action taken. However, the same would not take away the fact that finally, after 4 years, an inquiry has been held under Rule 5 of Order 22 and a finding has been rendered by the trial court. Again, the trial court could have been more explicit in the order passed by clearly and categorically stating the legitimacy or otherwise of the marriage and of the children. But reading of the order would indicate that it is because of Ratnamma being the second wife that she has not been brought on record as a legal representative of deceased Nagendrappa in a suit for partition, since she would not have any right either in the joint family property or the self-acquired property of Nagendrappa. Insofar as children are concerned, just because they are the children out of the second marriage or second relationship, the word illegitimacy is used. In my considered opinion, that there cannot be a illegitimacy of the children. At the most, it could be the illegitimate relationship between the father and mother. Be that as it may, these aspects have been categorically dealt with by the Honorable Apex Court in Revanasiddhappa's case, Supra, and the manner in which the rights of such children are to be considered has been clearly propounded. The finding of the trial court categorically indicates that plaintiff number 2 is the first wife and plaintiff number 1 is the son from and out of the first marriage of Nagendrappa with plaintiff number 2. Insofar as that aspect is concerned, the legitimacy of the marriage and legitimacy of the child has been established by the said order of the trial court. The other, the relationship of Ratnamma and the person now brought on record has also been dealt with. In that view of the matter, I have the considered opinion that the grievance of the petitioner can be addressed by directing the trial court to consider the decision of the Honorable Apex Court in Revanesiddappa's case at the time of final adjudication in terms of the observations made here and above. In that view of the matter, the above petition stands disposed in view of the observations made above.
Please. ಅದು ಇಲ್ಲಿ they may take at the very stage, my lord. I don't.
4 years you have delayed.
Even they have not get amended the cost at.
They are not imposing any cost. ಸುಮ್ನೆ ಜಾಸ್ತಿ ಹೇಳ್ಬೇಡಿ.
ನಾ ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ?
ಹೇಳಿದೀವಿ, that we dealt with, but we have let it go.
7, Santosh Rao.
May I make one submission, my lord?
Yes, Mr. Rao.
May I make one?
Yes, please.
My lord, the finding that they are legal representatives only for the purpose, limited purpose, my lord, they should not misuse this all other aspects.
The finding of the trial court that applicants number 2 to 4 are legal representatives can only be in respect of consideration of their right as regard to self-acquired property of Nagendrappa and not as legal representative per se in respect of the late Nagendrappa.
ಆಯದಲ್ಲೇ ಡಿಸ್ಪೋಸ್ ಎಲ್ಲ ಆಯದಲ್ಲಿ ಎಲ್ಲ ನಮ್ದು ರೈಟ್ಸ್ ಡಿಸೈಡ್ ಆಗೋಗ್ಬಿಟ್ಟು ಅಂದ್ರೆ ಇಟ್ ಹ್ಯಾಸ್ ಮೇಲೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹಸ್ ಗಾಟ್ ಎಂಪಲ್ ಪವರ್ ಟು ಡಿಸೈಡ್ ಆಲ್ ದಿ
ಅಷ್ಟೇ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಬರಬೇಕು.
ನಾನು ಏನ್ ಕೇಳೋದು ಇಲ್ಲೇ ಎಲ್ಲಾನು ರೈಟ್ ಡಿಸೈಡ್ ಆಗ್ಬಿಡ್ತು. ಆಮೇಲೆ ಡೈರೆಕ್ಟ್ ದೆಮ್ ಟು ಅಮೆಂಡ್ ದಿ ಕಾಸ್ಟ್ ಅಟ್ಲ ಇನ್ನೂ ಮಾಡ್ತಲ್ಲ, ಅದಕ್ಕೆ ಮುಂದೆ ಹೋಗ್ತಾ ಇದೆ. 5 ಮುದ್ದತ್ತಾಯ್ತು ಇವಾಗ. ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ ತಂದಿದ್ದೀನಿ, ಅವ್ರು ಕಾಸ್ಟ್ ಅಟ್ಲ ಅಮೆಂಡ್ ಮಾಡಬೇಕಷ್ಟೇ.
Plaintiff to carry out necessary amendment in the cost title within 15 days from today.
Please,
and the trial court to proceed therefrom.
Please.
7, Santosh Raut.
Please, madam. The petitioners are the hereditary orders of
Caveat ಏನಿದು not put up. ಇದಿರಲ್ಲ 243 ನೀವು 24322 ಯಾರು? ಇನ್ನ ಒಂದು ಕೇವೆಟ್ ಇದೆ.
ಶರದ್ ಮಗ್ದು ಮಲೋಡ್ ಐ ಅಪಿಯರ್ ಮಲೋಡ್.
ಅಲ್ಲ ಇಲ್ಲಿ ಅದು ನಿಮ್ದು 24323. ಇನ್ನ ಒಂದು ಸಿಪಿ ನಂಬರ್ 24322 ಇದೆ. ಎರಡು ಇದಾವೆ. ನಾಟ್ ಪುಟ್ ಅಪ್. ನೀವೇ ಹಾಕಿರೋದ ಬೇರೆ ಯಾರು?
ಅದು ನಾವು ಒಂದು ಕೇವಿಟ್ ಹಾಕಿರೋದು. ಒಂದು ಕೇವಿಟ್ ನಾಟ್
22 ಯಾರ್ದು ಕೇವಿಟ್?
ಇಬ್ಬರದು ಒಬ್ಬರದು ಶರದ್
is not put up in this as a prayer.
ಸರ್ವಿಸ್ ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ದೀನಿ ಸರ್.
ರೆಡಿನಾ?
ರೆಡಿ ಮಲೋಡ್.
ನೀವು ಓನ್ಲಿ ಅಪೇರಿಂಗ್ ಫಾರ್ 13 and ಕೇವಿಟ್ ಯಾವ್ದಪ್ಪ ಇದು?
Because our lands mallard are involved.
ತರ್ಸಿ ಕೇವಿಟ್ ಪಾಸೋ. It is Amal, we can't hear it.
8, Abhijit Monkankar.
Yes.
I represent the petitioner, sir.
Ramnagara. Yenappa?
My lord, there was a direction to the petitioner to file an affidavit.
Yes. On the last date, I submitted that I'll supply the copy of affidavit which has been filed by the ADL. Said copy is not available, so I have filed the application. But I have a endorsement issued by the ADLR. It says that the said documents cannot be issued.
If your lordships were to recollect. ಇದಲ್ಲ ನಿನ್ನೆ ಹೇಳಿದ್ದೇನದು?
That is a translated copy.
This was not the order.
This is the endorsement.
738 acres ಯಾವುದೇ ಪೋಡಿ ಆಗಿಲ್ಲ. 738 acres ಒಂದೇ ಒಂದು ಇಟ್ಕೊಂಡು ಕೂತ್ರೆ ಹೆಂಗೆ?
Certain and make submissions.
ಪಾಸ್ ಹೋದ?
ADL, Joida. I will get.
ಪಾಸ್ ಹೋದ.
243.
9, Girish Dharwad.
243 ಪೈಕಿ.
Petition.
ಅಕ್ರಾಟ್.
Sorry.
Check ಮಾಡ್ಕೊಂಡು.
But plaintiff is before my lord's suit for possession. The allegation is that my lord respondent defendant has encroached an area of 10 into 10 feet in the petitioner's property.
Suit for?
Possession. Premised on the basis that my lord the respondent defendant has encroached a portion of 10 feet into 10 feet and has put up a shed in the said 10 feet. Matter evidence was led, my lords, matter was reserved for judgment. At that stage, my lord, the learned civil judge passes a suo motu order appointing a court commissioner. My only submission for my lordship's kind consideration is, my lord, suit is of the year 2016. Evidence has been led and closed. Matter has been reserved for judgment. But once the matter is reserved for judgment, my lord, it is only for the court to pronounce the judgment.
For the court to decide if it wants some assistance.
In that regard, if the court, my lord, of course, I cannot, my lord, come in the way of the court's
Court to
discretion. Absolutely, there is, my lord, unbridled discretion, my lord, to the court. But reasons have to be assigned. Court says, my lords, may kindly look at the impugned order. Page number 27.
Yes.
While perusing the records of the case and preparing for judgment, court finds necessary to appoint court commissioner for local investigation of suit properties for the purpose of better appreciation of evidence and effective adjudication of the dispute. My humble submission, that may not be sufficient. If my lords permit.
After having gone through the records.
Yes.
At the time of judgment, ಇಷ್ಟು ಬರೆದ್ರೆ ಸಾಕು.
If my lords permit, my lord.
ಆಗ್ತಾ ಇಲ್ಲ, ಇದು ಬೇಕು
ಅದಕ್ಕೆ ಅಂತ that is what is implied, my lord, under these in between these lines.
ನಿಮ್ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ನೀವು ಲೀಡ್ ಮಾಡಿ ಸರಿ ಇಲ್ಲ, ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ಅಂತ ಬರಿಬೇಕಾಗಿತ್ತು ಅವರು. Plaintiff has not done this, defendant has not done this.
That could have.
This is good enough.
My lords permit just, my lord. Reliance may be noted. 2004, my lord, division bench, relying on Arjun Singh's case, my lord, of the Honorable Apex Court. Only on that point, once, my lord, matter is reserved for judgment, paragraph number 9.
Application for evidence.
The reason I'm not drawing analogy is, if the court commissioner is appointed and he submits a report, again, my lord, it will be to the stage of leading evidence. That is not permissible.
Notice to respondent is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. Petitioner had filed a suit in OS number 154 of 2016 before the principal civil judge and JMFC Mudol for possession against the defendant therein on the ground that the defendant had encroached upon a portion of the property belonging to the petitioner. In the said suit, written statement having been filed, issues were framed, evidence was led by both the parties, the witnesses were cross-examined, and the matter was posted for judgment. At that stage, on 27/2024, the trial court, on 22/7/2024.
On 20th July, my lords.
22/7 order.
Yes, yes.
On 22/7/2024, the trial court passed the following order, inverted commas, while perusing the records of the case and preparing for the judgment, this court finds necessary to appoint court commissioner for local investigation of suit properties for the purpose of better appreciation of evidence and effective adjudication of the dispute completely.
I seek my lord's
inverted commas closed. It is challenging this order. The subsequent thereto, the
till today has not filed report, my lord, sir.
PDO of Lakshanatti village was appointed as court commissioner to submit a report. The report, according to the petitioner, has still not been filed. It is challenging the order suo motu order appointing the commissioner that the petitioner has challenged before this court in the present petition. The submission of Shri Girish Dharwad, learned counsel for the petitioner, is that once the matter had been posted for judgment, the question of appointment of a commissioner would not arise. That would amount to reopening of the stage of the case. And in this regard, he relies upon the decision in AR Online 2004, Karnataka 2, more particularly para
9.
9 thereof, which is reproduced hereunder for easy reference. His submission is that the object of amendment to the CPC in the year 1999 is to speeden up the proceedings. Thus, once a case is reserved for pronouncement of judgment, no application for recall of a stage would be maintainable.
May I seek my lord's permission? Great.
Heard so-and-so peruse papers. Firstly, the decision in Rubia B. Qasim's case, in my considered opinion, would not be applicable. And that was a case where, in a suit for recovery, when the matter was posted for judgment, the plaintiff filed an application for recalling of the stage to lead evidence. This is a case where the court was of the opinion that a commissioner was required to be appointed to carry out local inspection of the properties and submit a report for better appreciation of the evidence and effective adjudication of the dispute. Order 26, Rule 9. Of the Code of Civil Procedure is reproduced hereunder for easy reference. A reading of the said provision would indicate that in any suit where the court determines a local investigation to be requisite, then such a local commissioner could be appointed by the court appointing a commission. The fact that the words used are, inverted commas, the court deems a local investigation to be requisite or proper, inverted commas close, gives ample discretion to the court to decide whether a court commissioner is to be appointed or not. This power of the court is not restricted by any application to be filed by any of the parties, but it is sufficient if the court deems fit. That would mean that even a suo motu power under sub-rule 9 of Rule 26, Order 26 can be exercised. In the present case, the matter having been posted for judgment, the trial court, in its abundant discretion, having come to a conclusion that the court finds it necessary to appoint a court commissioner for local investigation of suit properties for the purpose of better appreciation of evidence and effective adjudication, no fault can be found therewith. No grounds being made out, the petition stands dismissed.
Ten. Husnur Rajesh.
Please.
This petition is a defendant's number 1 petition.
Yes.
So challenging the order passed by trial court.
Suit for?
Suit for partition and separate possession. My lord, the parties to the suit are Mohammedans. And regarding the relationship, not a dispute.
Yes.
And the suit filed by the daughter-in-law and her sons against the grandfather. That is, the daughter-in-law is a wife of a predecessor son of the defendant number 1, who is filed the writ petition before this honorable court. And the suit properties, the claiming the main contention of the suit, contention before the trial court of the plaintiffs, that is respond number 1 to 3, is that the suit properties are joint family properties. There is no as such joint family is available in the Muslims. And moreover, my submission before these lordships and also before the trial court is that during the lifetime of the father, legal heirs or the sons have no right to seek a partition or even their heirs also.
We are now considering 6 rule 17, not.
Yeah, then we have appeared and filed a written statement on the ground, and also I have filed IR number 7 prior to IR number 8. Seeking rejection of the plaint on the very
That
ground.
is not under challenge before us.
Sir?
That
No, we have
order is not, you are challenging only order on IA 8.
IR number 8 is challenged, and also order on IR number 7 is also challenged.
Where?
Before this court in CRP number 1.
You can address that argument, not here.
No, sir. My submission before Lordship is after conclusion of the arguments on IR number 7 to 11, this very plaintiff has filed an IR number 8, that is which is challenged before this court, before this Lord bench, seeking striking out of the pleadings. That is a strike out of the 2 properties.
Could
Where
not have
3
been
properties
done.
are standing in the name of
Giving up admission. Adiyarli, ನೀವು 7 to 11 ಏನಕ್ಕೆ ಹೋಗ್ತೀರಾ?
ಇಲ್ಲ.
The further proceedings, issue notice to respond number
and proceeded with
1 to 6, returnable by 28th April. The further proceedings in OS number 216 of 2022 pending on the file of the additional senior civil judge and JMFC Mudor. He stayed till the next date of hearing. Process fee and copies to be furnished by end of day 27th February. Acknowledgement of service on the respective counsel for response before the trial court to be filed by end of day 5th March. Failing either of which, the interim order will stand automatically vacated.
11, Nandish Patil. For the petitioner, my lord.
Lord, last week, my lord, this matter had come up before your lordship. As it is covered, my lord, your lordships had directed it to be listed in preliminary hearing.
Notice is not served. Copy is not served.
Lord, I have served on Mr. Prashant Matpati, my lord.
My name
Prashant
is.
Matpati serve ಮಾಡಿದ್ರೆ
ಅಲ್ಲ ಅವ್ರಿಗೆ last year there's an
Prashant
order
Matpati
my
ಅಂತ ಹೇಳಿದ್ದಾರೆ.
to
PP
serve the copy
Matpati
on
ಅಲ್ವಾ?
Mr. Kanavi and
VP
Mr.
Matpati.
Prashant
VP Matpati have sir. That will last time.
Lord, NHAI,
BP Matpatiನಪ್ಪ.
please, my lord, he has collected the.
BP na?
P.
BB ಅಂತ ಆಗಿದೆ. Registry direct correct the appearance of
R2 and R3.
counsel for respond number 2 as BP Matpati.
And R2 and R3. R3 is the SLO.
Submits that. R3 is ನೀವು SLO ನಿಮಗೆ
ಇಲ್ಲ ನಾವು ಬರ್ತೀವಿ ಸರ್ ಅವ್ರು ಬರಲ್ಲ ನಾವು ಬರ್ತೀವಿ
ನೀವು SLO ಗೆ ಅಪಿಯರ್ ಆದ್ರೆ
SLO and
you are running a big risk.
ಸರ್ ನಾವು ಯೂಶುವಲಿ ಎಲ್ಲ NHI
Usually ಗೊತ್ತಿಲ್ಲ ನಮಗೆ SLO you can't appear. You are the beneficiary of the acquisition.
On the last occasion, I made a submission, I accept notice ಅಂತ ಹೇಳಿ.
If you are going to appear for, NHA is going to appear for both SLO and.
SLO and.
Then the acquisition itself is riddled with malafide and bias. On that ground only we'll quash all the acquisition.
The
SLO is supposed to be independent authority.
Not, it is under the.
It can't be under you. We'll record your statement and ask for explanation. Shri BP Matpati.
No,
Permit that you would also be appearing for
I'll-
respond number 3.
I'll take the instruction and I take the
The
instruction.
special land acquisition officer. I am of the considered opinion that the same counsel cannot appear for both the beneficiary of the acquisition and the special land acquisition officer. The SLO being a delegate of the state discharging the power of eminent domain. No, the same counsel cannot appear for both the beneficiary and the state. The SLO being required to discharge its functions in an independent manner without being influenced by the beneficiary. Hence, the Principal Secretary Revenue Department, as also the Chairman of the NHAI, are directed to file their respective affidavits, making their stand clear on this aspect.
Lord, may I request, my lord, can I argue on the interim prayer, my lord? Because last time it was adjourned, my lord, the interim prayers. The lordship may kindly see, my lord, there are 2 notifications, my lord. One notification, my lord, is dated. ಅಲ್ಲ ಅದರದಲ್ಲ ಇಲ್ಲಿ ಹುಬ್ಳಿ ಧಾರವಾಡ bypass, my lord. There is one notification, my lord, that is dated 27/12/22. My lord, we agreed to that notification. The entire work, my lord, has been completed. The road has been widened. The drain also, my lord, has been fixed and the barricades are also completed. I have produced the photographs to that effect. 27/12/22. My lord, the very next day, 2 days after that, my lord, 29/12/22, there is one more notification. Again, my lord, seeking for another additional 18 guntas for the same project.
Let them make the stand clear.
Lord, let there be an interim or not to precipitate, my lord, because, my lord,
Compensation for that.
My lord, now what has happened, my lord, your lordship may kindly see. The photographs may kindly be seen.
You will get your compensation. This is a road project.
My lord, we
Of
have
course,
agreed, my lord, we have agreed for
NHAI is
the,
thinking no end of themselves. We need to rein them in.
my lord, the project having been completed, my lord, additional 18 guntas they are seeking.
It may be required for a service road. It may be required.
Illa,
for so
service
many
road is also completed. Your lordship may kindly see the photographs, my lord.
We'll see
I'll
the
just
photograph, but we are
Your
not going
lordship
to
may
stay.
kindly see page 50, my lord. I'm not objecting, my lord. For the first notification, we have clearly, my lord, conceded.
Really, where is the photograph?
My lord, page 50, your lordship may kindly see, my lord. My lord, the photograph that the first photograph itself, my lord, your lordship may kindly see. The entire project is completed. Drain is also formed.
Illa, inna bada kelsa ide.
Illa. Your lordship may kindly see, my lord. Four
Bada
photographs
kelsa
I have
ide.
produced.
Inna bada kelsa.
Another 18 guntas they are seeking, my lord.
List on width ಎಷ್ಟು?
Lord, insofar as 2712 notification they have completed.
Length ಎಷ್ಟಾದ್ರೂ ಇರ್ಬೋದು, width ಎಷ್ಟಿದೆ?
Width, my lord, that is what, my lord, there is no details in the notification also. Hence, we are relying upon your lordship's judgment.
11th March.
Please.
12, Srivatsa Hegde.
Yes.
On behalf of respondent number 2.
Who is respondent number 4?
My lord, if my lord recollects, this is a petition where I hold the concessionaire agreement with the respondent number 2 and 4.
You will have to pay process fee. You don't pay a process fee.
No,
what
I
to
will
do?
just refresh my lord's memory. The other day, my lord had passed an interim order. Then third respondent intervened to say that he will try to be of some help in disposing of the matter itself.
I'll secure instructions and they're disposing. I'll secure instructions.
But
What
then
exactly is has been done?
No, after passage of the interim order, he made a submission, my lord, and that is the reason why it was.
Asked, because we called him and we asked him to get instructions, museum and either Thane.
Yes, yes.
Oh,
But then we said that respondent number 4 has to be served. We asked you if you have any standing counsel.
I
Illa
would
andre.
request, my lord, dispensation of notice to R4 because
How can we
I'm not in
dispense?
conflict with either R2 or R4.
How can we dispense with
They
that?
have been actually writing letters to respondent number 3 to allow this implementation of the project, my lord. Smart City Corporation has been writing letters, but it is only the third respondent who has been putting fetters in my project.
Kapil Walvekar.
My lord, on behalf of respondent 2, seek 2 weeks time for filing objections and
Yeah.
withdrawal.
No, I have not made any prayer against R2.
Without respondent number 2 supporting you, how can you get any order?
Allah, now he is a proxy counsel, my lord, but my petition, I have not made any prayer against R2 or R4.
Yes.
It is only third respondent who has been.
We can't tell you what you are supposed to do.
No, my lord, they are with
But if
me.
they are going to come and ask for time, because without their support, how do we pass an order?
No, my lord had already passed an order. Kindly, my lord, because he came in between and said, don't pass the interim order because I will get instructions. This is what he had said.
Yes.
My instructions are not, subsequently, my lords, corporation has passed a resolution, my lords, not to give this land to the smart city for this multi-facility
You are
utility.
not giving the land at all.
Yes, my lords. This is the resolution passed by the city corporation, my lords. We have, this is my instructions.
Told they will be filing statement of objections on behalf of respondent number 2, my lords.
Why should we give you time? You are supposed to come and make your submission at least. How can you be asking for time?
Proxy submission, my lords. Due to some personal inconvenience, Kapil sir could not be present here today, that's why.
So?
At least a week's time, maybe.
We'll direct them to get the land and give it to them.
At least a week's time, my lords.
The my lord, kindly see page number 31.
If
This
they are not
land is
giving it,
already
what
handed
to do?
over. Land is already handed over to me.
Now they will take it away. Why do you want to spend money?
They can't, my lord, because there is an agreement.
The net counsel for respondent number 3 submit that there is a resolution passed by respondent number 3 cancelling the allotment made of the land to respondent number 2. And as such, he submit that the petitioner cannot go on with construction on the said land. Learned counsel for respondent number 3 seeks for a short accommodation to make his submission. He is directed to make a submission as to whether the land continues with respond number 3 and whether the petitioner can go on with the project. Relist on
Lord,
4th March.
Lord, truly speaking, my lord, I am feeling tricked because the other day I secured an interim order at the hands of my lord, and then at the right time he makes a submission that he will come out with something which will help this honorable court. Now he says that he has no instructions. There was an order passed.
Yes, that this one has been cancelled antare.
No cancel. They cannot, my lord. This land is already handed over.
That is what his
Corporation.
submission, council resolution is saying.
My lord, corporation has no authority to cancel this.
Place it on record, then you'll have to challenge it.
Kindly have it, my lord. If it happens before my lord, I would be grateful.
It won't happen in next 2 days. In erade dina iradu. Let them place it on record.
Well, I have made
You will have to
investments, my
challenge
lord.
it.
And because I am never so persuasive, my lord, because
Say, if you have spent money, you can recover it from smart city. Needless to say, if the land is no longer available with respond number 3, respond number 3 would be liable to make good all the losses which have been caused to the petitioner. That you use against them. Both of them are playing around.
all the damages were whatever.
Everything. We don't need to tell you.
13, Vijay Kumar Horatti.
As to regarding prayer A is concerned, my lord, it has already been, my lord, expired. I had sought for, my lord, the stay of the meeting, which was to be held on 21st.
In meeting up, I know.
Meeting was, my lord, it was held by the respondent 5 for allotment of houses under Rajiv Gandhi Housing Corporation. But, my lord, as per the norms are introduced by the respondent 2, whereby, my lord, it specifically states that certain of the houses have to be allotted to
And
the.
AGA accepts notice for respond number 1. Rajiv Gandhi yaru. Avinash Bankar for 2. ZP Koppal.
ಅಲ್ಲಲ್ಲ ರಾಜೀವ್ ಗಾಂಧಿ ಅವಿನಾಶ್ ಬಣ್ಕರ್ ಅಲ್ಲ
ಮತ್ತೆ ಯೂನಿವರ್ಸಿಟಿ
ಹೌಸಿಂಗ್ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಯೂನಿವರ್ಸಿಟಿ ಅಲ್ಲ
ಯೂನಿವರ್ಸಿಟಿ ಅಲ್ಲಪ್ಪ ಹೌಸಿಂಗ್ ಬೋರ್ಡ್
ಹೌಸಿಂಗ್ ಮೇಡಮ್ ಅಪಿಯರ್ಸ್
ಸುಮನಾ ಬಾಲಿಗ
ಹೌದು
ಸುಮನಾ ಬಾಲಿಗ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಕೊಪ್ಪಳ ವಿಜಯ್ ಕುಮಾರ್ ಬಳಗೇರಿ ಮಠ್ ಫಾರ್ 3, 4, 5, 6. Please counsel for the petition serve 2 sets of the petition along with the next on the said counsel. Relist on 11th March.
14, Raja Raghavendra Naik.
Seek permission to appear on behalf of petitioner. The defendant's petition, the suit is for declaration. After closing the plaintiff's evidence, immediately, my lords, I filed application seeking to reopen the case and cross-examine PW 2 and 4.
You are?
I am defendant.
Defendant number 1.
Defendant number 1. Suit is for declaration. Plaintiffs, my lords, have concluded their evidence. Immediately, my lords, before I ventured into the box, I filed, my lords, 2 applications to reopen the case and permit me to cross-examine PW 2 and 4. That's the court, my lords, that I am trying to protract the proceedings.
Very long cut.
I did not, my lords, I did not protract the proceedings. Immediately next, my lords, I filed.
Issue notice to respond number 1 to 5, returnable by 16th April. The further proceedings in OS number 81 of 2015 pending on the file of the senior civil judge Kushtagi is stayed till the next date of hearing. Process fee copies by end of day 27th, acknowledgement by 6th, failing which.
Please. Next matter is also same. Only the plaintiff is different. Same, my lords. Same application.
Same order 15.
Please. Grateful.
16, H.N. Gulreddy.
Lordship, writ of mandamus, your lordship. Here the respondent number 2 has not considered the representation dated 29/11/24.
OD and Durustina.
Your lordship, here the
32 acres. And AG accepts notice for respond number 1 and 2. Petitioner is before this court seeking for the.
One submission. Insofar as consideration of their annexure C is concerned, they are seeking for fixing the boundaries.
Determining.
But as per the sale deed, there is no such boundaries which have been notified in the.
ಮಾಡ್ಲೇಬೇಕಲ್ಲ ಇವಾಗ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ದಲ್ಲಿ ಅವ್ರ boundaries ಏನೇ ಇಲ್ಲ.
ಯಾರು ಸೇಲ್ ಡೀಡ್ ಮಾಡಿರೋದು? Who has executed the sale deed? The private party.
ಹೌದು.
Your Lordship.
There is no boundary at all.
How did it get registered by the sub-registrar?
Your Lordship, there is total 226 acres, Your Lordship. Out of that, we have purchased 32 acres.
So where is that 32 acres? What is the boundaries according to you? It's right, ellogi ಹುಡುಕದು.
Kindly pass, Your Lordship. I'll seek instruction.
Get a rectification of the sale deed done and then come.
The second matter is also same, Your Lordship. 70.
Pass.
Please.
18, Turaj Parole.
Read for mandamus, my lord. My lord, here the petition property is situated within the limits of corporation, my lord. And I have submitted a representation to the corporation, respond number 3, for the.
ಯಾರು ಬೆಳಗಾವಿ ಸಿಟಿನ?
Please, ma'am.
ಚೇತನ್ ಮುನೋಳಿ.
Covered by your lordship
AG accepts
judgment.
notice for respond number 1 and 2, Shri Chetan Munoli for respond number 3.
Covered by our lordship judgment, my lord. This one, when the property is situated within the limits of corporation.
Judgment, ಅದಕ್ಕೆ ಏನಕ್ಕೆ judgment ಬೇಕು? Petitioner is before this court seeking for the following relief. The grievance of the petitioner is that the
Petition property.
request of the petitioner by way of a representation dated 4/2/2025 to issue a khata in respect of the property of the petitioner which falls within the jurisdiction of respond number 3 has not been considered. ನೀವು ಕೊಟ್ಟಿರೋದೇ
4/2 ಕೊಟ್ಟಿದ್ದಾರೆ.
19/8 ಇದೆ. Earlier representation 19/8/24 and subsequent representation 4/2/2025 has not been considered. In that view of the matter, whenever any application is same, I pass the following order. Writ petition is allowed, a mandamus is issued. The respond number 2 and 3 are directed to consider the representation dated 19/8/24 at annexure D and 4/2/2025 at annexure A within the timelines prescribed under Karnataka Sakala so and so.
Please.
19, Pichidananda.
Lord,
Petitioner.
Lord, this with regarding to educational institution
run by
exemption.
the panchayat in Uttar Kannada district, please, my lord. In Mirjan village. They
now
have served
demand
with a
notices have
demand
been
notice.
issued.
Property tax.
ಹೌದು.
Property tax.
Education. ಯಾರು?
SVIG ಅವರು.
And AGA for respond number 1, SVIG for respond number 2 and 3. Petitioner is before this court seeking for the following reliefs. Education. Liberty is reserved for.
Please.
Liberty is reserved for carrying out a survey to ascertain premises used for non-educational purposes and levy tax.
Petition accordingly disposed of.
Disposed. IA 1 stands allowed.
20, Sharad Patil.
Yesterday's matter, my lords, lordships have directed to post.
Yesterday ಅಂದ್ರೆ ಏನಪ್ಪ? Yesterday ಅಷ್ಟೊಂದು.
Cavator, my lords, I have served a copy, my lords, to the cavator.
ಯಾರಪ್ಪ? ಶಿವಕುಮಾರ್ ಅಪರಾಜ್.
On Sunday also, my lords, I have served. Today also, my lords, I have served in the copy, my lords.
Yes, ಹೇಳಿ.
My lords, this is next year J, my lords, challenging, my lords, land tribunal order, my lords. It was remanded twice, my lords. Only on the stray admission given by the landlord and the tenant, it has been ordered. My lords, it was in Saluruli Patta land, my lords. He says, my lords, the land itself is not cultivable. And the portion of the order may kindly see, my lords. He says some of the lands belongs to Karnataka and the remaining lands, the portion belongs to owners. Which proportion of land doesn't say at all, my lords.
ಎಲ್ಲಿದೆ ಅದು?
My lords, at 86, my lords, page number 86. Adesh Shanti. Second paragraph. Lords, it says, my lords, ಆದೇಶವು ನೀಡುವ ಗ್ರಾಮ RS ನಂಬರ್ 121 ಕ್ಷೇತ್ರ 5 ಎಕರೆ 15 ಗುಂಟೆ ಆಕಾರ. ಈ RS ನಂಬರ್ ಈ ಜಮೀನುಗಳನ್ನು ಅಂದ್ರೆ ಗೌರ್ಮೆಂಟ್ ಹೋಗ್ತಾ ಅಂತಾರೆ. ಆಮೇಲೆ the remaining lands will go to the owners ಅಂತ. From 1964, my lords, my names are in the record of rights. And my lords,
What is the reason for it to go to the government?
My lords, since it is the land itself is not cultivatable ಅಂತ ಹೇಳ್ತಾರೆ, my lords. And my lords, kindly see annexure EF, my lords. It is the loan, my lords, where I have taken. And annexure G is a special land acquisition officer who has acquired the land.
Cultival ಅಂದ್ರೆ ನಿಮ್ಗೆ ಏನಕ್ಕೆ ಬರ್ಬೇಕು? ಲ್ಯಾಂಡ್ ಓನರ್ ಗಾರು ಕೊಟ್ರು, ಓಕೆ, ನಿಮ್ಗೆ ಏನಕ್ಕೆ
ಸರ್?
ಏನ್ ಮಾಡ್ತೀರಾ ಅಲ್ಲೋಗಿ ನೀವು?
One submission in the earlier litigation before this honorable court, page 75 may kindly be seen.
Yes.
At para 13. The land tribunal at one breath holds that the landlords are personally cultivating, but however proceeds to invoke section 44 of the act and has passed a vesting order. This finding has been palpably erroneous and contrary to material law. If the tenancy of the land immediately prior to 1374 is not established, there can't be vesting. The object of amendment of Karnataka land reform was to bring in abolition of appensity landlordism and conferment of ownership on the actual filers of soil. Having rejected the four numbers filed by the tenants, there cannot be implead vesting order. There has to be a positive finding that even landlords are not personally cultivating the land in question. All these material aspects are not dealt by the respondent while tribunal. Thereafter, my lord, the lordship at page 85. Now the present impugned order. May I take it at first paragraph?
Yes.
Email
Lord, withdraw.
We have dictated the matter. Please don't make it sub-
I know,
Don't
I
do
know,
this.
I know.
Don't do this.
Please.
Sir, cause list 2 of Court Hall 4.
Cause list to connect. Yes,
Serial number 24, my lord.
34,
24.
24.
It has settled, my lord. The
Hmm?
negotiation is going on. Matter may be restored, my lord.
Ma-
Matter may be restored, my lord. In the next date of hearing, the settlement will be reported.
ನೀವು ಸೆಟಲ್ಮೆಂಟ್ ರಿಪೋರ್ಟ್ ಮಾಡಿ ಯಾವತ್ತು ಅವತ್ತು ರೀಕಾಲ್ ಮಾಡ್ತೀವಿ ಯಾವತ್ತು ಹೇಳಿ
In my second week of March, any
2009 ಮ್ಯಾಟರ್ ಯಾವತ್ತು ನಾಳೆದ್ದು
ನಾಳೆ ಬೇಡ. Still negotiation is going on in the next
ಹೇಳಿ
week of
ಬೇಗ?
my lord March, any date.
24 counsel for the petitioner submit that if the matter is taken up on 10th March settlement
Please.
would be reported relist on 10th March at 2:30 p.m.
Please.
Serial number 131.
Hmm?
131 serial number. That is linked with some other matter. My matter is GMCPC. That is LP matter is connected.
ಯಾರು ಹೇಳಿರ್ತೀರಾ 131 ಅಜ್ಜನ್ ಆಗಿದೆ
But de-link it that.
131.1 de-link and relist on 12th March.
Serial number 71, my lord.
ಹೇಳಿ
Further office objection regarding court fee is raised, my lord. Court fee is paid today. As far as 30.1 is concerned, the office has raised objection to produce the plaint in OS 33 of 1992,
Mr.
my lord.
Latkan,
ಅಲ್ಲ ಅದರಲ್ಲಿ I have produced the endorsement
you
from.
are please mentioning now, you are not arguing a matter. ಅದರಲ್ಲಿ ಇದರಲ್ಲಿ ಏನಿದೆ
Please.
ನೂರ ಐದು ರೀಚ್ ಆಗಿಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಐತೆ ಎಕ್ಸ್ಟೆಂಡ್
ಆರ್ಡರ್ ಶೀಟ್ ಯಾಕಂದ್ರೆ ಇದ್ರಲ್ಲಿ 25
ಟುಸೆಟಿ ಯಾವುದು ಮಾಡಲ್ಲ ಸರ್ ಇದೆ ಸರ್
ಶ್ರೀಮಂತ ಬರ್ಕೊಂತೇನ
ಮಧ್ಯಾಹ್ನ ಓದ್ತೀನಿ ಇಲ್ಲ ಮುಸ್ಲಿಂ ಹೇರಿ ಮುಗಿದೈತಿ
ನಂದು ಅದು 105 ಬರ್ಕೊಂತೀನಿ ನೋಡಿ ನೆಕ್ಸ್ಟ್ ಬೆಂಚ್ನಾಗ ಮತ್ತೆ ಯಾರ ಬಂದಿರೋದು
ಇಲ್ಲ ಸರ್ ಮಾಡ್ತೀನಿ ನಾನು ನೋಡ್ತೀನಿ ತೋತೀನಿ ಅವ್ರ ಹೆಸರಿಲ್ಲ 30 ಇದು 12/3
ಸರ್ ಕಲಬುರ್ಗಿ ಇದೊಂದಿದೆ ಸರ್, ಕಲಬುರ್ಗಿ ಇದ್ದಿದೆ, ಅದು ಮುಗಿಸಿ ಹೆಂಗೆ ಹೇಳಿ ಸರ್ ನಾನು 10 ನಿಮಿಷನೂ ಆಗ್ಬೋದು, ಅರ್ಧ ತಾಸು ಆಗ್ಬೋದು.
ಸರ್ ಪಾಸೂರು ಯಾವಾಗ ಕರಿತೀರಿ?
ಪಾಸೂರು 2:30 ಮುಗಿಸಿ ಕರಿತೀನಿ.
2:30 ಮುಗಿಸಿ ಕರಿತೀರಿ. ಥ್ಯಾಂಕ್ ಯು.
ಶರವಣ 64 ಮೊನ್ನೆ ಇವತ್ತು ಹಾಕಿ
ಮಾತಾಡ್ಬೇಕಿದ್ರೆ
ಎಂಟ್ರಿ ಮಾಡೋ ಅರ್ಜೆನ್ಸಿ ಮೆನ್ಷನ್ ಮಾಡಿ ಲಾಸ್ಟಿಗೆ ತಗೋರಿ. 64 ಆರ್ಡರ್ಸ್
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಆಗಿಲ್ವಾ ಅದರಲ್ಲಿ? ಹೇಳಿ ಆಮೇಲೆ.
ಫಸ್ಟಿಗೆ ಹೇಳೇನು ಗುಲ್ಬರ್ಗ ಆದ್ಮೇಲೆ?
ಇಲ್ಲ, ಬೆಂಗಳೂರು ಇದು ಕಲಬುರ್ಗಿ ಇದೆ, ಕಲಬುರ್ಗಿ ಮುಗಿಸ್ತಾರೆ.
2:30 ಬಂದಿಲ್ಲಲ್ಲ?
ಆಮೇಲೆ
2:30 ಬಂದಿಲ್ಲ.
ಎಷ್ಟು ಸುಲಭ ಇರ್ತಾವ 2:30 ಮೂವ್ ಮಾಡಿರ್ತಾರ, ಅಲ್ಲಿ ಫೈಲಿಂಗ್ ಆಗಿರಲ್ಲ.
ಅದು ಮಾತ್ರ ಖರೆ.
ಅವ್ರು ಬಂದು ಅವ್ರು ಎಂಟ್ರಿ ಮಾಡಿ ಈ ಕಡೆ ಬಂದು ಸ್ಕೂಟ್ನಿ
ಅಂದ್ರೆ 7 ಗಂಟೆ ತನಕ ಇರೋ ವಸ್ತಿ ನಾವು.
7 ಗಂಟೆ ನಾವು ಸಾಹೇಬ್ರ ಇದ್ದಿತ್ತು, ನಾವು ಹೋಗಿವಿ 8:30 ಪುಣೆ 9. ಯಾವ ಎಲ್ಲ ಬರ್ತವೆ, ಯಾವುದು ಬಂದಿಲ್ಲ ಇನ್ನು.
ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು 98 ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು.
98 ಅರ್ಜೆಂಟ್
ಎಲ್ಲ ಗವರ್ಮೆಂಟ್
ನೋಡು ವೇಟ್ ಮಾಡಂದಂಗ ಆತಲ್ಲ ನಿಮ್ ಕಲಿಗ.
ಔಟ್ ಆಫ್ ಟರ್ನ್ ತೊಗೊಳಲ್ಲ, ಯಾವುದು ತೊಗೊಳಲ್ಲ. ನೀವು ಕವರ್ಡ್ ಅಂದ್ರೆ ತೊಗೊಳಲ್ಲ, ಏನು
ಆರ್ಡರ್ಸ್ ಏನ್ ಹೇಳ್ಬೇಕಾ?
ಎಂಟ್ರಿ ಮಾಡೋದಿಲ್ಲ
ಬಂದಿಲ್ಲ ನಂದ್, ಬಟ್ ಹೋಗೈತ್ ನಂದು ಬೋರ್ಡ್ ಬ್ರಾಂಚ್.
99
ಹಣ ಎಷ್ಟದ ಗುಲ್ಬರ್ಗ ಎಷ್ಟು?
ಒಂದೇ ಒಂದು
ಅವು ಲೇಟ್ ಲಿಸ್ಟ್ ಬರೋ ಮಟ್ಟ ಕರೆಯೋದೇ ಲೇಟ್ ಆಗಿ 2:30 ಮುಗಿಯೋ ಮಟ್ಟ ಕರೆಯೋದಲ್ಲ ಅಲ್ಲಿ.
ಲಿಸ್ಟ್ ಬಂದಿದ್ದೀರಲ್ಲ ಬಂದಾಗ ಇವ್ರು ಕರಿಬೇಕಾದ್ರೆ ಬೆಂಗಳೂರಿಂದ ಲಾಗಿನ್ ಆಗಿದ್ದಾರೆ. ಯಾರು ಲಾಗಿನ್ ಆಗಿದ್ದಾರೆ ಇವ್ರ ಲಿಸ್ಟ್ ಬಂದಾಗ ಇವ್ರು ಕರಿಬೇಕು.
Friday something. The PA holder is not well.
Serial number
133.
133. At the request of council, both the councils relist on
Friday.
28th
Please.
February. Agata?
Everything is ready. That PA holder is not well. I'll avare madidare.
28.
Please.
My lord, shorts.
Madam.
64, my lords. Your date ಕೊಟ್ಟಿದ್ರು my lords for interim order. I have served a copy to R6. Postal share has been attempt delivered. Lords, I request some urgency matters not to alienate to third parties.
No, we'll see.
Please.
Everybody has urgency. ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Date has been.
Matter pertains to Kalburgi bench. Muhammad Abdul Qayyum.
Yes, Mr. Bhatt. We can't hear you. We can't hear you.
Kalburgi bench matter.
Yes, Mr. Bhatt. Lord AG, though has logged on, this court is unable to hear him. He seeks for 2 weeks. He seeks for and is done 2 weeks time to report further compliance. Relist on 17th March.
To 30 matter. 118. Surabhi Kulkarni.
ಕೇಸ್ಗಳು ಇವ್ರು ಗೊತ್ತು ಹೆಂಗ್ ಮಾಡೋದು ಅಂತ ಅವ್ರನ್ನ ಇವಾಗಲೇ ಲಾಗಿನ್ ಆಗಿ ಕೇಳಿ ಲಿಸ್ಟ್ ಬಂದವಾಗ ಇವ್ರು ಬರಲಿ ಇವ್ರಿಗೆ ಏನು ಮಾಡಿದ್ರು ಅಂತ ಅದಕ್ಕೆ
Lords, in this regard, my lords, I have only a couple of submissions to make, my lords.
Oh,
Lords,
this is at 5:59.
please.
Yes.
The petitioners are husband and wife, my lords, and are now aged about 78 and 68 years. My lords, the petitioners have been in possession of the entire extent of the land since 1986 as its lessees, my lords. And they were running a firewood depot in the said land. And my lords, the owners of the said land had permanently settled in Mumbai, my lords, and they had completely handed over the possession to the petitioners.
Yes.
In 2000, my lords, when the sale deed was executed, it was executed only in respect of some portion because, my lords, the other portion was earmarked for road. Although, my lords, the owners intended to sell the entire portion, they could not do it because the other portion was earmarked for road.
Yes.
Thereafter, my lords, when the road was not formed and land was not...
But you did not want to pay for the entire thing. So you paid only for what you bought.
Even after the sale deed, my lords, they remained in possession of the other portion, my lords, as lessees.
Yes.
They continued in possession. And my lords, thereafter, when the land was not acquired for road for so many years, the owners, my lords, reaffirmed their intention by virtue of a compromise decree. My lords, reaffirmed their original intention to sell the entire...
Sale deed, madam, compromise is not acceptable.
I agree, my lords, the sale deed is only in respect of some portion. But my lords, this compromise, my lords, reaffirms their intention to sell the entire extent.
The intention can be anything. Is it been affected? Your intentions are clearly coming out the way you're misled everywhere.
My lords, admittedly, it is a private land, my lords. It does not belong to the corporation. And my lords, the corporation was duty bound to acquire it, my lords, in accordance with law and pay the compensation to the rightful owner.
Whom? Not for you.
By virtue of, my lords, compromise, when the owners, my lords, are admitting...
We have already told you, huge cost will be imposed. Reserved.
Hundred and 19, Anand Arkolli.
Yes, Mr. Kohli.
My lord, yesterday I filed an affidavit of the Assistant Commissioner stating that, my lord, the document which has been produced along with the memo with regarding to the requisition of no confidence, on that requisition it has not been acted and a second file has been maintained. Based on the original file, my lord, as the lordship has already gone through the original file. On that basis, my lord, Form 3.2 was issued.
We consult.
Why two files are maintained?
My lord, insofar as that consent is, my lord, that pursuant to the lordship's directions, we have intimated the assistant commissioners not to take in endorsements of the PDO, but that requisition which was submitted certified copy, wherein my lord PDO was requested that. For that reason, my lord, the assistant commissioner insisted that not to accept that. So for having submitted, he has maintained a second file, but the acted upon the original file, that is on the same day another requisition has been submitted by the members. On that basis, my lord, Form 3.2 has been issued. That Form 3.2 has been stayed by this honorable court not to precipitate.
Where is Mr. Kohli?
Anand Arkolli.
And this is the original file which the lordship has already gone. Please, please, please.
Dismiss madveno.
Right.
It's Bunny, Mr. Kohli. ನೋಡಿದಿರಾ affidavit?
Yes, sorry. Ready?
ಹೇಳಿ.
ಆಯ್ತು. Lords, page 34, my lords. Where, my lords, in pursuance of this notice, my lords,
a no confidence meeting is fixed on 7/1/25.
Hmm.
When this is pending for considerations, my lords, they had moved another one on 24/12/2024.
Page?
My lords, form number 1, my lords, you'll get, my lords, at page 39.
Either form 2 on 21/12.
Yes, my lords.
Yes.
And my lords, on 18/1/2025, my lords, form number 2 has been issued,
Hmm.
where, my lords, meeting is fixed on 18/1/2025, issued on 3/1/2025.
Hmm.
Where, my lords, my respectful submission is this, my lords.
Yes.
Plus, when, my lords, form number 2 has been issued on 21/12/2024, when it is already under process,
Hmm.
on the basis of the second, my lords, the representations, the assistant commissioner, my lords, cannot move.
No meeting took place on 7/1.
Yes, on 7/1, no.
Yes.
And also I had been produced, my lord, to that effect, my lords, where the PDO has been issued. That meeting was not been held on 7/1/2024. On 7/1/25, my lords.
Yes. Yavattu ಅದು? Where is that?
Yet that, my lords, I had produced along with a memo dated on 17/1/25, my lords,
17.
to show that meeting was not held.
Yes.
Since, my lords, as my lordship known, my lords, clause 5, my lords, section 3,
Hmm.
where, my lords, when already, my lords, the process is going on, when the meeting is yet to be, my lords, happened in the next date, previous that, my lords, they can't move an applications. Assistant commissioner do not have jurisdictions, my lords, to issue another one. My first submissions, my lords. And second, my lords, if first submissions could be, my lords, the whole good, my lords, they filed an affidavit to the extent of that, my lords, form number 3 forms, they made my representation in the form number 1, 3 applications. One is, my lords, to me, and one is, my lords, to the assistant commissioner, and, my lords, another one, my lords, another one on the endorsement of the PDO.
ಇಲ್ಲಿ 3 forms ಎಲ್ಲಿದೆ?
No, sir. 3, my lords, this way, my lords, that original record that have been produced.
ಇದೆ ಅಲ್ಲ original record.
Yes.
Which are the 3 forms?
3 in the sense, my lords, one endorsing the PDO, another one is the original file, and, my lords, even the original is also with me. Why I am saying is this, my lords, the last day assistant commissioner filed an affidavit saying that, my lords, they have not been acted upon.
Hmm.
My lords, as per my party instruction is concerned, my lords, they filed an applications, my lords, by endorsing the PDO on 24/12/2024. Later on, my lords, when come to the notice that, my lords, without, my lords, withdrawing this, they filed, my lords, without, my lords, endorsement on the PDO. Yes.
There are 2 different arguments.
Yes.
One is 7/1 ಇದ್ದಾಗ ಇನ್ನೊಂದು 24.
Yes, that is the legal ground, that is, my lords.
Second one is you are saying PDO signature ಇದೆ ಅಂತ.
Yes.
ಅವ್ರು ಹೇಳ್ತಾರೆ ಅದು 2 ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದು ಕೊಟ್ಟಿದ್ದು ಅದು ಅದ್ರ ಮೇಲೆ ಆಕ್ಟ್ ಮಾಡಿಲ್ಲ, ಬೇರೆ ತಗೊಂಡ್ ಬನ್ನಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದು ತಗೊಂಡು.
That is on fact is concerned, my lord, that is the second
So the second argument will not
I am
work.
not pressing that.
The first argument is what?
Yes.
ಇನ್ನೇನಾದ್ರು ಇದೆಯಾ?
No, my lord. Second, where, my lords, 5, my lords, please show that, my lords, assistant commissioner, my lords, cannot act upon or to withdraw
Clause 5, my lords. Save as otherwise in the act of these rules, meeting convened for the purpose of consideration of the motion sub rule 1 shall not be for any reason adjourned.
Yes.
So Assistant Commissioner, my lords, cannot adjourn them. He has to attend the meeting on 7/1/2025.
Here it is not the question of adjournment, it's a fresh notice being issued.
Yes, fresh notice has been
Fresh
issued.
notice also cannot be.
Yes, that can't be done.
Yes.
So my respectful submission insofar as annexure F is concerned, my lord, at page 33, that notice has not been acted upon.
How can you say not acted upon?
My lord,
Why did you issue the notice?
My lord, thereafter, annexure H, page 39, motion of requisition submitted by the members. That was on 24/12/2024. Based on this, my lord, annexure J and J1 have been issued.
So you issued form 2 on 21/12.
So, yes, my lord. Yes.
Setting the date of meeting as 7/1.
Yes, my lord.
What happened to this?
This has not been acted upon, and on the last occasion, I made a submission that the Assistant Commissioner has withdrawn.
Where is the withdrawal?
My lord,
You should have communicated the withdrawal to everybody.
for that reason, it is part of the record, but it is not communicated to the members of the. But it
in record ಅಲ್ಲಿ ಏನಿದೆ?
withdraw ಮಾಡಿದ್ದು
ಏನಂತ reason ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ?
wait. Lord, the reason assigned is ಪ್ರಯುಕ್ತ ಸದರಿ ಉಲ್ಲೇಖ ಮನವಿಯಲ್ಲಿ ಪರಿಗಣಿಸಿ ದಿನಾಂಕ 24/10/24ರಂದು ಅಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ಮತ್ತು 10/12/24ರಂದು ಉಪಾಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ಅವಿಶ್ವಾಸ ನಿರ್ಣಯ ಕುರಿತು ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯನ್ನು ಇದೇ ಹಂತದಲ್ಲಿ ಮುಕ್ತಾಯಗೊಳಿಸಿದೆ ಎಂದು ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಚುನಾಯಿತ ಸದಸ್ಯರಿಗೆ ಈ ಮೂಲಕ ತಿಳಿಸಪಡಿಸಿದೆ. That is on 23/12/2024. The reason for the reason ಮೇಲ್ಗಡೆ ಹೇಳಿದ ದಿನಾಂಕ 18 ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ರಿಟ್ ಪಿಟಿಷನ್ ಸಂಖ್ಯೆ 10681124 ದಾಖಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ದಿನಾಂಕ 18/12/24ರಂದು ಸದರಿಯವರು ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯನ್ನು ವಜಾಗೊಳಿಸಿರುತ್ತಾರೆ ಮತ್ತು ಅಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ಅವಿಶ್ವಾಸ ಸೂಚನೆ ನಿರ್ಣಯವನ್ನು ಮಂಡಿಸಲು ನೂತನ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಲು ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿರುತ್ತಾರೆ. ಅದರಂತೆ ಅವಿಶ್ವಾಸ ನಿರ್ಣಯದ ಕುರಿತು ದಿನಾಂಕ 24/10/24ರಂದು ಅಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ಮತ್ತು ದಿನಾಂಕ 10/12/24ರಂದು ಉಪಾಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯನ್ನು ಪರಿಗಣಿಸಿದಂತೆ ಮನವಿಯನ್ನು ಹಾಗೂ ಹೊಸ ಅರ್ಜಿಯೊಂದಿಗೆ ಅವಿಶ್ವಾಸ ನಿರ್ಣಯ ಸಭೆಯನ್ನು ನಿಗದಿಪಡಿಸಲು ಮನವಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. So based on that, my lord, it was
reserved, so they were given. Yes.
Based on this, my lord, on the immediate, that was on 24 acted upon. But after came to the Assistant Commissioner realized that, my lord, in view of the liberty having been immediately na ಮಾಡಬಾರ್ದಿತ್ತು, action would have not been taken. So for that reason, he passed a corrigendum order on 23/12/2024 stating that this notice which was issued under Rule 32 has not been, and it has been withdrawn. Though there is no such provision under the Act with regarding to the withdrawing of the order wherein, my lord, pursuant to which, but as per our respectful submission is that the notice which has been issued has not been acted upon on 7/1/2024. No meeting has been proceeding. Thereafter, my lord, a fresh requisition having been submitted by the members on 24/12/2024, proceedings have been initiated. So, my lord, even though if you take into consideration, if it is acted, then for the next 6 months there is no. So when the Assistant Commissioner has not acted upon the said impugned, that is annexure F is concerned.
He, my lord, let my lord,
No proceedings have been initiated on that. So my respect.
If law permits, my lords, to do the act, my lords, let him do.
That will take action against the Assistant Commissioner.
Yes.
But that cannot deprive the elected representatives from moving a no
confidence motion.
But when, my lords, law, my lords, he cannot adjourn the meeting for any reasons.
ಹೌದು, ಅದು ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ and we'll take action against them. We'll take action. We'll take action against the Assistant Commissioner. But that does not mean that the elected representative cannot call for a meeting.
Yes, and my lord, if that is the case, my lords, then insofar as the representations is concerned by the PDO, where, my lords, they had issued a certified on 24/12/2024.
Anyway, now we'll quash this. We'll
liberty shall be reserved to the members to move for a fresh.
We'll take action against the Assistant Commissioner. So fresh round, one more round.
Yes.
ಎಲ್ಲ ಇದಾರ 2-19 ಇಬ್ರು ಇದಾರ ಯಾರು ನಿಮ್ ಲಿಸ್ಟ್ ಬಂದವಾಗ ಬನ್ನಿ. MNPG list ಬಂದಾಗ ಆಗ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ. CL number 119. The petitioner is before this court. Petitioners are before this court seeking for the following reliefs. Petition number 1 is the Adhyaksha and petition number 2 is the Upadhyaksha of the Ganadal Gram Panchayat. The petitioners are aggrieved by the notice issued by respond number 1 Assistant Commissioner dated 3/1/2025 fixing the date of the meeting
On
for
18/1.
consideration of the no confidence motion against the petitioners on 18/1/2025. The submission of Shri Anand Kolli, learned counsel for the petitioner, is that once earlier a notice had been issued on 3/1/2025 fixing the date of meeting on 18/1/2025.
Lord, 21/12, annexure F, page 33.
On 21/12/24 fixing the date of meeting as 7/1/2025.
Yes.
The said notice having been issued in terms of Form 2 in pursuance of Sub-Rule 2 of Rule 3 of the Rules of 1994, there was no meeting which was conducted on 7/1/2025, and as such, a fresh notice could not have been issued on 7/1/2025, fixing the date of meeting as 18/1/2025. The submission in this, as regards this, is twofold. Firstly, by relying on Sub-Rule 5 of Rule 3, he submits that when a meeting has been convened for the purpose of consideration of a motion under Sub-Rule 2, it shall not be, for any reason, be adjourned. And in the event of adjournment, then no such meeting can be called for a period of 6 months from that date. And as said, the second notice which has been issued is improper. Improper. Lastly, he submits that on an application being filed with the Assistant Commissioner's office, a certified copy of form number 1 has been furnished, which indicates that the said certified copy contains the writing seal and signature of the Panchayat Development Officer, and I said the same being contrary to the decision of the Honorable of a coordinate bench of this court in Sangana
versus Biradar case.
Necessary action would have to be taken on that by quashing it. Shri V.S. Kalsurma, Learned Counsel, appearing for the state, would submit that insofar as the notice which had been issued on 21/12/2024, fixing the date of meeting as 7/1/2025, the same has not been acted upon. The meeting never took place. None of the Panchayat members came to the Panchayat office. They having been informed about the cancellation of the meeting. It is thereafter that on receipt of another requisition in form number 1 from the Gram Panchayat members on 24/12/2024, that the notice dated 3/1/25 was issued, fixing the date of meeting as 18/1/2025. He therefore submits that the meeting having not taken place, the question of adjourning a meeting and or the motion having not gone through would not arise. On the basis of the fresh requisition, a subsequent notice on 3/1/25 has been issued, which cannot be found fault with. As regards the certified copy, he submits that initially the Panchayat members had approached with form number 1 with the endorsement, with the writing, seal and signature of the PDO. The Assistant Commissioner, in view of the various directions which have been issued by this court from time to time in different matters, had called upon the panchayat members to furnish a requisition without any writing, seal or signature of the PDO. It is in furtherance thereof that the requisition subject matter of the above matter at annexure H and H1, which do not bear any writing, seal or signature of the PDO, were submitted. And acting on the same, the notice in form number 2 was issued on 3/1/2025. Since an earlier requisition had been submitted bearing the writing, seal and signature of the PDO, 2 separate files had been maintained. Explaining this, the affidavit of the Assistant Commissioner Koppal has been filed. On that basis, submit that there is nothing wrong in the notice which have been issued, which has been issued fixing the date of the meeting. Third, so and so peruse papers. The points that would arise for consideration in the present matter are: 1, whether when once a notice has been issued in form number 2 in pursuance of sub-rule 2 of rule 3, could the said notice be cancelled or withdrawn? 2, whether despite there being no power to cancel or withdraw a notice issued in form number 2, could the Assistant Commissioner be prevented from, could the Gram Panchayat members be prevented from submitting a fresh requisition in form number 1 in terms of sub-rule 1 of rule 3 of the rules of 1994? 3, whether a subsequent requisition in form number 1, which does not bear the writing, seal, signature of the PDO, can be considered for issuance of notice in form number 2, even though there is another requisition which had been submitted bearing the sign, seal and signature of the Panchayat Development Officer. 4, what order? Answer to point number 1. In the present matter, the facts are not in dispute inasmuch as there was a notice which had been issued on 21/12/2024 in form number 2 fixing the date of meeting as 7/1/2025. Before the said date, the endorsement
23.
on
23/12.
23/12/24 itself, the
24.
Assistant Commissioner had cancelled the meeting slated to take place on 7/1/2025, which was informed to the members of the Gram Panchayat. In reason,
It has not been it has not been informed. It is an official note that it's
First para, last 2 lines, 2-3 lines ಅಷ್ಟೇ.
Though an office order dated 23/12/24 has been passed, there are no particular reasons which are found in the said office order which would support the cancellation of the meeting to be held on 7/1/2025 and the recall of the notice dated 21/12/2024. The submission of Sri Anand Kohli, learned counsel for the petitioner, is also that the said order had not been communicated to the petitioners. A perusal of Rule 3, which relates to the procedure for holding the Rule 3 of the Rules of 94, which relates to the procedure to be followed while holding a meeting, does not provide for cancellation of a meeting scheduled to take place. In fact, in terms of Rule 5 of Order 3, there is a clear interdict that once a meeting has been convened for the purpose of considering a motion under sub-rule 2 of Rule 3, it shall not for any reason be adjourned. This interdict in sub-rule 5 of Rule 3, to my considered opinion, not only applies to a meeting already convened, but also as regards the meeting proposed to be convened. That is to say, a postponement or adjournment of the meeting after convening the meeting or even prior to the convening of the meeting is not permissible in terms of sub-rule 5 of Rule 3. Once a meeting has been convened under sub-rule 2 of Rule 3, the said meeting is required to go on since the rules do not provide for the said meeting to be adjourned or postponed. The submission of Sri Anand Polli, the further submission of Sri Anand Polli, learned counsel for the petitioner, is that there being no postponement or adjournment which can take place, the meeting not having been held in terms of sub-rule 6 of Rule 3, the notice would have been lapsed. Notice stood lapsed. Nearly 6 months yavadappa.
Shall not.
49 alva.
Yes, 49 one.
49.
And as per proviso 3 of subsection 1 of section 49, it should be held that the resolution has been negatived, and as such a similar motion cannot be moved for a period of 6 months from the date of the said decision. Insofar as the first submission is concerned, I have dealt with above and held that the Assistant Commissioner has no power to cancel or postpone the meeting once fixed. The Assistant Commissioner is only an executive officer and not an elected member of the Gram Panchayat. On account of any inaction or mistake on part of the Assistant Commissioner, the democratic rights of the elected representatives cannot be taken away. The submission made by relying on third proviso to subsection 1 of section 49, that due to the postponement stroke adjournment made by the Assistant Commissioner, the motion is deemed to have been negatived, cannot therefore be accepted, inasmuch as for the purpose of negativing the resolution, there is required to be a meeting held and a vote made thereon. It is only on a vote being made by the members of the Gram Panchayat and the motion not being carried by 2/3 majority, then could it be said to be negatived, attracting the rigor of third proviso to subsection 1 of section 49. In the absence of a meeting taking place, which would obviously mean that there is no vote which has taken place, it cannot be said that either the notice has lapsed in terms of subsection 6 of section 3, or that in view of third proviso to subsection 1 of section 49, no further resolution can be moved for a period of 6 months. Thus I answer point number 2 by holding. Point number 3. The submission of Sri Anand Polli, learned counsel for the petitioner, by relying on the decision in Sanganna Biradar, is that as per the certified copy of form number 1 which has been furnished, there is a writing, seal and signature of the PDO. Therefore, applying the rigor of Sanganna Biradar's case, the entire proceedings taken in pursuance thereto, including the notice dated 3/1/2025, fixing the date of the meeting as 18/1/25, is required to be quashed. Learned AG has submitted that though the first requisition was submitted with the seal, with the writing seal and signature of the PDO, the same was replaced by the requisition in form number 1 as produced by the petitioners themselves at Annex H and H1, which does not bear the writing seal and signature of the PDO. Thus, what has been acted upon being Annex H and H1 for the purpose of issuing the notices at Annex J and J1, the question of the earlier requisition bearing the writing seal and signature of the PDO would not make any difference. The purport of the decision of the coordinate bench of this court in Sangana Biradar was to ensure that there is no interference by the PDO in respect of any requisition submitted in Form 1 pursuant to Sub-Rule 1 of Rule 3 of the Rules of 94. In the present case, though a requisition had been initially submitted bearing the writing seal and signature of the PDO, when this aspect was brought to the members, notice of the members of the panchayat who had submitted the requisition notice in terms of Form 1, they have submitted a fresh requisition on the very same date without the writing seal and signature of the PDO. Thus, this requisition which has been submitted, not falling in the mischief of Sangana Biradar's case, and there being no other mischief which could be pointed out in relation thereto, the second requisition having been acted upon by the Assistant Commissioner, I am of the considered opinion that the requisition which has been acted upon by the Assistant Commissioner not having any writing seal signature of the PDO is proper and correct and would not come in the mischief of Sangana Biradar's case. Answer to point number 4. In view of my findings above, taking into consideration that during the pendency of the above matter, the date fixed for holding the meeting being 18/1/2025 has lapsed, I pass the following order. Writ petition has become infructuous insofar as prayer A and B are concerned by efflux of time on account of the interim order granted by this court, the meeting not having been held. Liberty is reserved to respond number 3 to 19, 2 to 19 to submit a fresh requisition, which requisition shall be considered by the Assistant Commissioner without reference to, which shall be treated as a fresh requisition by the Assistant Commissioner. And necessary Form 2 be issued by the Assistant Commissioner within the time frame prescribed. The Principal Secretary Revenue Department is directed to issue necessary instructions to all the Assistant Commissioner coming within his jurisdiction.
That is already done.
ಏನಂತ?
Government circular issue ಮಾಡಿದೆ.
ಏನಂತ?
ಅಲ್ಲ, to all the assistant commissioner and also to
ಏನಂತಪ್ಪ?
ಅದೇ with regarding to the insisting of the PDO and with regarding to the
ಒಂದು ಮಿಸ್ಟೇಕ್ ಮಾಡಿದಾರಲ್ಲ.
ಅಲ್ಲ ಅದು withdrawing.
Necessary instruction to all the Assistant Commissioner coming under his jurisdiction not to withdraw any notice under Form 2 and or postpone or cancel a meeting convened by issuance of Form 2. And if any such action is taken in future, by any particular assistant commissioner to take disciplinary action
Please.
against them, against such assistant commissioner.
Publish.
120, Suresh Kini.
May it please your lordships. My lord, my first submission is, my lord, it is squarely covered by my lord's judgment passed in the earlier phase, my lord, regarding the NH, which, my lord, clearly holds that the 3A notification having not been issued properly in accordance with the directions issued by the Honorable Supreme Court in Baranagore and, my lord, lordship's judgment, which digests most of the cases on the point, this section, my lord, 3A notification should go. And secondly, my lord, a submission was made on the last occasion that no construction work is done. May I beg to produce, my lord, a memo in which they acknowledge that work is being carried out. They acknowledge in writing. May I, my lord?
Page.
Sorry, my lord.
Memo was filed on 21st, my lords, because after hearing on the last occasion.
21st of
February.
This 15/2/2025, my lord, in response to my letter. Lordships have it, my lord.
What are you wanting us to see, Mr. Prabhu?
First submission is, my lord, it is squarely covered. That on that count alone, my lord, it may be disposed of.
So apart from, if we don't agree with your submission, you have no other submission.
I have 3 other submissions.
And then please make your submission and close it completely.
I'm making.
Don't do this.
I'm so sorry. I'm so sorry. One second thing is, my lord, that on the last occasion they said no construction work is being undertaken, and my lord, that was taken on record. May I persuade your lordships to see their letter of 15/2/2025, wherein, my lord, they say, may I read it with your lordships, my lord, the second paragraph of that letter.
Where is that letter?
It is, my lord, produced by way of a memo. It is readily available, my lord, with my colleagues as well.
The
It is
memo
filed
date
before you.
ಏನಿದೆ ಅಂತ page number ಹೇಳಿ.
The only one page memo, my
letter
lord.
ನಿಮ್ಮ ಮುಂದೆ ಇಟ್ಕೊಂಡು ಅದನ್ನ ನೋಡಿದ್ರೆ.
I'm sorry, my lord, it was filed. My learned friend says, my colleague there says, my lord, it was filed. May I, my lord? One page letter.
Submissions like this.
I'm so sorry, my lord.
Yes, 15/2.
Yes, my lord. Accordingly, the second paragraph, my lord, I am reading with your lordships. Accordingly, the construction work is being carried out only within the existing so and so stretches, and department assured that there is no activity will be taken so and so. Now they say the construction work is going on. According to them, they are carrying out in ROW. Whatever is, my lord, the entire stretch of land is subject matter of Annexure L. That is, my lord, the 3D notification. Third submission is, my lord, that may I persuade your lordships to see page 188 of my writ petition, which contains, my lord, the description of the land in 3D notification.
188.
Yes, my lord.
Yes.
That is, my lord, the part of the 3D notification annexure.
Serial number?
One itself, my lord, lordships may see government land. Now what they are saying is, now government land al kelsa marta idivi ant heli. That is, my lord, the submission made on the last occasion. All these, my lord, are government lands only. Serial number 1, serial number 5, serial number 6, all are government lands only. And, my lord, they belong to HDMC. As per the National Highways Act, my specific submission is, after 3D notification only, it shall vest with the central government and they can carry out work or survey work, etc. Now,
who are you?
I am, my lord, a temple and landowner. Other two are the landowners.
You are not the HDMC.
I am not HDMC, my lord. I am saying.
You are not objecting on behalf. You are objecting on your own
I am
behalf.
not objecting. I am not objecting. I am
Why
saying.
referring to HDMC?
No, I am saying, my lord, it's a government land, no doubt. But the vesting of the land happens pursuant to 3D.
That is the arrangement between them and HDMC. If HDMC gives, what's your problem? You cannot take up that contention on their behalf.
I leave it at that. I leave it at that. I am only saying, Lord, the 3A notification issued in violation of the orders passed by my lords. At my lord, the
HDMC is very happy to give land to everybody. They give it to PWD, they give it to NHA, they give it to everybody to make the roads. And then they put road made by HDMC.
Yes, that I go down, Lord, whatever I. Now, I'm only submitting, my lord. This came up because lordships noticed on the last occasion that in the PIL, that they in the division bench, my lord, they had said that 40% of the work is over. And without a 3D notification, that could not have been undertaken, is what my lords observed.
Yaudu?
Idರಲ್ಲಿ, your lordships may see the order, my lord, division bench
Page
order.
page 235.
232.
235, my lord, sir.
238, my lord.
235.
238, I'm sorry. 238, I'm sorry. Lordships may see the percentage of work they have, my lord, undertaken. This is also noted in the last date, my lord, last date's interim order.
Yes.
That table, my lord, if your lordships may see name of the work, so and so, then percentage of work. Tender cost, financial progress, then physical progress. This order is dated, lordships noted, my lord, on the last occasion. This order is dated much prior to the 3D notification issued. So your lordships noted that, my lord, the division bench was misled to believe that, my lord, as on 21st September 2023, this much of work was undertaken. So my respectful submission is, my lord, that without a 3D notification in place, this work could not have been undertaken. Now, my lord, the projection is that we have carried about 40% of the work. Your new writ petition hakidiri, the remaining portion of the work is pending, and we are carrying out work in the government land, and it should be allowed to complete. That is the submission made before your lordship.
3D is not published, it's still a
No.
3A.
3D is published, my lord. That is
Now it
published,
is published.
now. Your lordship
Now
will see Annexure L. In 2024 June, my lord, that is published. Your lordships will get the date at 164. I'm sorry.
That is 12th November.
November, sorry, November, my lord, sorry.
24th.
12th November is when the 3D is issued.
Yes.
And, my lord, there is a submission is made before the PIL court in division bench. As on September 2023, 40% of the work is done already, which your lordship saw at 238. So this could not have been done. Those are, my lord, some of the aspects I would like to bring to your lordship's notice. Without prejudice to all this, my lord, I am saying the issues will pale into oblivion once, my lord, lordships have declared the law that 3A notification issued without following the due process should go.
Yes.
Kindly see, my lord, the 3A notification at Annexure D.
Page.
And, sorry, my lord, the Annexure D, page, sorry.
Annexure E.
Annexure E, I'm so sorry.
Now here the page number, Annexure 3P.
63, my lord, 63,
Page
I'm so
one.
sorry. That is initial notification, my lord, I'm so sorry.
Where is the relevant entry as regards your property?
Yes, that is, my lord. Your lordships will see, my lord, in the annex.
131. Page 1.
Beg ahead, Mr. Prabhu. Everybody is waiting.
I'm so sorry, my lord. 131.
131.
Yes.
Serial number.
42, my lord. 42, my lord, on 131. 2961, your lordship.
61. Non-agriculture 77.26.
That's all, my lord, it says.
Yes.
So this, my lord, entire notification your lordships will see. All our properties are described in this fashion.
Yes. Anything else?
No, this squarely covers, my lord, is my submission. Since the 3A notification itself is issued in violation of
NHA. Yaro.
My lord, it is a state wing of the NHA doing this, my lord. The engineers posted there is the state officer.
Not the national.
Not
authority.
national. Why the?
Then you are using 3A.
Please, I'll make two submissions. My lord, already there is an existing road. And it is part of the national highway. The state has undertaken that is elevated corridor, my lord. So the work has started. Subsequently, my lord, the officer felt that, my lord, there not be any encroachment at after the construction of the elevator. There may be some overlapping in the ground area of the petitioner and some other persons. Therefore, these notifications have issued. Regarding the 40% of the work is concerned, my lord, that is in the work which is already in the existing roads. The existing property which is
elevated expressway on the existing
road la ಮಾಡ್ತಿದ್ದೀವಿ. So there may be in future, my lord, we are not using the land of the petitioner for any other purpose except for widening of the.
Is it elevated expressway, Mr. Prabhu?
Yes, that is not in dispute. But my land is, my lord, being acquired.
We'll come to your land later, but your whole argument on 42%, which you are so vociferous about,
yes,
that it could not have been done, now falls by the wayside.
No, my lord. No. Your lordships may see the elevated, my lord, the overbridge is being constructed. There is no dispute about that. Even on my land, the entire thing stretch, my lord, is an overbridge, the bridge only. It's an elevated corridor only. No dispute. But
Then why are you making, why did you make so
land
much
acquire
of this?
my land is
On
being acquired.
42% ಖರ್ಚು ಮಾಡಿದ್ದಾರೆ, they could not have done, they have done it
That your
without
lordship will
ಅಂತ
see.
ಎಲ್ಲ ಮಾಡಿದ್ರಿ.
ಅಲ್ಲ ಅದನ್ನ ಆ ಎಲಿವೇಟೆಡ್ ಗೆನೆ ಇವ್ರು ಎಕ್ಸ್ಟ್ರಾ ಲ್ಯಾಂಡ್ ತಗೊಳ್ಳಿ ಫಾರ್ ವೈಡನಿಂಗ್ ದೇ ಆರ್ ಟೇಕಿಂಗ್ ಲ್ಯಾಂಡ್ ದ ಲ್ಯಾಂಡ್ ಇಸ್ ಮೇ ನಾಟ್ ಬಿ
They will take it, but they have done the construction of the columns and everything can be done without that.
the road is also, my lord, being acquired. The markings are, my lord, on the
Will
road
be
only,
acquired,
not on the elevated corridor.
Your prejudicial argument that without acquiring they are doing it on your property is what you made.
I am saying, my lord,
Submission, that's a false, please don't make
without
false submission.
no, my lord, my lord, the 3D notification was not issued when this work was undertaken, and this work, the land was not acquired. The work is also on
We'll
the
deal
road.
with the submission, Mr. Prabhu, if you persist. Yes.
So therefore, my lord, we have executed the work in the government land. And my instructions are that, my
So
lord,
this 42% is for the columns.
in the
not-
government land, madam. Yes, madam, government land. In the Channama circle, madam, in Hubli, madam, heart of the city, more conjunction of the vehicles and all those things, madam. So that is why this elevated corridor was been intended, madam.
Yes.
And the properties, even my instructions are that not even 1% of the, on the land of the petitioner, work is going to be done at the lower. Since it is an elevated corridor, maybe overlapping in the properties of the petitioner. So therefore, my lord, to avoid all these complications, subsequently the government has intended for the acquire of the land.
ಇನ್ನ ಒಂದು 3A notification issue ಮಾಡಿ exact
Work maybe in respect of the except the petitioner, my lord, no one has been.
ಅದಕ್ಕೆ rest you continue.
Yes, in respect of the petitioner, will do it.
ಒಂದು 3A 3D ಕೊಡಿ.
May I submit this, my lord? May I submit this, my lord?
Yes.
May I submit this, my lord? What is the government portion of the land is evident from 3D notification itself, page 188.
You are concerned with only 2961, Ms. Prabhu.
And also the other properties, my lord, of the other petitioners.
Which are the other petitioners?
Lordships may see, my lord, the area of petitioners and the survey numbers are also described.
Yes, give us the numbers, please.
Yes, they are there, my lord. I am sorry. Lordships may see, my lord, the survey numbers are described.
Where?
In the prayer column, my lord. I am so sorry.
You get ready and come another day.
No, my lord. I will show the survey numbers. They are there, my lord, at page 25 itself. Page 25, my lord.
You can wait, please.
2990,
We may be permitted to do the work in the others land, except petitioner, my lord.
2960.
ಅಲ್ಲ ನಾವು last occasion some miscommunication, we are not working ಅಂತ ಬಂದಿದೆ ಅಲ್ಲಿ ಅದು we are not working in the petitioner land, we are not working at the petitioner land.
Lordships may see, my lord, the work is on the entire 3D notification was stayed, and lordships may see, my lord, page 25 I have given the survey numbers also. Petitioner wise survey numbers are also given. 2889, 2990, 2991, 2960, 2961 are all mentioned. Page 25, my lord.
Mr. Prabhu, we are getting a little losing our patience with this kind of submission.
No, I'm sorry, my lord. The survey numbers are mentioned.
ನೀವು ಓದ್ತಾನೆ ಇದ್ದೀರಾ, ನಮ್ಗೆ ಯಾವ ಪ್ಯಾರ ಅಂತಾನೂ ಹೇಳ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲ prayer column, my lord, page 25, my lord. I'm so sorry. Page 25, my lord. The survey numbers are mentioned.
Survey numbers elli?
Page 25, my lord. The survey number 1, immobile first
2989.
They belong to, my lord, first
2991, 296061, 2995.
second petition. Yes. All three.
3 plus 3, 6.
Correct.
Now show us what are the serial numbers in 3A notification.
Yes.
2960 is not acquired. It's only 2961.
Yes.
No, that is also, my lord.
Where's
3D
296?
notification may kindly be seen, my lord. I am so sorry.
Page.
Ultimate. Annexure L, my lord, page number 164 onwards, and my lord, particular survey numbers also I have marked, my lord. My one friend is there with the page number details. My lord, 193, my lord, is one survey number that your lordships will get. 2961.
ಅದೇನಪ್ಪ ಹೇಳಿ ಬರೀ 2961, 2960 ಇಲ್ಲ. There's no acquisition.
It is there.
Where's 2960?
Yes.
Page. It seems to be deliberate, all these things.
No, my lord. I'm so sorry. Kindly see, my lord. No, my lord.
Schedule ಅಲ್ಲಿ ಹೇಳ್ತೀರಾ 44% mislead ಮಾಡ್ತೀರಾ ಇದು ಹಿಂಗೆ
I
ಮಾಡ್ತೀರಾ
am not, no, my lord, it was noted by your lordships that, my lord, 40% of the work is being
It is
undertaken.
noted on
It is
account
not
of your
government land, my lord, I'm
your
sorry.
submission. Now Mr.
It is
Gangadhar
my
has given the
submission, my lord.
explanation.
It is not
ಆಯ್ತು
government land.
2989 ಹೇಳಿ.
Your lordships
Yes,
may see, my lord.
2989.
Yes, my lord.
131.
2989, 2990, 2991.
My lord, 52, serial number 52, 194, my lord.
2995.
Yes,
Yes.
it is on page 194.
So it is 0.00222859 square meters.
That is what, my lord, is being projected.
0.022859 square
ಅದ್ರ
meter.
ಕೆಳಗಡೆನೂ ಒಂದಿದೆ, ಅದ್ರ ಕೆಳಗಡೆನೂ ಇದೆ ಸರ್, ಅದ್ರ ಕೆಳಗಡೆ
ಒಂದಡಿ ಒಂದೇ ಒಂದಡಿ.
That is what, my lord, they have projected. But your lordships may note, my lord, at the time of interim order, lordships noted the one anomaly, my lord, very clearly. 140 may, page 140 may kindly be seen, my lord. On RTI, they say that they are not acquiring 2961. Page 140 may kindly be seen, my lord. ಮೇಲ್ಕಾಣಿಸಿದ 140 may kindly be seen. ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನೀವು ಕೇಳಿದ ಮಾಹಿತಿ ಪ್ರಕಾರ 2960 ಮಾತ್ರ ಹೆದ್ದಾರಿಗೆ ಭೂಸ್ವಾಧೀನಗೊಳಿಸುತ್ತದೆ, 2960 ಭೂಸ್ವಾಧೀನಗೊಳಿಸುವುದಿಲ್ಲ. But as against that, in 3D, my lord, they are acquiring this land. Kindly see page 193, my lord.
Yes.
Page 193, my lord.
Another 3A for this.
No, my lord.
3D for this. That's all.
Allah, your lordships may see, my lord, that
We are allowing your petition.
Yes, grateful.
You don't want it to be allowed.
Grateful, grateful.
Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the lands of the petitioner are sought to be made use of for the purpose of establishing an elevated expressway without the petitioners being made aware of the extent and the boundaries of the land proposed to be acquired, inasmuch as in the notification issued under Section 3A of the National Highway Authorities of India Act, the properties of the petitioner are found at CL number 42, 54, 55, 56, 55, 56, 57, and 59, except giving a reference to the square meter of the land proposed, square meters and hectares proposed to be acquired. There are no details as regard the boundaries and the identification of the land mentioned in the 3A notification. Even in the 3D notification issued on 12th November 2024 at Annex L, the properties of the petitioner are found mentioned at CL number 39, 52, 53, 54, and 56. And this time, only the extent of land in hectares has been mentioned. And as such, the petitioners could not reply to the acquisition notification expressing any of their objections. On that basis, he submits that the writ petition is required. Additionally, he submits that the NHA has misled this court when orders were passed in WP number 4352 of 2022 on 21st September 2023, inasmuch as it was contended that 43.55% of physical progress had been made as on 29/2023, when by that time the 3D notification had not been issued. The 3D notification had been issued on 12/11/2024, There's a submission of Sri Sridhar Prabhu, learned counsel for the petitioner, is that the respondents could not have carried out any work until the 3D notification was issued, and the reference made of 43.55% of work being done is completely misconceived and a mischievous statement to mislead this court. Taking into account the said submission, this court, by its order dated 17/2/2025, had called upon Sri Mrutyunjay Alikeri, learned counsel appearing for the SLAO, and the additional government advocate to obtain instruction, make their submission as to on what basis the percentage details have been provided to this, were provided to this court. Today, Sri Gangadhar, learned additional advocate general, would submit that the submission made by the counsel for the petitioner is as if to indicate that it's a new road being formed. What work is being undertaken is a elevated
Corridor.
elevated corridor over the existing road, which requires columns to be built and the
Construction on the
beams. Beam.
Columns and beams.
I'll kill your beams.
Columns and girders.
Columns to be built on which the girders would be placed. The works being carried out, what is the extent? Yes, kilometer.
In page 235 on 3 different highways, between which extent it has been mentioned in the first paragraph itself. 235, one in existing kilometer 135.65 to 136.450. Then NS
The works
63.
being carried out over several kilometers of existing roads. The amount of 42% provided by the authorities was as regards the works, 43.55% was as regards the works carried out on the existing roads, and no works had been carried out before the 3D notification. Apart therefrom, he submit that some works have been carried out in the government land, as regards which there is no particular private, no objection by anyone person which can be raised. As regards the details not being available in the section 3A and 3D notification, NIM submission and order. He submits that the details are sufficient enough for the petitioner to have considered the same and submitted a reply. The fact that the petitioner has filed the above petition would indicate that the petitioner is completely aware of the extent of acquisition and the location of the acquisition. Heard so and so peruse papers. A perusal of the section 3A notification indicates that insofar as CTS number 2961, an extent of 77.266 square meters is proposed to be acquired. In respect of 2989, 25.145, 2990, 69.481, 2991, 41.651, and 2995, an extent of 124.632 square meters. What objection will you submit for this, Mr. Prabhu? What details do you want to know in this?
No, my lord. Details matra alla.
What boundaries do you want of this extent?
No, my lord, the other contentions in the writ petition, I of course, my lord, did not present it before your lordships. We are even saying, my lord, the Land Acquisition Act itself is, my lord, applicable in view of section 2. All those objections, my lord, we'll raise
We
before
asked
them.
you whatever argument you want to advance, please advance. You have restricted it to 3, we are dealing with 3. What boundaries do you want for this?
First of all, my lord, as far as the first petitioner is concerned, there are 2 markings. They are not sure, my lord, what is the exact extent that is being acquired.
To market for you, that's all.
And secondly, my lord, no, my lord, I'm so sorry. Second is, my lord, as regards the second petitioner is concerned, his name itself does not figure. I am a permanent lessee for 99 years. And, my lord, my erstwhile owner's name, who is no longer in Raitwari system, my lord, the permanent lessees were the owners.
Give your objections, they'll consider it.
I will file the objections, my lord. Let them, my lord, I will
You
file
should
all
have
the
filed it by
objections.
now.
No, that issue is, my lord, raised in the writ petition itself. They are aware, my lord. I will file it, my lord, in detail, because this extent, my name itself is not there in 3D, my lord, as far as second petitioner is concerned.
So the Sridhar Prabhu, learned counsel for the petitioner, relies upon a decision of this court in, what is this one?
Yes.
Party's name?
Yes, my lord. That is, my lord.
Dated 22nd January 2025 in
Yes.
WP number 10061 of 2024 and other connected matters,
Yes.
to contend that it was
Shamrao.
required for the NHAI to have clearly and categorically provided the boundaries and the extent of the land proposed to be acquired. And as such, he submit that the same not having been provided, the notification under section 3A, as also the notification under section 3D, suffer from legal infirmities. The judgment in WP number, in Shamrao's case, was also delivered by this court and was so delivered on the basis of the contentions raised in that matter, that large extent of land was being acquired for establishment of a greenfield ring road in Belgavi, and that the landowners did not know the extent of land proposed to be acquired in their respective land. The present matter is not a greenfield project, but is a elevated corridor being built on the existing road.
But there is land
And
acquisition,
as
my lord.
per 3A notification, the extents which are proposed to be acquired of the petitioner's property range from 25 square meters to 124 square meters. This being only on the edge of the property,
Lord, I'm sorry. May I make one submission, Lord?
edge of the existing road, where the elevated corridor is proposed to be built. In my considered opinion, the decision in Shamrao's case would not be applicable to the present matter, since it would not be capable of exact boundaries and the width and length to be provided. The approximate extent of land required, as indicated in notification, in my considered opinion, would be sufficient.
Lord,
However, there is some substance in the submission made by Sridhar Prabhu, in as much as the area proposed to be acquired needs to be identified. This grievance can be redressed by directing the SLO to clearly mark out the extent of land in the land of the petitioners which are proposed to be acquired, so as to enable the petitioner to submit any further objections, if any, as regards any special circumstances relating to that land, that portion of the land, full stop. Insofar as the contention that the NHAI has carried out construction over to an extent of 45%, 43.55%, taken on record by the Honorable Division Bench of this court in this order dated 21st September 23 in WP number 4352 of 2022 is concerned. Though the submission of Sri Sridhar Prabhu at first blush appeared to be attractive to point out defaults committed by the authorities, in view of the submission now made by the learned Additional Advocate General, that the project is for establishment of an elevated corridor, and it's only portions of the land which are proposed to be acquired, juxtaposed with the notification themselves, which would indicate that it is only small extents of land which are proposed to be acquired on the periphery of the existing road. In fact, the total extent proposed to be acquired under the 3A notification is being provided only in hectares to be 1.10955.05 hectares. And under 3D notification has been provided to be 1.024315 hectares. The road being sought to be established over several kilometers, the elevated corridors being proposed to be established over several kilometers. The proposed extent of acquisition being just about 1 hectare makes the entire extent to pale into insignificance, taking the entire road which is being put up.
Yes.
Thus, the
Lord, one
judicial
submission.
arguments, please don't interrupt.
Sorry.
That's a prejudicial argument which was sought to be addressed, stating that the NHA has carried out works even before the 3D notification, and therefore NHA has violated all provisions of law and commenced work before acquisition, is rendered completely baseless, inasmuch as work has, even if large amount of work had been done on the existing road, even if a little amount of work is done on the existing road for putting up of columns and girders, the same would be well within 44% as indicated. Therefore, I do not at this stage find any kind of misleading submission made by the respondent authorities. But prejudicial arguments are sought to be advanced by the petitioner, which cannot be countenanced. In that view of the matter, I am the considered opinion that there are no grounds which have been made out to interfere in the matter and grant the release which have been sought for. Hence, I pass the following order. Writ petition is dismissed. Respondent number
Lord.
3, SLO, and respondent number 7, Assistant Director of Land Records, are directed to mark out the area of the land of the petitioners which are going to be utilized in terms of the acquisition notification in CTS number 2960, 2961, 2989, 2990, 2991 and 2995 within 1 week from today, that is on or before 4th March. The petitioner is granted a week's time thereafter to file any additional statement of objections in respect of the marked area alone, to indicate any special circumstances as to why that land is not required to be acquired, which shall be submitted on or before 11th March to the SLO for consideration and passing of necessary orders.
One prayer, my lord. Page 140 RTI information nalli, lordships had noted the survey number which was not, my lord, said to be acquired is acquired under page 193 3D notification, my lord. Page 140.
This is by the state government, not by the central government. So
this, my
they will
lord,
give-
is issued by the SLA only, my lord.
A notification has been issued.
In 3A, my lord.
They'll mark it. They'll
They
mark
say,
it.
my lord, the survey number 2961 was not sought to be acquired, but that is acquired under 3D, my lord.
It probably is a typographic error, 2960,
No, my lord.
2961. New notification ನೋಡಿ clear ಆಗಿದೆ.
ಅಲ್ಲ 2961 ನೋಡಿ ಸ್ವಾಮಿ 2961 is, my lord, not acquired ಅಂತ ಹೇಳಿ acquire ಮಾಡಿದ್ದಾರೆ.
Only we are not imposing cost because you are a land loser. But this kind of arguments would have required this court to impose exemplary cost. Don't come in the way of development. If there is some reasonable cause, we'll interfere. Don't make a mountain of molehill to the whole, this one project will come to a standstill, which is good for people in Hubli Dharwad. Don't do these kind of things.
121, Prakash Jawalkar.
Lordship, on the last occasion, Lordship asked me to verify whether the amount has been credited to the account of the petitioner.
ಯಾವ್ದಪ್ಪ ಇದು? Yes.
Delayed payment ಅಂತ ಹೇಳ್ಬಿಟ್ಟು reject ಮಾಡಿರೋದು. In fact, Lordship, here, what has happened in the year 2017 to 2022, order was made to the petitioner to deposit the amount of the development charges and all within 90 days, as per the annexure D, page number 17. But here, Lordship, after lapse of 2 years,
Is a conversion.
please, after lapse of more than 2 years,
Refund
they have
ಮಾಡಿದ್ದಾರೆ.
credited, what has happened, Lordship?
Have you given back the money?
ಇಲ್ಲ ಏನಾಗಿದೆ ನಾವು ಇದು ಕಳಿಸಿದ್ದೇವೆ ಚೆಕ್ ಕಳಿಸಿದ್ದೇವೆ immediately but check was received by him but they are not encashed it just I'll furnish it on 21/12/2024 we have sent check lordship by post 24/12/2024 they have received it they are not encashed it.
Where are the documents?
Just,
ಅಷ್ಟೊಂದು
I'm sorry I'll produce along with the ಇದು
ಇಲ್ಲೇ ಮಾಡಬೇಡಿ. Where is your letter?
letter I'll produce along with memo.
ಅವ್ರು ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು?
30 lakhs.
So you returned 29,95,000.
Deducting charges. And even Lordship, my only respectful submission that Lordship, because the committee has to take a decision regarding all the, because after 2.5 years Lordship, there are so many changes, valuation in the land and everything. If they make fresh application Lordship, the committee has to decide. I'm not the only person.
We'll ask them to reconsider. If there are any compliances to be made, you carry out the compliance. ದುಡ್ಡು ಹೆಂಗೋ ಅವ್ರ ಹತ್ರನೇ ಇದೆ. They had sent it to you, but you are not encashed it, so it is with them. The difference also they will calculate and tell you. That's what you said. If there are any other compliances to be made, also you'll have to make the compliance.
Committee has to decide.
We'll ask them to consider your old application, but if there are some compliances to be made, if there may be some changes which would require some compliance, you'll have to carry out the compliances. Petitioner is before this court seeking for the following reliefs. The petitioner is the owner of the property bearing block number 28/2, measuring 13 acres, 26 guntas of Sattur village, Taluk and district Dharwad. The petitioner had made an application for conversion of the said land from agriculture to non-agriculture purposes. And for formation, and subsequently for formation of a layout. The Deputy Commissioner Dharwad had issued NOC. The HDUDA, Hubli Dharwad Urban Development Authority, had issued NOC. So also were NOCs received from the other departments, which were submitted along with the application. Apart therefrom, the petitioner is also stated to have paid a sum of rupees. A demand has been raised
On 17.
While order dated
17 to 2022.
to 2022 at annexure D,
page
by a sum of rupees 30,00,370. The petitioner paid the said amount on 15/3/2024.
After lapse of 2 years.
Consequently, The petitioner, having followed up, had been informed
A 90 days time was fixed to pay the amount, but they are not paid, Lordship.
We are not saying how the dates are working, Mr. Javalkar, you know it better. The petitioner came to know on 27/3/2024, on being served with a notice that the approval had been cancelled on account of late payment. And that late payment. It is in that background that the petitioner is before this court seeking for the opposite relief. The submission of Shri Javalkar, learned counsel for the petitioner, is that the petitioner is willing to make payment of any differential amount, if any, in respect of the said conversion and layout plans action. His further submission is that the petitioner, having followed up and obtained all the permissions, now cannot be relegated to file a fresh application only because there being certain delay in payment of monies. If there are any further compliances and or NOCs which are required to be obtained by the petitioner would apply for and furnish the same to the respondents. Shri V.M. Shilwant, V.M. Shilwant, learned counsel for the respondent, submits that if the petitioners were to comply with all the present requirements and make payment of the due amounts as calculated and furnished by the respondents, the respondent will once again consider the application filed by the petitioner
By holding meeting.
in accordance with law and pass necessary orders. The same would answer the grievance of the petitioner. In that view of the matter, I pass the following order. Writ petition is allowed. A certiorari is issued. The order dated 14/3/24 bearing so and so, passed by the Deputy Commissioner at Annexure H, is quashed. The matter is remitted to the Hubli Dharwad Urban Development Authority for fresh consideration in terms of the observation made here. Within a period of 30 days, 95, within a period of 30 days from the date of receipt of
30 better, 2 months. Can your Lordship,
95 only, it is 30 days now. 15 days for opinion, 15 days for processing.
within that, they need to comply all the requirements.
122, E.N. Asmane.
Lord, in this, to file compliance report, my lord, I 6 weeks time. The last occasion, the lordship was pleased to grant me 2 days time pursuant to the lordship's directions.
38A.
Yes, another week's time.
Week time on a Friday na illa?
ಇಲ್ಲ ನಾ ಫೈನಲ್ಲೇ ಮಾಡ್ತಾ ಇದ್ದೇವೆಲ್ಲ.
The AGA seeks for is granted 3 weeks time to report compliance. Relist on 12th March.
Please. ಅದಲ್ರಿ.
123, H.M. Darigon.
Lord, these may Lord, with regarding to the no confidence motion. Lord, serial number 61 and the present case proceedings have been initiated and PDO have been suspended.
123,
So, my lord,
counsel for the learned AGA submits that necessary instructions have been issued by the Principal Secretary Rural Development Department to all the Rural Development and Panchayat Department to all the PDOs.
Yes.
And by the Principal Secretary Revenue Department to all the Assistant Commissioners. As also necessary action has been initiated against the errant PDOs.
Yes.
His submission is taken on record. The petition stands closed.
Please, serial number 61 also same.
61, same order.
Please.
124, M. Shivprakash.
That's it. Before commencing with the matter, respondent number 11 is the Pollution Control Board. We don't appear for Pollution Control Board. I think the petitioners are confused and my name is being shown. We appear for the Slum Board.
Slum Board.
We appear for Slum Board and not Pollution Control Board.
The Pollution Control Board yaru? Gurudev.
No. Slum Board.
ಯಾರು ಹೇಳಿದ್ರಿ ಅದಕ್ಕೆ ಹೇಳಿದ್ರಿ ಅವ್ರು ಇಲ್ಲ ಅಂತ. ನೀವು ಅಪೇರ್ ಆಗ್ತೀರಾ?
I think they have started achievement also.
P for and
Is there?
yes. Yes.
Madam, I appeal on behalf of respondent number 10.
My lord, may I make a question, my lord? Is it audible, my lord?
Yes.
Yes, my lord. My lord, on the last occasion when the writ petitions filed, the sample court, after reading the matter, the notices are issued. Now, except R10, that's a private entrepreneur company has appeared. Now all other respondents now they are put into appearance, and the government is the main party here. They have not taken their stand, or they have not filed their statement till date.
First you tell us your stand, Mr. Prakash. 71 opposition, you are challenging in 2025.
One by one I am going, my lord. Now, so far as this writ petition is concerned, it's of course it's a question of the year 1971. 71. On the last date of hearing, my humble request before this humble court, as well as information given to this respondent is, the learned senior counsel Shri Padmanabh Male has been engaged in this matter, and he is bedridden. Now he has been discharged from the hospital. He is taking rest. That's why on the last occasion I sought for little time. This humble court, after hearing the matter, after hearing my submission, granted time. Then the learned
No, and that was not the submission made. You did not make that submission. Your colleague made the submission.
My colleague made.
Please don't do this.
My colleague made.
What was mentioned was your colleague had informed everybody. Everybody has consented for an adjournment. It may be adjourned by 2 weeks.
My lord, to everybody it has been informed on the day, and on the same day with the telephonic number.
Please listen to us.
My lord.
Mr. Raghavan and all the counsels have been waiting from morning to evening. And or yourself did not have courtesy to inform a counsel?
No, it's not correct.
And you are making this kind of a submission now?
No, it's not correct. It's unfair. My lord, the learned counsel who appeared for this 10th respondent is Mr. 10th respondent. He has been informed over telephone. His telephone number is also noted in a memo. I have stated, my lord. And the learned counsel who is on record, it is his duty to inform to the learned senior counsel, Shri Raghavan.
If you were to insist, we'll go further. We'll direct you to file affidavit. We'll direct everybody to file an affidavit, and we'll direct the Airtel or whoever to give us the call records.
Please, my lord, please, because I have noted the number.
We have no problem in doing it.
My lord, I have also noted number and also timings. I have informed to all the learned advocates, and I have given the instruction that the senior advocate is not keeping well. That's why we are seeking time. That's the thing we have informed.
File an affidavit of, file your affidavit.
I'll file it, my lord. This is one submission.
You also file it, Mr. Gowder, because he's saying that you have received the call. Both of you file it.
And this is, I'll file affidavit, number one. Number two, my lord. Number two, now as it is, my lord has said that it is 1972 acquisitions. Acquisition is under the Land Acquisition Act of 1894. Land Acquisition Act 1894 invoked to acquire this vast extent of land for public purpose under section 3. May I kindly take my lord to the second petition, 10,367 of 2025. It is at page number is 60, my lord.
60.
60, my lord.
Yes.
In 60 Annex A is the Gazette notification which I placed as Annex, my lord, wherein this is number RD 33 acquisition 71 dated 20th February 1971. The first line read
60 CL number 75 ಇಂದ ಶುರು ಆಗುತ್ತೆ.
ಇದು ಪ್ರಿಯಂಬಲ್ ಅಲ್ಲಿ ನಾನು 16 ಅಲ್ಲಿ ಮೊದಲನೇ ಪ್ರಿಯಂಬಲ್ ಇದೆಲ್ಲಾನು ಬಿಟ್ ಮಾಡಿದ್ದಾರೆ, ಒಂದೊಂದು ಕಡೆ ಮಾಡಿದ್ದಾರೆ, ಎಲ್ಲಾನು ಬೇರೆ ಮಾಡಿದ್ದಾರೆ. ಮೊದಲನೇದು ನಾನು ಫಸ್ಟ್
ನಿಮ್ಮ ಪೇಜ್ ನಂಬರ್ ನೀವು ಕೊಡಿ, ಆಮೇಲೆ ಅವ್ರು ನೋಡೋಣ.
ಹೌದು, ನನ್ನ ಪೇಜ್ ನಂಬರು 10,367 of 2025 ನಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ is 60.
367
of 60.
ಹಾ, yes.
My lord, got it, my lord? Whereas, whereas, married, my lord?
Yes.
Whereas it appears to be government of Mysore that the lands specified in the schedule hereto are likely to be needed for public purpose. I insist on this public purpose, my lord, to wit for the location of Hosapet steel plant at Toranagal village, and also the Vijayanagara steel plant. It also called the Vijayanagara steel plant.
Yes.
Notice to that effect is hereby given to all of whom may consent to, according to the provisions of subsection 1 of section 4 of the Land Acquisition Act 1894, as amended by Mysore Act 17 of Government of Mysore, hereby authorize the special land acquisition officer, Hosapet Steel Plant, Bellary, and his staff and workmen to exercise the power conferred by section 4 of the Act. Under section 3E of the same act, the government of
ಇವತ್ತು ನೋಟಿಫಿಕೇಶನ್ ಫುಲ್ ಓದಬೇಕು ಅಂತಿದ್ದೀರಾ ನೀವು?
ಇಲ್ಲ ಇಷ್ಟು ಮಾತ್ರ ಓದಿಬಿಟ್ಟು, ಯಾಕಂದ್ರೆ ಅದು ಪಬ್ಲಿಕ್ ಪರ್ಪಸ್ ಅನ್ನೋದು ಯಾಕೆ
ಪಬ್ಲಿಕ್ ಪರ್ಪಸ್ ಆಯ್ತು, ಓದಿ ಆಯ್ತು. ದಿಸ್ ಇಸ್ 71, ಯು ಆರ್ ಸೇಯಿಂಗ್ ಇನ್ 24. ಅದು ಏನು ಅಂತ ಹೇಳಿದ್ರೆ ನೀವು ಅದು ಹೇಳ್ತಾ ಇಲ್ಲ.
71 ಅಲ್ಲಿ ನೋಟಿಫೈ ಆಗಿ ಈಗ ನಾವು ಇನ್ ದ ಡೈಲಿ ನ್ಯೂಸ್ ಪೇಪರ್ ಅಂಡ್ ಆಲ್ಸೋ in the news item of 2024, when government has published and there is a news item and government has taken a decision to lease this property and to execute sale deed in favor of respondent 10, then only the cause of action has come cause of action for this writ petition. Why I am making this submission is, now
when was the final notification? Did you receive the compensation, Mr. Shivprakash? Who are you first? You are the landowner, I presume.
My landowner is my grandfather and my father. They are no more. Now I am the children. I am represented this petition. They are dead.
Now right? They did not object. Now you are objecting.
No. Why I am objecting is the reason to object it, my lord, because the entire object of the government, the other government of Mysore, is to establish this Vijayanagara steel plant, Hosapet steel plant. Now it is a totally diversification of the scheme and object. That's the main thrust of this entire writ petition. Number two, when I have made a certain statement of allegations that clear fraud has been played by the government. It is abuse of process of statute and law. And third one is a colorable exercise of power by the state government. These are the main grounds on which I presented this writ petition. May I kindly take for a moment, my lord, what is the prayer I have sought? May I kindly take, my lord, the prayer which I have sought? My lord will get it at page number 54. My lord, number 1, I need not read it. Number 2, this is in respect of issue writ of circular and required notification so and so and annexure A1 to A3 published in Mysore Gazette in respect of villages Tornagal, Yarabanahalli, Musinayakanhalli and Karakuppa of Sandur Taluk, and consequently to declare that the acquisition of land is not sustainable in law for the reason that there is diversification of purpose for which land was acquired under 3F and 4 and 6 G of the Restored Land Acquisition Act of 1894, and consequently to restore possession of land to the petitioner's landowners. Issue writ of mandamus directing the respondent union government and state government to place all the records since 1971-72 till 2022. The decision taken by the government to divert the land in favor of private company, defeating the very object of the notification at annexure A1 to A3. Number 4, issue writ of mandamus and to place the report submitted by the Commission of Inquiry, Justice N. Santosh Hegde, and locate the report in respect of loss of 324.42 crores caused by the institution of state along with respondent number 10.
What is this item number 4?
4, I'll take the connection where the Lordship Jadan Justice N. Santosh Hegde has given a clear report that this company, that's the third respondent, the respondent 10, have caused a revenue loss to the government 324.42 crores.
Mining report adu.
ಹೌದು, ಮೈನಿಂಗ್
ರಿಪೋರ್ಟ್ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
ಮೈನಿಂಗ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಇವ್ರ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಇದೆ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. is a tainted. It is shown. I will take that annexure also. I'll take that annexure also. The illegal getting the iron ore and the iron to this company, they have caused, that is the report, and a specific statement is pinpointing at this respondent 10. Again,
File a public interest litigation, Mr. Shivaprakash.
it is also filed. It is also filed. I will take my lord to that petition
You
also.
filed a public interest litigation.
No, my lord, kindly, because it
Then
involves.
raise all these things there, not
No,
here.
substantial issues are there. That's what repeatedly I am appealing to my lord and this court that what is the stand of government is most important, my lord. Most important, because government from time to time they have taken and they have also taken different decisions. A subcommittee is appointed by the government, headed by the cabinet, to look into this matter. Subcommittee has not yet given any report till date. Till date, it is not given report.
Now, if we ask the government and government says they have no problem, then we can
No.
dismiss it.
If the government says no problem, then my lord's robust with experience, my lord can decide it. If government says no objection,
21 ಇವಾಗೆಲ್ಲ ಚಾಲೆಂಜ್ ಮಾಡೋದು ಬಿಟ್ರೆ ಹೆಂಗೆ ಎವ್ರಿಥಿಂಗ್ ವಿಲ್ ಓಪನ್ ಅಪ್. ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಅಕ್ವಿಸಿಷನ್ ನಾಳೆ ಓಪನ್ ಅಪ್ ಆಗುತ್ತೆ.
ಅಲ್ಲ ಹಂಗಲ್ಲ ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಇಂಪಾರ್ಟೆಂಟ್ ಅಲ್ಲ ಎಲ್ಲ
some semblance of time.
Everything we will not challenge, and we the advocates we have responsibility, my lord, what to file and what not to file, my lord. The government stand is very important, very important. Please, my lord, please, my lord.
Lord, in the entire petition, they have not explained this regarding to the delay which has been caused since Form 71 till filing of the writ petition. There is no reference. For the first time at para 17, they say that at page 39, most of the land owners depend on agriculture source and illiterate and ignorant of worldly affairs. Recently, when the 10th respondent through the district authority made attempts to cause interference with the petitioner, we are compliant to approach this honorable.
This land has been put to use.
Yes,
Yes, Lord, of course, Lord. We have produced enough.
We'll come to you later.
Very.
Use.
ಏನ್ ಮಾಡಿದೀರಾ ಇಲ್ಲ
ಇಲ್ಲಿ industry ಮಾಡಿದ್ದಾರೆ, yes.
ಮಾಡಿದೀರಾ? Construction is done.
ಹೌದು.
You have used it for that purpose. Now you are planning to lease. Yes, Mr. Shivaprakash, it has been put to use for the very same purpose.
I'll make clear. I'll make this point clear. Now, the total extent of the land notified under this notification is 10,000 and odd acres. 10,000 and odd acres. Now, the transaction between the government and this 10th respondent's private company is to an extent of 3,669 acres. That's the important thing which I want to make clear. Out of 10,000 and odd acres notified in the year 1971, the lease which now they have sought and they have got it is 3,667.31 acres only.
What is the security that you are willing to deposit to put this project at jeopardy?
My lord, now there is no interim order. Now I am not putting any jeopardy anything to this company. Now the decision making government is important. The government reply is very important. Now I am not for a moment against this respondent number 10. Now the decision taken and the process of taking decision by the government is very important. I have also given in my writ petition cause of action. When they
So you are not pressing the interim prayer.
That's what in the first day itself I have said. In the first day itself I have said interim order because of these changes I did not even before the lordship then Justice Podach I said the interim order as such because of this delay I am not insisting. Only what is the stand taken by the government is the most important. They have to explain it because the way in which 372 crores which they have caused a huge loss to the revenue to the government and the state of Karnataka, state of Mysore, they have to explain it through the government only because it's not
Then please file a petition against all the people named in the report.
My lord, report is also placed. It is annexed.
Have you filed all petitions against all the people named in that report?
My lord, I have stated.
This seems to be only extortion bit, Mr.
No, absolutely no. Absolutely no. I am before my lord seeking justice because the way in which this government, previous government and present government, they have handled this matter casually and no doubt it is for extraneous purpose they did it. With great pain and because it's a state rich mineral which they have looted. That's my concern.
The state appears to be against you. We'll only wait for their objection. Once
let
they
them-
file their objection, probably huge cost will be imposed on you to file this kind of
I'm
petition.
prepared to accept and I'm prepared to bow down my head. Let the state government.
We'll record that.
Let the state government make it stand clear. Let the state government make it stand clear. I am not against R10. I am only the
I think what is being said is completely against the law as laid down by the Honorable Supreme Court. Can I just point out one thing, my lord? Kindly see the judgment of the Honorable Supreme Court which I'm going to file. Give it to your lordship for our across.
I have
Shivprakash Nimdai, let Mr. Raghavan make argument.
Now, I am getting a petition to place it that Royal Orchid the company and also this Kedarnath, what's the state of union government, my lord, those things clearly explains what is the position of law and how the government acted when it has been notified under Land Acquisition Act and it is for public purpose. Can they divert this entire land to the private enterprises who has not paid any public out of public revenue? That's my point.
Permit me, I want to make some submissions. Please, he has had his say. Let me have for a few minutes.
My learned senior counsel, I'll complete it. Please, it is my request because you have every chance and the Honorable Court is granting time to you. What is my point? It is my case and I have to make my responsible submission to the Honorable Court. Sir, you have ample of time. You make your point. I am not coming in your way. The way in which the public fund, if they have paid one single rupee to the entire project, I bow down my head. I bow down my head.
Exactly what the Supreme Court has said should not take this Honorable Court's time when something is filed so belatedly. Please look at the latest judgment of the Honorable Supreme Court, my lord. Please look at this 2024 SCC online Supreme Court 513. But my learned friend will pass it on to your lordships, my lord.
We don't have it in front of us, Mr. Raghavan.
My learned friend is giving it to your lordships.
They are not giving it to us.
Mr. Prashant Gaurav is handing it over to your lordships.
They are still searching for it. Yavadu?
No, it's there, it's there. 2024 SCC Supreme Court 513.
Here is last one. 2020.
On when there is so much of delay, kindly see what the Honorable Supreme Court has said, my lord. Please be kind enough to turn to.
What is the citation, Mr. Raghavan? Page number,
2024 SCC online SC 513. It is handed over loosely to your lordship.
It is not handed over to us. It is not there in the document that has been handed over to us.
My learned friend, but Mr. Prashant Gaurav will hand it over to your lordship.
Yes, Mr. Prashant Gaurav gave us something which doesn't have that citation.
May I read it, my lord?
Ilva, you don't have that citation. They don't seem to have it.
Can we screen share it, my lord?
Mr. Raghavan, this will have to be heard. It won't happen today. Let everybody file their objection, then it will be heard. But we are putting Mr. Shivprakash on this one, that if it is dismissed, exemplary cost will be imposed. We will record a statement that he is ready to pay the exemplary cost.
And please also record, if your lordships are kind enough, that they are not pressing for the interim order. Interim order is ready.
Both the things will record.
In fact, my lord, this judgment says that you can't even go into merits if there is so much of delay. It is a very new angle.
You also have not filed anything, Mr. Raghavan. You are also only addressing orally. First, we need to find out at least if the project has been implemented. We need to see.
Has filed it, just 2-page affidavit has been filed. Kindly look at that.
That is not sufficient. You'll have to place the documents on record.
Please look at it. They have produced documents also.
What documents have they produced?
R10 has produced everything. Please take WP number 107726. Give me the counter.
All these things you have done is only after 2007.
No. Let me tell you not just in fact, we have a statement of what all has happened. Kindly look at Mr. Prashant Gaurav, give us this. But please be kind enough to turn to paragraph number 37.
37.
Yes, my lord. And these petitioners, my lord, have got ex gratia payment from us. They have received benefits from us. We have said everything.
First, the state will have to tell us from 71 what they have done, and if a utilization has been done, if they place it on record, that the petition will go.
Yes,
But
my
you
lord.
have started from 2007. We need from 71.
No, my lord, kindly see what we have said. That is exactly what I am going to point out to your lordship.
Where have you said that?
Please be kind enough to turn to paragraph number 6, my lord. I'll read that portion and then I'll leave it at that. The said steel plant and certain ancillary facilities and industries are established the petitioner on a total extent of 7,741.34 acres of land. The said land was allotted to the petitioner by the state of Karnataka in 5 tranches as follows. 3,430.16 acres of land situated at the villages of Vaddu, Kurikuppe and Thornagallu was allotted by government order dated 5/9/1995. Pursuant to this, lease cum sale agreement was executed at 10/9/1996 between KSIDC and dancing respondent. On 9/9/2005, KSIDC executed sale deed conveying the said extent of 3,430 acres of land to the dancing respondent. Then we have tranche number B. 29.95 acres of land situated at Kurikuppe and Vaddu villages was conveyed to the respondent by the sale deed dated 16/12/2011. 615 acres of land situated at Erbanahandi, Musanayakanahalli and Jannagallu was allotted by the state government by notification GO number so and so dated 22/7/2003. Thereafter, title to the said land was conveyed to the answering respondent by sale deed dated 22/10/2011. 2,000.58 acres of land situated at so and so was allotted by the state government by government order dated 7/2/2005 for expansion and other works at the investment of INR 3,206 crores. The state government executed lease cum sale in respect of the said land on 28/7/2006. Answering respondent is put in possession of the said land by possession certificate dated 31/10/2006. 1,700 acres of land in Thornagallu, Yerbanahandi and Musanayakanahalli villages was allotted to the answering respondent by government order dated 3/2/2007 for expansion works costing 10,192 crores. The state government has executed lease cum sale agreement on 24/10/2007. The answering respondent is put in possession of the said land under possession certificate dated 26/11/2007. Since the conveyance of the land mentioned in para 6D and para 6E above were kept pending for long time, although Department of Commerce and Industry had recommended that the sale deed may be executed in his favor on 26/2013 and 24/1/2018, approval of the Cabinet of Ministers of the State Government on 26/4/2021, and the issuance of government order for 6/5/2021 for execution sale deed. Hence, answering respondent, this is very important, madam, was constrained to approach this honorable court by writ petition bearing WP number 105060 of 2022. This honorable court was pleased to allow the said writ petition by judgment dated 12/3/2024, pronounced on 26/3/2024. Thus, the honorable high court directed the state government to take the G1 dated 6/5/2021, which is a product of the decision of the cabinet on 26/4/2021, to its logical conclusion and execute sale deeds in favor of respondent number 10. A true copy of the judgment of this honorable court dated 12/3/2024 is produced herewith and marked with annexure R10(1). Pursuant thereto, state government has approved execution of the sale deed in favor of answering respondent by government order dated 6/9/2024. A true copy of the said government order is produced herewith. In extent of 619.50 acres of land allotted as part of third and fifth tranches of allotment referred to above is included in impugn notification and annexure A to the writ petition, under which an extent of 1019.17 acres in Erbanahandi came to be acquired.
Yes, Mr. Shivprakash, all things have happened much earlier. ನೀವೇನೋ ಹೇಳಿದ್ ಏನು ಆಗಿಲ್ಲ ಇವಾಗ ಆಗಿದ್ದು ಅಂತ.
I'll clarify.
Deliberately misleading.
No, I'll clarify, madam, because
Clarify ಮಾಡಿ.
This
was done. Government order of 95, you are not challenged.
Malad,
Sale deed of 2005, 2011, government order of 2003, lease cum sale of 2006, possession certificate of 2006, the payment made of 10,192 crores, then earlier writ petition, everything is there.
No, I'll clarify it. I'll clarify it.
Clarify ಮಾಡಿ, ಬೇಗ ಮಾಡಿ, clarify.
Now, so far as my learned senior counsel submission that earlier in the year 1997-98, it is only a lease where there was a huge opposition by the government as well as to the local people. Then they have issued a notification and also.
What is your right, Mr. Shivprakash? You are a land loser. You are challenging the acquisition.
My lord, I am
What
the
is your
land.
right?
No, 1 minute, my lord, because learned senior counsel is not fair enough to make fair submission. Fair submission. It's all misleading. My lord, these lease agreements, the government assurance and given assurance is only for a temporary period, only a small extent of land, not in its entirety. Now, afterwards, when they made an attempt for a sale deed, then also there is opposition by the government and also cabinet decision. In the cabinet, they have taken a decision that these things involve illegal mining and all those things. It a subcommittee has to give a report. Now, subcommittee till date they have not given a report. Number one.
Where is the document appointing a subcommittee?
My lord, I'm taking, my lord, one by one I'm taking, because my learned senior advocate is only a pick and choose argument. In detail, it is there.
Mr. Shivprakash, please don't make these kind of submissions.
Oh, my lord, I with due respect,
It only reflects on you, please. There are junior lawyers watching your submissions.
My due respect is, if my learned senior counsel place all those documents and all those material, I put on my head. Now I'll take my lord to that point.
Where is that subcommittee?
I'm taking, my lord. I'm taking, my lord. My lord, in the same petition, the second volume is page number 241.
In which petition?
In the petition 10,367. Second volume, my lord. Second volume, my lord.
One volume. Yes, second volume.
Second volume, my lord. It is in page 241.
241.
241.
Yes.
My lord, this I obtained by RTI. Rahasya and Bargade. ಅದರಲ್ಲಿ ಸಚಿವ ಸಂಪುಟದ ಟಿಪ್ಪಣಿ. My lord, one by one it may take more time, but I take, my lord, to page number 251. 251.
Yes.
1.33, my lord. ದಿನಾಂಕ 26/6/19 ಅಧಿಕೃತ ಜ್ಞಾಪಕದಲ್ಲಿ ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆ ಸಂಡೂರು ತಾಲೂಕಿನ ವಿವಿಧ ಗ್ರಾಮಗಳಲ್ಲಿ 3667.31 ಎಕರೆ ಭೂಮಿಯನ್ನು ಮೆಸರ್ಸ್ JSW ಸ್ಟೀಲ್ ಲಿಮಿಟೆಡ್ ಪರವಾಗಿ ಶುದ್ಧ ಕ್ರಯಪತ್ರವನ್ನು ಜಾರಿಗೊಳಿಸುವ ಪ್ರಸ್ತಾವನೆ ಕುರಿತು ಪರಿಶೀಲಿಸಿ ಸೂಕ್ತ ಶಿಫಾರಸುಗಳು ಮಾಡಲು ಸಚಿವ ಸಂಪುಟದ ಉಪಸಮಿತಿಯನ್ನು ಅಂದಿನ ಮಾನ್ಯ ಗೃಹ ಸಚಿವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ರಚಿಸಲಾಗಿತ್ತು. ಅದರಂತೆ ದಿನಾಂಕ 8/7/19 ಮೊದಲ ಸಭೆಯನ್ನು ಕರೆದು ವಿಷಯವನ್ನು ಚರ್ಚಿಸಲಾಗಿತ್ತು. ಆದರೆ ಈ ಸಂಬಂಧ ನಡವಳಿಕೆಗಳಿಗೆ ಸಹಿ ಹಾಕಿರುವುದಿಲ್ಲ. ತದನಂತರ ಸರ್ಕಾರದ ಅಧಿಕೃತ ಜ್ಞಾಪನ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ದಿನಾಂಕ ಸೋನ್ಸೋಲ್ಲಿ ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆ ಸಂಡೂರು ತಾಲೂಕಿನ ವಿವಿಧ ಗ್ರಾಮಗಳಲ್ಲಿ ಒಟ್ಟು 3667.31 ಎಕರೆ ಭೂಮಿಯನ್ನು JSW ಲಿಮಿಟೆಡ್ ಸಂಸ್ಥೆ ಪರವಾಗಿ ಶುದ್ಧ ಕ್ರಯಪತ್ರವನ್ನು ಜಾರಿಗೊಳಿಸುವ ಪ್ರಸ್ತಾವನೆ ಕುರಿತು ಪರಿಶೀಲಿಸಿ ಸೂಕ್ತ ಶಿಫಾರಸು ಮಾಡಲು ಮಾನ್ಯ ಬೃಹತ್ ಮತ್ತು ಮಧ್ಯಮ ಕೈಗಾರಿಕಾ ಸಾರ್ವಜನಿಕ ಉದ್ಯಮಗಳ ಸಚಿವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ಮಾನ್ಯ ಕಂದಾಯ ಸಚಿವರು ಹಾಗೂ ಮಾನ್ಯ ಗೃಹ ಸಚಿವರನ್ನೊಳಗೊಂಡಂತೆ ಸಚಿವ ಸಂಪುಟ ಉಪಸಮಿತಿಯನ್ನು ರಚಿಸಲಾಗಿದೆ. ಅದರಂತೆ ಸಚಿವ ಸಂಪುಟ ಉಪಸಮಿತಿಯು ದಿನಾಂಕ 22/12/20 ಸೋನ್ಸೋ ಡೇಟ್ಗಳಲ್ಲಿ 7 ಡೇಟ್ ನಲ್ಲಿ ಸರ್ಕಾರದ ಅಪರ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿ ವಾಣಿಜ್ಯ ಮತ್ತು ಕೈಗಾರಿಕಾ ಇಲಾಖೆ, ಸರ್ಕಾರದ ಅಪರ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿ ವಾಣಿಜ್ಯ ಕೈಗಾರಿಕಾ ಆಯುಕ್ತರು, ಕೈಗಾರಿಕಾಭಿವೃದ್ಧಿ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು, ಕರ್ನಾಟಕ ರಾಜ್ಯ ಮಿನರಲ್ ಕಾರ್ಪೊರೇಷನ್ ಲಿಮಿಟೆಡ್ ಹಾಗೂ ಸರ್ಕಾರದ ಅಪರ ಕಾರ್ಯದರ್ಶಿ ಕಾನೂನು ಇಲಾಖೆ ಸಭೆಯನ್ನು ನಡೆಸಲಾಗಿರುತ್ತದೆ. ಅಂತಿಮವಾಗಿ ಸಚಿವ ಸಂಪುಟ ಉಪಸಮಿತಿಯು ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆಯ ಸೋನ್ಸೋಲ್ಲಿ ಪರ ಶುದ್ಧ ಕ್ರಯಪತ್ರ ಜಾರಿಗೊಳಿಸುವ ಪ್ರಸ್ತಾವನೆ ಪರಿಶೀಲಿಸಿ ಕೆಳಕಂಡ ಸಚಿವ ಸಂಪುಟದ ಮುಂದೆ ಮಂಡಿಸುವ ಶಿಫಾರಸನ್ನು ಮಾಡಿದೆ. ಲೀಸ್ ಕಮ್ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್, ಲೀಸ್ ಕಮ್ ಸೇಲ್ ಪತ್ರಗಳಲ್ಲಿ ಮೆಸರ್ ಸೋನ್ಸೋ ಕ್ರಯಪತ್ರ ಷರತ್ತುಗಳನ್ನು ಪೂರೈಸುವುದರಿಂದ ಇವರಿಗೆ ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆಯ ಸಂಡೂರು ತಾಲೂಕಿನ ವಿವಿಧ ಗ್ರಾಮಗಳಲ್ಲಿ ಒಟ್ಟು 3667 ಎಕರೆ ಭೂಮಿಗೆ ಶುದ್ಧ ಕ್ರಯಪತ್ರ ಜಾರಿಗೊಳಿಸಬಹುದು. ಮೆಸರ್ಸ್ MML ನಡುವೆ ಇರುವ ವಾಣಿಜ್ಯ ತಕರಾರಿನ ಕುರಿತು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ನೀಡಿರುವ ತೀರ್ಪಿನ ಮೇಲೆ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ SLP ಹುಡುಗರ ಬಗ್ಗೆ ಸರ್ಕಾರದ ಅಪರ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿ ಗಣಿ ಮತ್ತು MSME ವಾಣಿಜ್ಯ ಮತ್ತು ಕೈಗಾರಿಕಾ ಇಲಾಖೆಯವರು ಮಾನ್ಯ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಅವರ ಅಭಿಪ್ರಾಯವನ್ನು ಪಡೆಯುವುದು ಹಾಗೂ ಸದರಿಯವರ ಅಭಿಪ್ರಾಯದ ಮುಂದಿನ ಕ್ರಮ ವಹಿಸುವುದು. Again, I am taking my light to page number 254. ಯಾಕಂದ್ರೆ ಇದನ್ನೆಲ್ಲಾನು ಇನ್ನ ಸಮಿತಿ ಇದೆ ಬಂದಿಲ್ಲ, ಅದನ್ನ 1.39 ಅಷ್ಟರಲ್ಲಿ ಸಚಿವ ಸಂಪುಟ ಸಭೆಯು 27/5/21 ಮೆಸರ್ಸ್ JW ಲಿಮಿಟೆಡ್ ಹೆಸರಿಗೆ ಶುದ್ಧ ಕ್ರಮ ಕುರಿತು ಸಚಿವ ಸಂಪುಟ ಸಭೆಯಲ್ಲಿ 21 ತೆಗೆದುಕೊಂಡ ತೀರ್ಮಾನವನ್ನು ಸ್ಥಿರೀಕರಣಗೊಳಿಸಿರುವುದಿಲ್ಲ. ಅಂದ್ರೆ ಇಟ್ ಈಸ್ ನಾಟ್ ಎಟ್ ಕನ್ಫರ್ಮ್, ನಾಟ್ ಎಟ್ ಅಪ್ರೂವ್ಡ್. ಅದರಂತೆ ವಾಣಿಜ್ಯ ಮತ್ತು ಕೈಗಾರಿಕಾ ಮೆಸರ್ಸ್ JW ಸ್ಟೀಲ್ ಲಿಮಿಟೆಡ್ ಶುದ್ಧ ಪತ್ರವನ್ನು ನೆರವೇರಿಸುವುದಿಲ್ಲ. ಮೆಸರ್ಸ್ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ 13/1/21 ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ವಿರುದ್ಧ SLP ಪ್ರಕರಣ ಸಂಖ್ಯೆ 63/78/2021 ದಾಖಲಾಗಿಸಿರುತ್ತದೆ. ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಪ್ರಕರಣವನ್ನು ದಿನಾಂಕ 34/24/24 ವಿಚಾರಣೆಗೆ ಬಂದಿದ್ದು ಪ್ರಸ್ತುತ ಬಾಕಿ ಇರುತ್ತದೆ. ಮೆಸರ್ಸ್ KSML ಅವರು ಕೌಂಟರ್ ಕ್ಲೈಮ್ ಅನ್ನು ಸೆಟಿಸೈಡ್ ಮಾಡಿದ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ವಿರುದ್ಧ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯವು ಯಾವುದೇ ತಡೆಯಾಜ್ಞೆ ನೀಡಿರುವುದಿಲ್ಲ. KDB ಘಟಕ ಸಂಕೀರ್ಣ ಯೋಜನೆಯಡಿ ಭೂಸ್ವಾಧೀನ ಪಡಿಸಿಕೊಳ್ಳುವ ಕಂಪನಿಗಳಿಗೆ ಭೂ ಹಂಚಿಕೆ ಸಮಯದಲ್ಲಿ ಇದು KDB ಅಕ್ವಿಸಿಷನ್ ಲಾ, ಇಟ್ ಈಸ್ ಅಂಡರ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಕ್ಟ್, ಇಟ್ ಈಸ್ ನಾಟ್ KDB. ಇದು ಕಂಪನಿಗಳಿಗೆ ಭೂ ಹಂಚಿಕೆ ಸಮಯದಲ್ಲಿ ಭೂಸ್ವಾಧೀನ ವೆಚ್ಚ ಹಾಗೂ ಮಂಡಳಿಯ ಸೇವಾ ಶುಲ್ಕವನ್ನು ಪಡೆದಿರುತ್ತದೆ. KDB ಕಂಪನಿ ಜೊತೆ ಲೀಸ್ stonesorly, it is mentioned that agreement deed represent the tentative cost of land, and in the event lessor incurs a payment of amount to the land owners over and above the award made by the acquiring authority by virtue of the award passed by the competent court, the same will be collected from the company at the time of execution of the sale deed. And the KDB ಶುದ್ಧ ಕ್ರಯ ನೆರವೇರಿಸುವ ಸಮಯದಲ್ಲಿ ಭೂಮಿಯ ಮಾರುಕಟ್ಟೆ ದರವನ್ನು ಪಡೆದಿರುವುದಿಲ್ಲ.
Where is the constitution of this subcommittee, Mr. Shivprakash, that is looking in, that is investigating and looking into it? Where is the constitution of the subcommittee? Idella odidralli ಏನು ಇಲ್ಲ. You are trying to waste the time of the court to reading inconsequential things.
1.8 inches issue.
I'm not making one by one. This is because it's a voluminous things which requires little more time, and I'm taking one by one. I am not placing anything.
We specifically understand your intention. It is very clear on the face of it.
My lord,
we don't expect this kind of a practice from your end.
No, my lord.
Saying something, reading something else. This is only to waste the time of the court. Ashte ನೀವು ಮಾಡ್ತಾ ಇರೋದು.
No, certainly not.
This seems to be the only purpose. You want to try the patience of the court? We have a lot of patience. Don't worry.
My lord, certainly not. No, my lord should have not.
ಕಮ್ಮಿ ಇರಬಹುದು, but patience is there. You don't try doing all this.
No, with robust knowledge and experience, my lord is now looking into with abundant patience.
We asked you a simple question. You are not answering any question. We will make note of it and dismiss your petition if this is the conduct.
No, my lord, kindly.
There is a subcommittee which has been formed. Where is that subcommittee formed? Torsi andre ಏನೇನೋ ಓದ್ಕೊಂಡು ಕೂತ್ಕೊಂಡಿದ್ದೀರಾ.
ಬಂದೆ subcommittee ಮೊದಲು ಓದಿದ್ದು 1.33.
You are not only wasting the time of the court, you are wasting time of so many lawyers who are waiting for their matters.
That subcommittee report and subcommittee.
ಎಲ್ಲರೂ ನಿಮ್ಮನ್ನೇ ಬೈಕೊಂಡ್ತಾ ಇರೋದು.
ಇಲ್ಲ
ನಮ್ಮನ್ನೇ ಬೈಕೊಂಡ್ತಾ ಇರ್ತಾರೆ, ಯಾಕೆ ಇಷ್ಟು ಬಿಡ್ತಾ ಇದಾರೆ ಅವ್ರನ್ನ ಅಂತ.
ಇಲ್ಲ, ವಕೀಲ ಮಿತ್ರರು ಯಾರು ಬೈಕೊಂಡಲ್ಲ. ನಾನು ಯಾಕಂದ್ರೆ ಒಂದು ಜಸ್ಟಿಸ್ ಕಾಸ್ಗೆ
ಕೇಳೋಣ ಇಲ್ಲಿ
ಅಲ್ಲ ಫೈಟ್ ಮಾಡ್ತಾರೆ,
ಎದ್ದು ನಿಂತಿದ್ದಾರೆ.
ಅದು ಟೈಮ್ ಆಯ್ತು ಅಂತ ದಯವಿಟ್ಟು ಆ ರೀತಿ ಆ ಇಂಪ್ರೆಷನ್ ಕೊಡಬೇಡಿ. Because
tell us, where is the committee constituted?
ಅದು 251ನೇ ಪೇಜ್ ಅಲ್ಲಿ ಓದ್ದೆ ನಾನು. ಇನ್ನೊಂದ್ಸತಿ ತಮ್ಮ ಅವಗಾಹನೆಗೆ ಓದ್ತೀನಿ.
ಇವಾಗ ಕಮಿಟಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗಿದೆ, ರಿಪೋರ್ಟ್ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಅವಾಗ ಅಷ್ಟು ಜೋರಾಗಿ ಸಬ್ಮಿಷನ್. ಕಮಿಟಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗಿರೋದು ಯಾವಾಗ ಕಮಿಟಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗಿದೆ, ಯಾವಾಗ ಬಂದಿಲ್ಲ ಅಂತ ತೋರಿಸಿ. Just don't go on reading and wasting time just because you have produced 1,000 pages.
Again, 251 page number, Malak, 251. I read it, 1.33. 1.33.
Yes.
At the cost of repetition, at the valuable time of court, I am repeating it. 26/6/19 ಅಧಿಕೃತ ಜ್ಞಾಪನದಲ್ಲಿ ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆಯ ಸಂಡೂರು ತಾಲೂಕಿನ ವಿವಿಧ ಗ್ರಾಮಗಳಲ್ಲಿ 3667 ಭೂಮಿಯನ್ನು ಸೋ ಪರವಾಗಿ ಪೇಪರ್ ಜಾರಿಗೊಳಿಸಿ ಪ್ರಸ್ತಾವನೆ ಕುರಿತು ಪರಿಶೀಲಿಸಿ ಸೂಕ್ತ ಶಿಫಾರಸುಗಳನ್ನು ಮಾಡಲು ಸಚಿವ ಸಂಪುಟದ ಉಪಸಮಿತಿಯನ್ನು ಅಂದಿನ ಮಾನ್ಯ ಗೃಹ ಅಧ್ಯಕ್ಷರು ರಚಿಸಲಾಗಿತ್ತು. ಅದರಂತೆ ದಿನಾಂಕ 8/7/19 ಮೊದಲ ಸಭೆಯನ್ನು ಕರೆದು ವಿಷಯವನ್ನು ಚರ್ಚಿಸಲಾಗಿತ್ತು. ಆದರೆ ಈ ಸಂಬಂಧ ನಡವಳಿಕೆಗೆ ಸಹಿ ಹಾಕಿರುವುದಿಲ್ಲ.
That was a different government at that time. Now that committee is gone.
No,
that committee is no longer in existence.
It is.
And you are relying on this. What is this?
My lord, now government may change and party may change, but the decisions of the government, it is the mighty government and the sovereign power. They cannot misuse and they cannot abuse and they cannot exercise their colorful powers in this fashion. My lord, again, the way in which this committee constituted and the way.
ನೀವೇ ಓದಿರ ಸಚಿವ ಸಂಪುಟ.
That committee itself, kindly see para 1.36. Kindly see 1.36. That committee itself has given a report. Please see, that's over, my lord. What is my lord?
1.36 ಬನ್ನಿ ಕರೆಕ್ಟ್ ಹೇಳದವರು.
ಬಂದೆ 1.3 ಫೈನಲ್
approved it. They approved it.
ಬಂದೆ.
Pursuant to which my lord decision was taken, writ petition was allowed.
ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಅವರು ಏನೂ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿಲ್ಲ.
ನೀವು ಫಸ್ಟ್ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡ್ರಿ ಇಲ್ಲಿ.
My learned is saying that writ petition mandamus they sought, and if the stand of the government at that time is so clear, they have not filed any statement of objection. What is their stand? They have not disclosed even that writ petition also. My learned friend, my learned senior counsel knows it. Now, my learned senior counsel says that writ petition was allowed. Now, I will take little later the writ petition and its contents and also the observation made with
259 para 7 is the ಅನುಮೋದನೆ ಮಾಡಿರೋದು. The recommendation, everything is done.
ಮೇಲೆ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ಸರ್ಕಾರ ವ್ಯವಹಾರ ನಿರ್ವಹಣೆ 77ರಲ್ಲಿ ಇದು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ದಿನಾಂಕ 24 ಆದೇಶದಂತೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಆದೇಶ ಮಾಡಿರೋದು ಮ್ಯಾಂಡಮಸ್ ಹಾಕಿರೋದು. ಅದನ್ನ ಐ ವಿಲ್ ಆಲ್ಸೋ ಟೇಕ್ ದಟ್ ಆಲ್ಸೋ ಟು ದಿಸ್ ಆಂಬಲ್ ಕೋರ್ಟ್. ಅನುಮೋದನೆ ಆದೇಶದಂತೆ ಮಾನ್ಯ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಅವರು 23 ಅಭಿಪ್ರಾಯದಂತೆ ಲೀಸ್ ಕಮ್ ಸೇಲ್ ಕ್ಲಾಸ್ 8 ಮತ್ತು 9 ಕಂಪನಿ ಪೂರೈಸಿದ 19 ಮತ್ತು 21 ಸಚಿವ ಸಂಪುಟ ತೀರ್ಮಾನದಂತೆ ಕೆಳಕಂಡ ಅಂಶಗಳ ಬಗ್ಗೆ ಸಚಿವ ಸಂಪುಟ ಅನುಮೋದನೆಯನ್ನು ಕೋರಲಾಗಿದೆ.
ಓದಿ ಅಲ್ಲೇ ಯಾಕೆ ನಿಲ್ಲಿಸ್ತೀರಿ?
ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆಯ ಸಂಡೂರು ತಾಲೂಕಿನ ತೋರಣಗಲ್ಲು ಮತ್ತು ಕರೆಕುಪ್ಪ ಗ್ರಾಮಗಳಲ್ಲೂ 2058 ಎಕರೆ ಜಮೀನನ್ನು ಪ್ರತಿ ಎಕರೆಗೆ 1.22 ಅಂತಿಮ ಬೆಲೆಯಾಗಿ ನಿಗದಿಪಡಿಸಿ JSW ಪರವಾಗಿ ಶುದ್ಧ ಕ್ರಯಪತ್ರ ನೆರವೇರಿಸಲು ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆಯ ಸಂಡೂರು ತಾಲೂಕಿನ ತೋರಣಗಲ್ಲು, ಮುಸನಾಯಕನಹಳ್ಳಿ ಮತ್ತು ಯರಬನಹಳ್ಳಿ ಗ್ರಾಮಗಳಲ್ಲಿ ಪ್ರತಿ ಎಕರೆಗೆ 1050 ಅಂತಿಮ ಬೆಲೆಯಾಗಿ ನಿಗದಿಪಡಿಸಿ JSW ಪರವಾಗಿ ಶುದ್ಧ ಕ್ರಯಪತ್ರ ನೆರವೇರಿಸಲು ಇದಕ್ಕೆ KPCಯಲ್ಲಿ 999 ಎಕರೆ ಪರಿಹಾರ ಭೂಮಿಯನ್ನು ಭೂಸ್ವಾಧೀನ ಪಡಿಸಿಕೊಳ್ಳುವ ಸಂದರ್ಭದಲ್ಲಿ ಒಂದು ವೇಳೆ ಪರಿಹಾರ ಭೂಮಿಯ ಭೂಸ್ವಾಧೀನ ವೆಚ್ಚವು ಮೆಸರ್ಸ್ JSW ಲಿಮಿಟೆಡ್ ಹಂಚಿಕೆಯಾದ ವೆಚ್ಚಕ್ಕಿಂತ ಹೆಚ್ಚಾಗಿದ್ದಲ್ಲಿ ವ್ಯತ್ಯಾಸ ವೆಚ್ಚವನ್ನು JSW ಲಿಮಿಟೆಡ್ ಲೀಸ್ ಕಮ್ ಸೇಲ್ ಡೀಡ್ ಪತ್ರ ಮತ್ತು ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ 2007 ಅನ್ನು ಸರ್ಕಾರಕ್ಕೆ KEDBಗೆ ಅದನ್ನು ಭರಿಸುವುದಾಗಿ ಮುಚ್ಚಳಿಕೆಯನ್ನು ಬರೆದು ಕೊಡುವ ಷರತ್ತಿಗೆ ಒಳಪಟ್ಟು ಇಲ್ಲಿವರೆಗಾಗಿದೆ. ಮುಂದೇನು ಇದೆ, ಆದ್ರೆ RTI ನಲ್ಲಿ ನಾನು ಹಾಕಿದಲ್ಲಿ ಇನ್ಫಾರ್ಮೇಶನ್ ಏನು ಕೊಡ್ತಿಲ್ಲ. ಆಮೇಲೆ ಈ ಪೇಪರ್ ನಲ್ಲಿ ಎಲ್ಲಾನು ಪಬ್ಲಿಸಿಟಿ ಬಂದಲ್ಲಿ ನಾನು
submission was that the subcommittee which is not given the decision. Subcommittee has given the decision, it has been accepted, it has been acted upon. There is nothing pending. Why are you misleading the court?
No, it's not misleading. Now subcommittee, let the government say, subcommittee as per my information not yet given any final report is my respectful submission, my lord. Not yet given any final report. That's why when asked on the RTI, the chief secretary has till date he has not replied and till date he has not given that information or the committee's report, my lord. That's what I am repeatedly requesting and appealing to my lord. The government stand is very much important on this subcommittee also. If they are given such a report by the subcommittee, let them place it on record. I bow down to their.
You have not crossed even 1 inch from where you started from. Don't ask them to do it. Your 1971 acquisition you are challenging. If you encourage these kind of things, all acquisition in Karnataka will get challenged.
My lord,
this kind of a challenge was just made.
No, it's not so, my lord. Kindly bear with me because it has got a very serious.
We are actually bearing with you, Mr. Prakash, from that time. What do you think we have been doing?
Now, for a moment, I will take the one other annexure, my lord, one other annexure. May I kindly take, my lord, to the annexure K at page number 311.
311.
In the second volume, my lord.
Yes.
Now, report on the reference made by the government of Karnataka under section 7, subclass 2A of the Karnataka Lokaयुक्त Act in 1984. My lord, this is a detailed report where I can take, my lord, to the only one or two paragraphs. My lord, 328, my lord.
Yes.
Before 328, one page, may I kindly take, my lord, 319, my lord, 319, only one page.
Yes.
My lord, in 319, there is a tabular column. I will not read that also. Kindly note, my lord, 319 tabular column, the transaction of the amount. This is by JSW. And again, my lord, next page is 320, my lord. Kindly look at the tabular column, my lord. Tabular.
How is that relevant for acquisition, Mr. Shubhrakash?
Now,
If they
one
have
by
committed some mistake there, they will be hauled up there. The investigation will go on, they will do it.
These
Now,
are
we
the
are here in a different matter.
My lord, yes, I do obey, my lord. These are the external factor, and now may I kindly take, my lord, to the page number is 330, my lord.
Tomorrow you will say probably there is a partition suit among them that is relevant and Theladalla.
My lord, it's a
You
public
this matter.
It's a land and a land of valuable land where government is the owner, and now the government to their whims and fancies they cannot act. My lord, 330, my lord. Para 5, my lord.
Yes.
I may read this, my lord. Even by excluding the multiple use of the some permits which is common thing in iron ore transportation and ignoring the cases of a small quantity of overloading, the finding of Dr. U.V. Singh's committee is that during the relevant period, at least 12,97.705 metric tons of iron ore was supplied in excess to JSW Limited, which is calculated at the rate of rupees so and so per metric ton, which was the prevailing market rate at that point of time. The loss suffered by the state comes to 324.42.72 rupees. After perusing the report, the material relied upon by Dr. U.E. Singh committee and accepted by the state government should take immediate steps to recover the amount of rupees so and so.
Mr. Shivprakash,
My
we
lord.
understand, we very clearly understood the scope of your argument and nature of argument. What we'll do is we'll just pass over this matter, deal with the urgent matter, and take up your matter till the time that you want to argue.
My lord, may I kindly appeal to my lord? May I kindly appeal to my lord because it takes a little more time. May I kindly accommodate some more time so that I can take one by one?
No. We have spent 1 hour on this argument.
My lord, still,
Your purpose we understand, but
my
that
lord,
1 hour should not go waste.
my lord,
At the
still,
cost of the other lawyers, we have heard you. So please
my
wait.
lord, still a substantial issues are there. May I
No
kindly
problem. ನೀವು ಎಷ್ಟು ಟೈಮ್ ತಗೊಂತೀರಾ ತಗೊಳ್ಳಿ.
ಅಲ್ಲ ತಗೊಳೋದಲ್ಲ
ನಮ್ಗೇನು ಇಲ್ಲ. ರಾತ್ರಿ 10 ಗಂಟೆವರೆಗೂ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ ಮಾಡಿ.
ಬೇಡ ದಯವಿಟ್ಟು ನಾನು I appeal to my lord. No, may I appeal to my lord on Thursday, that is day after tomorrow at 2:30. May I kindly request my physically will.
ನಿಮ್ಮನ್ನ ನಮ್ಮನ್ನ ಬೈಕೊಂಡು ಲಾಟ್ ಆಫ್ ಲಾಯರ್ಸ್ ಆರ್ ಸಿಟ್ಟಿಂಗ್ ಹಿಯರ್. ಥರ್ಸ್ಡೇನು ಮತ್ತೆ ಬೈಸ್ಬೇಡಿ. ಇವತ್ತೇ ಕಂಪ್ಲೀಟ್ ಮಾಡಿ ಇವ್ರದ್ದು. 12 ಮ್ಯಾಟರ್ ಇದೆ, ಈಗ ಮುಗಿಸ್ಬಿಟ್ಟು ನಿಮ್ಮ ಮ್ಯಾಟರ್ ಬರ್ತೀವಿ.
ಅಲ್ಲ ನಾನು ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀನಿ ಥರ್ಸ್ಡೇ. ಅಲ್ಲ ಫಿಸಿಕಲ್ ಅಪಿಯರೆನ್ಸ್ ನಾ ಬರ್ತೀನಿ ದಯವಿಟ್ಟು, ಯಾಕಂದ್ರೆ ಇದು ಅಲ್ಲ ಇಟ್ ಟೇಕ್ಸ್ ಲಿಟಲ್ ಮೋರ್ ಟೈಮ್.
Mr. Shivprakash, please don't interrupt again. Pass over, that's all.
ಅಲ್ಲ ಇಟ್ಸ್ ಓನ್ಲಿ ಮೈ ರಿಕ್ವೆಸ್ಟ್.
Your request rejected. You can finish and go. Ready.
Also recorded. 16 years thereafter, the respondent is supposed to disclosing the challenge the mutation entry, saying that one of the power of attorney was illegal. In the mutation, it is set aside, my lord, much in violation of the aim of 16.
Where is that order? Where is the impugned order?
Annexure A in the A1, my lord. Kindly come to page number 15. That is annexure A. And page number 20 is annexure A1.
Title decide ಮಾಡಿದ್ದಾರೆ. And AGA accepts notice for respond number 1 to 3, issued notice to respond number 4 to 20. AGA for 1 to 3 and 21. Issue notice to 4 to 20, returnable by 25th April. Both the petitioners and respondents, private respondents, the petitioner and respondent number 4 to 20 are restrained from any manner alienating, dealing with, creating a charge on property bearing RS number 267, Piranwadi, Belgavi, till the next date of hearing. We are restrained both. Process fee and copies to be furnished by end of day 27th, failing which the interim order will stand automatically.
To SS Mittal Court.
Recalling PW1.
PW1. On 14/2, the matter was posted for cross-examination. On that day, counsel on record for held up.
14/2. One day.
One.
Issue notice to the respondents returnable by 23rd April. The further proceedings in MC number 58 of 2020 pending on the file of the Principal Judge, Family Court, Dharwad, is stayed till the next date of hearing. Process fee and copies by end of day 27th. Acknowledgement of service on the counsel for respondents to be filed on or before 5th March, failing either of which the interim order will stand automatically.
3 Anandar Kolli.
Petitioners. Yes. Without acquisitions, my lords, the respondent number 3 had, my lords, issued a work order in favor of the respondent number 4. And my lords, they are respondent number 4, my lords, has started to do the road work. Where, my lord, this honorable court, my lords, page 38, my lords, in respect of similarly situated lands, adjustment lands, where, my lord, this honorable court has directed not to proceed, direction to the respondent number 4.
Acquisition agilla.
No acquisitions.
230 matters, no file.
ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ ಯಾವ ಫೈಲ್ಸ್ ಇಲ್ಲ ಇಲ್ಲಿ.
Adjourned.
All the 230 matters, no files.
ಅಂತ ಹೇಳಿದ್ವಿ.
ಲಿಸ್ಟ್ ಒಂದ್ ಬಿಟ್ರೆ ಬೇರೆ ಏನಿಲ್ಲ ಅದು.
ಇಲ್ಲ, we have, without, my lords,
We said, give it there, give it to the AGA here. ಅವ್ರು ಫೋನ್ ಮಾಡಿ ಕೇಳ್ಬೋದು, ಅವ್ರು ಇಲ್ಲಿ ಇರ್ಬೇಕಾ ಆಫೀಸ್ ಕಳ್ಸ್ಬಿಡೋಣ, ಹೋಗ್ಬಿಡ್ರಿ ಆಫೀಸ್ ನೋಡ್ಕೊಂಡು ಬನ್ನಿ.
Right now will serve. Since, my lords, without serving, my lords, the government. Yes, sir.
That is in the AG's office. That's why we keep telling you, serve it here and on all the standing counsel. Immediately bharat information.
I apologize, my lords.
Illare, I want one
Yes,
week
I
time
understand.
antarivans.
Yeah. Practical, I understand, my lords, practical. Where, my lords,
And AGA accepts notice for respond number 1 to 3, issue notice to respond number 4, returnable by 19th March. Respondents are restrained from carrying on any work of road laying on the land of the petitioner bearing survey number 102/2, 101/B, 110/B, 21/B, 109/3 of Kankapur village, Sandur Taluk, Bellary district, without having acquired the land on which the road is proposed to be laid. Process fee and copies to be furnished by end of day 27, failing its interim order.
obliged.
4th Chetan Manoli.
Petitioner number 1 is, my lords, education institution. Petitioner number 2 and 3 are its, my lords, president and treasurer. My lords, properties at, my lords, page number 9, 1 to 7 are standing in the name of petitioner number 1. And property at serial number 8 is standing in the name of its treasurer, personal property. And 9 to 15 are standing in the name of president. All these properties are being used for, my lords, education institutions. And so I served him the copy.
Milord, it is true that, Milord, educational institutions are exempted from payment of HAD. tax. Lord, in order to claim that exemption, Lord, petitioners have to submit them, Lord, materials before the Gram Panchayat in order to, Lord,
Liberty, you go in.
please.
If it is not,
Because they have constructed the so many buildings, but without any construction license.
Lord,
In order to claim, Lord, at least they should have to place the.
notice for the 187.
Please, Lord. But
187.9.
by claiming under this exemption, Lord, they are not permitting the Gram Panchayats to, Lord.
If they have not taken permission, demolish that building only, then there won't be any
Please.
tax also.
What kind of license they have?
ಬೇಕಾಗಿಲ್ಲ, ಅವರು ಕೊಡೋದು ಬೇಕಾಗಿಲ್ಲ.
Please.
ಹೆಂಗ್ ಬಿಡ್ತೀರಾ ನೀವು without license construction ಮಾಡಕ್ಕೆ?
That's why, Lord, even though, Lord, at least, Lord, the authorities claiming the exemption under educational institutions, they should have to submit them, Lord,
We'll
materials
direct them to
before.
furnish the plans.
Sorry,
Plans ಇಲ್ಲದೆ construction ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ, I secured instructions.
Submit ಮಾಡಿ.
Yes, Lord.
That AG accepts notice for respond number 1.
2 and
Shivraj Remit accepts notice for respond number 2 and 3. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the respondents 2 and 3 have called upon the petitioner to make payment of taxes.
3 only.
3.
2 and
called
3.
upon the petitioner to make payment of taxes, property taxes on premises used by the petitioner exclusively for educational purposes. And in this regard, he relies upon so and so. One the then not the same model.
Please.
5, Suraj Mudhol.
Yes, Mr. Mudhol.
Appear for the petitioner, but the respondent number 7, Lord, submitted an application for grant of Lord CL7 license, page 1 annexure H. But very same day, Lord, the inspector recommended for Lord the grant of approval, and he mentioned that building is unauthorized. Lord, he mentioned page 103, Lord.
Who are you?
Lord, I am the resident of Lord the area, and the building is not unauthorized, and I agree, it is residential area.
It's a public interest litigation. It's not a private interest. Your relief is negative, not to grant CL license.
Lord, earlier, Lord, annexure. Lord, this honorable court ordered, Lord, page 94, directing the authority to consider my objections. They have considered and returned entire their papers, Lord. Annexure F, page 94.
You may have a grievance, but is it a private grievance or is it a public grievance? CI ಹಾಕ್ಬೇಕಾಗತ್ತೆ ನೀವು ಹಿಂಗ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಇಂಥ ಆರ್ಡರ್ಗೆ.
I'm only, Lord, the request is consider my objection. That's simple, Lord.
Not to grant and
let them consider annexure J. Annexure J is my objections. So far, they have not granted, Lord. Annexure K is municipal commissioner, Lord, informed that the building is unauthorized. Annexure K, page 107. He intimated to the Lord excise authority that ಕಟ್ಟಡವು ಅನಧಿಕೃತ ಕಟ್ಟಡವಾಗಿರುವುದರಿಂದ ಕಟ್ಟಡಕ್ಕೆ ನಂಬರೇ ಕೊಟ್ಟಿಲ್ಲ. Lord, annexure K, page 107. Let them consider.
We can't grant this without service of notice on respond number 7.
Please, I pray for emergent notice.
And AG accepts notice for respond number 1 to 6. Issue emergent notice to respond number 7, returnable by 3rd April.
Please, much more.
6, Avinash Banka.
Please. Petitioners, Lords, are running the mutton shops. Lords, in CTS number 1694 of Lords of Badgi town. Lords, from many years. The said Lords CTS number Lords is basically Lords was a mutton market. But now Lords, the respondent number 2, the chief officer municipality, has issued a notice Lords to shift these all the mutton shops Lords to the market ground where Lords the municipality shops are located. Since the said number the place shops are located. Since the said number the place where Lords now it has been proposed, Lords, it is surrounded by all the temples. The other again Lords, it will lead Lords, the public will object for that. Without Lords issuing notice, nothing. Now they have not issued this notice.
If they are designated a particular place, they can always do it.
Because that I have produced the photographs to show that annexure C. That Lord, it is surrounded by the temple. That place. Annexure C. So this is a temple. Beside this temple, Lords, the shops are located. The second photograph, Lords.
Verify and tell us.
Yes, Lord. That's
why you have chosen that location. And you should guarantee that they won't have any problem there.
Since the,
Yes, yes,
what,
madam.
where
It is
we are-
only with an,
the present
because of,
shops where we are running, it's already a mutton market. Annexure A, I produced the CTS extract, register card. It is 1960-94.
So tomorrow you place it.
yes, madam. Now, madam, just now he has given me copy. It is only, madam, to accommodate those, all those persons. Market itself is being shifted to some other place.
Temple ಪಕ್ಕದಲ್ಲಿ shift ಮಾಡ್ತಾ ಇದೀರಾ ಮಿಸ್ ಸಾವ್ಕಾರ?
No, no, no. It is beside that. I will get information about that, madam.
You should give a guarantee that nobody will disturb them.
Yes, yes. Now, because they are disturbing here in the present place, we are decided to shift there.
Place,
And
may I request-
public auction is being conducted on 19.
Respond number 1, Shri Saukar accepts notice for respond number 2. He seeks fund, is granted 2 days time to obtain instruction, make a submission. Relist on 27th at 2:30 PM.
Please.
7, Rashik Rahili.
My lord, submission is it, but yesterday matter was listed, my lordships, that, Lord, at the time of, I was in reconciliation, my lords, that I am unaware of the order passed by the central question. Please, sorry, my lords, my submission. What happened, my lord? My lord, they were, my lord, without acquisition of lot, without my consent, my lord, without
There is
agreement.
already a notice.
But my lord, my submission is that, my lord, what happened, my lord? They were started the laying of transmission line in my property, my lord, with high-handedly, my lord, with police aid, my lords.
The order passed by recorded benches. Can't do anything. So it will have to be relist on 10/3/25.
Please.
8, R.K. Kulkarni.
Mr. Kulkarni,
R.K. Kulkarni.
and AGI accepts notice for respond number 1, TMC Malingpur.
TMC Malingpur.
Bhushan, Belgavi, Balakot. District Balakot, sorry. Shri Bhushan Kulkarni is directed to accept notice for respond number 2. Relist on 7th March. In the meanwhile, office objection to be complied.
9, Shivprasad Shantangowda.
For the petitioner.
Yes.
Lord, petitioner is the energy producer and energy transmission company. With respect to that, my lord, the permission being granted for energy production is at Annexure A, page 23. Annexure B and C, my lord, is the permission granted to lay the transmission lines. Now, what has happened, my lord? The civil court has granted an injunction insofar as setting up of the poles and transmission line is concerned. At the Annexure H, page 61. Now, kindly see the order of injunction granted, which the relevant portion is at page number 63. I am permitted to read more. Defendant, its men, agents, servants are restrained from entering in the possession and enjoyment of the suit scheduled property as mentioned in IA number 1 till filing of objection. And in respect of installation of the poles in the said property is concerned, ex parte order is not granted. Now I need not have to set up only the poles. I have to set up the transmission lines also, be that as it may.
Where is the plaint?
The plaint copy, my lord, is in the page number 51. I'm not here, my lord, on the ground of fact merits of the case. Now kindly see, my lord, insofar as energy projects are concerned, there is a specific code designated at page number, my lord, page Annexure J, page 65.
They mentioned electric wire corridor at
Yes,
para 5.
yes.
So the court should have seen it.
Yes.
In page number?
Annexure J, page 65. Pursuant to the amendment made in Specific Relief Act 20 capital B, Annexure J, page 65, my lord, the government in consultation with the Honorable Chief Justice, there is a special designated court which is fixed in the entire district, the third paragraph. Hence, preliminary civil, principal city civil and sessions judge Bangalore and all principal district and sessions judges in the High Court in state are directed that one specific day in a week, that is Monday, shall be dedicated for trial for suits pending before the existing designated special court under section 20B of the Specific Relief Act. The purpose of this is the paragraph number 2.
How is 20B attracted to this?
Kindly see, my lord, section 20B.
Specific Relief Act.
Yes. This was an amendment brought in so that there is the ease of business insofar as infrastructure projects are concerned. 20 capital A may first kindly be seen, my lord. Section 20 capital A. No injunction shall be granted by a court in a suit under this act involving a contract relating to infrastructure projects specified in the schedule, where granting of injunction would cause impediment of delay in progress or completion of such infrastructure project. Now, thereafter, my lord, central government, the consultation process has to take place. 20B, my lord, is a specific special court which has been formed. The state government, in consultation with, my lord, got it, my lord, 20B special courts.
Yes.
The state government, in consultation with the Chief Justice of the High Court, shall designate by notification published in the official gazette one or more civil courts as special courts within the local limits of the area to exercise jurisdiction and to try suit under this act in respect of contracts related to infrastructure projects. Now, what are these infrastructure projects, my lord? There is a schedule. That schedule may kindly be seen. This is after section 44. Infrastructure project. Category of projects and infrastructure subsectors. Number 1, transport. Number 2, energy generation, energy transmission, electricity distribution. So, insofar as, my lord, energy,
So contract would also include injunction in terms of.
yes. That is why there is a specific clause at the beginning of 20A saying that no injunction shall be granted insofar as contracts related to infrastructure projects. The purpose is this, because
Is there a notification issued in the state of Karnataka?
yes, circular, pursuant at, that is at Annexure J, page number 65. The notification mentioned the government of Karnataka by notification number so and so dated so and so and corrigendum dated so and so has designated course.
Only be the principal city civil and session judge?
Yes.
Or the principal district and session judge in each
Of
district?
that concerned district, which has the jurisdiction to entertain the suits, insofar as infrastructure projects are concerned.
Some other village in the headquarters barbeka.
This is the pursuant to the notification, my lord, which has been issued by the government of Karnataka. Now, reason is this: there is a prior to passing this notification, there was a detailed discussion, my lord, which has happened. I'll produce the discussion. The reason is because several infrastructure projects, my lord, the progress was hampered. For this reason, that for one or the other reason, injunctions were granted by the court. For ease of doing, the purpose was to encourage more businesses to come into this country, and that project should not be hampered. Keeping that in mind, for the
It doesn't need to be decided now. The order itself is bad. Issue notice.
Order also, my lord, to set up polls, there is no injunction.
Issue notice to respondent, returnable by 22nd April. The operation of the order dated 28/1/25 at Annexure H, passed by the civil judge and JMFC Elburga, coupled in invoice number 14 of 2025, he stayed till the next date of hearing. It is made clear that the petitioner, in exercise of the powers under section 10,
20 cap.
20 idu, enter upon 10 alva.
Yes.
Telegraph Act kodi.
Telegraph Act.
Would be entitled to in terms of section 10 of the Indian Telegraph Act 1885, enter the land upon the respondent to lay the electric poles and corridor in the said land. Compensation, if any, would have to be determined in accordance with section 16 of the Indian Telegraph 1885 by the Deputy Commissioner at the earliest.
They have produced that also, but compensation is already fixed.
Fixed. If he has any grievances, again, Deputy Commissioner for revision.
Please.
But this issue about the court's jurisdiction will have to be looked into, because ella PDJ ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ people cannot afford.
The purpose was, my lord, so
ಯಾವುದೋ ಒಂದು ವಿಲೇಜ್ ಅಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟು ಅಲ್ಲಿಂದ ಧಾರವಾಡ PDJ ಬರಬೇಕು ಅಂದ್ರೆ how will they come?
Mr. Milord, but the pursuant to, my lord, the discussions happened between with the
To
stakeholders.
facilitate you, they cannot be made to suffer. Can't be that draconian.
Yeah, at the time of discussion, my lord, the central government, my lord, they said that
If they challenge it, we'll go. It can't be that draconian.
Then
It's designated each taluka level, yes, but not saying come to a district.
Because
ಒಂದು ಎಕರೆ ಅದರಲ್ಲಿ ನೀವು ಹೋಗಿ
20B, my lord, says civil court, but the our High Court, my lord, pursuant to Karnataka notification, it is designated as a district court. Because
20B is civil
intention was always civil court.
That is what is close.
Yes.
Can't be the other principal district judge.
Principal, yes.
We are not convinced about it now, probably not later also.
At least for the moment, it has not been challenged.
ಅಲ್ಲಿ ಇದುವರೆಗೂ ಬೇಕಾಗಿಲ್ಲ this order ಗೆ.
then Shashank Hegde.
I appear for the petitioner in this matter, my lords. In this petition, we are challenging, my lords, the ex parte assessment order passed under the Income Tax Act on various grounds, my lords. The first ground is that, my lords, the approval issued under section 151, my lords, is unsigned by respondent number 2, is the approving authority, which will, my lords, render the document.
What is the hurry for it to be moved at the end of the day? We'll hear the and pass orders and what.
My bank account is attached, my lords. The petitioner is distributor.
Nothing will happen in one day.
Not sure.
ಯಾರು
Tirumalesh, my lord.
Tirumalesh.
126 Tirumalesh.
ಏನ್ initial?
M Tirumalesh.
M Tirumalesh. He is directed to accept notice for respond number 125. IDPA error.
Lordship may issue emergent notice.
Notice may be issued, madam.
Standing counsel ಯಾರಿಲ್ವಾ IDPA ಗೆ?
It's private bank.
If we issue notice, then it won't be on day after. That's why. Notice to respond number 6 is deferred for now, released on 28th.
11 Rintesh Kharvi.
Down of that recognition to the primary school, my lords. Page number 34, my lords, that notice was issued as per the provision of 1392 on 2019, my lords, and page number 34. So that was replied by the institution, my lords, page number 34. So court notice issued on 22/7/2019, we have replied, and as per that, my lords, notice we have provided all the, my lords, that is security amounts and also school board and reply also, and conducting the, at the time, COVID-19 also, my lords, conduct the classes. Subsequently, my lords, surprisingly on 14/3, Annexure P, my lord, page number 43. Shoka is, my lords, withdraw that recognition given to the primary school, my lords. So now it is learned that, my lords, on July 2024, they have closed that, my lord, SATS, my lord, student achievement track systems, to upload that students, all students in that SATS, and also close the dice number, my lords. So it is so meantime, my lord, though it was
no notice, nothing in the order.
Ascertain and make submission by Thursday or Friday.
27/2/30, my lord.
He accepts notice for
All
respond number 125. Counsel for the petitioner is directed to furnish 2 sets of the petition along with annexure of the learned AGA who seeks fund is granted 2 days time to obtain instruction, make submission. Released on 27th at 2:30 p.m.
Please.
12 Shashank Hegde.
Same. The M. Tirumalesh for 1 to 5. Do IDBI.
Yes, same.
Notice to respond number 5 is deferred for now. Release. ಇನ್ಯಾವುದು ಇದಿಲ್ವಲ್ಲ ಅಲ್ಲ ಇವೆಲ್ಲ ಅಡ್ಮಿಷನ್ ಪಾಸ್ವರ್ಡ್ ಇದಿಲ್ಲ. It's only 120.
Password matter 124.
Connected, my lord. That both matter may be clubbed together. Cylinder 10 and 12.
You have to connect one.
23 on this.
124.
All other matters are unlikely to reach. Mr. Shiv Prakash will keep us.
25. Serial number 125.
125. One 125.
Lord, may I sit on Thursday? Regarding to the pathway.
Notice ಆಗಿದೆಯಾ?
ಅಲ್ಲ ಆಗಿದೆ last time. Others it deferred ಆಗಿದೆ. So can we take?
And AGA seeks for 2 days time to obtain instructions. Released on 27th at 2:30 p.m. ಎಲ್ಲ ಅರ್ಜೆಂಟ ಏನ್ ಕವರ್ಡ್ ಮ್ಯಾಟ್ರಪ್ಪ ಕೊಡಿ ಆರ್ಡರ್ ಇದೆಯಾ ಕವರ್ಡ್ ಕವರ್ಡ್ ಅಂತ
survey number. That is only my lord.
ಇದು ಕೇಳಬೇಕು ನಾಟ್ ದಟ್ ಡೇಟ್ 27th ಎಲ್ಲ ಆಗಲ್ಲ ಇನ್ನ
serial 130 my lord.
Just a moment, Mr. Kasturi. ಯಾವ್ದು ಎಜುಕೇಶನ್ ಮ್ಯಾಟರ್ ಇವತ್ತಿದೆಯಾ ಮಾಟರ್ ಇದೆ ಅಲ್ಲ ಎಂಟ್ರಿ ಮಾಡೋ ಇದೆ $127 at the request of Shri Avinash Bankar, released on 27th at 2:30 p.m.
126, serial number 126 was substantially heard. Heard in the exams, not NCAS and matter, lords, where teachers, lords, were PG course, lords. They were supposed to publish the report, final report. Heard is the exams, lords.
Where is Angadi?
The exam. Now, by virtue of the interim order, my lord has to pay the examination fees. Heard is the exam, lords.
ಮಾಡಿ ಎಕ್ಸಾಮಿನೇಷನ್ ಫೀ ಕೊಟ್ಟಮೇಲೆ Respondents are yet to file the report. In that view of the matter, they are directed to facilitate students of the taking up the examination scheduled from the 3rd. The said yes, Mr. Angadi. 126. ಎಲ್ಲ ಒಂದು ನಿಂತ್ಕೊಳ್ಳಿ ಪರವಾಗಿಲ್ಲ ಬಿಡಲ್ಲ ನಂಬರ್ 132 ಒಂದು ನಿಮಿಷ ಅದ್ ಮುಗಿಸೋಣ ನಿಮ್ಮನ್ನ ನೋಡ್ಕೊಂಡೆ ಹೆಂಗ್ ಬಂದ್ರೆ
My lord, I had kept the file there.
ಆಯ್ತು ನೋ ಪ್ರಾಬ್ಲಮ್.
My lord, the yesterday's notification given by them, my lord. My lord, it will be applicable only insofar as the promotion is concerned, my lord. In this case, my lord, in our case, my lord, our NCSM is not disputing this document. My lord, our contention is that, my lord, they have been appointed in one department, and now, my lord, they wanted to change to another department, my lord. For that purpose, my lord, PG is required. That is the only contention, my lord. This particular document, my lord, will not dispute.
ಇಲ್ಲ ಅವ್ರಿಗೆ ಚೇಂಜ್ ಆಗಿಲ್ಲ
ಅಲ್ಲ ನಮ್ಮ ಕಂಟೆನ್ಷನ್ ಇರೋದೇ ಅದು ಸರ್
SR Remark He has continued. Now he is a principal.
ಅಲ್ಲ ಜಾಗೀರ್ದಾರ್
Jagirdar.
ಜಾಗೀರ್ದಾರ್ ಅವರು ರಾಶಿಶಾಸ್ತ್ರ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದಾರೆ ಸರ್. ಇವಾಗ ಅವರು ಬೇರೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ, ಅದಕ್ಕೆ ನಮ್ ಕಂಟೆನ್ಷನ್. ಅದು ಒಂದೇ ನಾವು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೊಟ್ಟಿರೋದು ಅದೇ ಸಾಹೇಬ್ರೆ. if my lord they wanted to continue in the same subject, my lord, we don't have any objections, but they wanted to change the department from one department to another department subject. ಇಲ್ಲ no my lord.
No, appointment prior to 89 and continuing in the same subject. There seems to be some logic.
ನಮ್ದು ಆ ತರ ಇದೆ.
If you continue in the same subject, there's no problem. Has he been teaching the other subject? Iವಾಗ change ಮಾಡ್ತಾ ಇರೋದು ನೀವು. You are asking for a change now. This one records, what are the records for that? What are the records that you have produced that they were teaching the other subject?
My lord, in OTM
Statutal and your qualification of that teacher. Lawyer civil practice ಮಾಡಬಹುದು, criminal practice ಮಾಡಬಹುದು. But criminal ಮಾಡಿದೀರಾ ಅಂತ ತೋರಿಸಬೇಕು.
They themselves have shown in the chart that he was earlier teaching Ayurvedic Samiti Siddhanta, then he converted to exempt for Rashishastra.
ನೀವು ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಇಬ್ರು ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಮಾತಾಡಿ. ಇದು ದಿನ ಹಿಂದೆ ಮುಂದೆ ಇದೊಂದ್ ಹೇಳೋದು, ಅವ್ರು ಒಂದ್ ಹೇಳ್ಕೊಂಡ್ ಬರೋದು. ವಾಟ್ ಎವರ್ ಕ್ಲಾರಿಫಿಕೇಶನ್ ದಟ್ ಯು ವಾಂಟ್ ಅವ್ರು ಕೇಳಿ ಕೊಡ್ತಾರೆ.
ಕೊಟ್ಬಿಟ್ಟಿದ್ವಿ ಸಾಹೇಬ್ರೆ. We already, my lord, we have given them. My lord, my only contention is this, my lord. My only contention this. My lord, in OTMS, my lord, that is the portal in which, my lord, all the information pertaining to professors have been uploaded by them itself, my lord.
They have uploaded it, but the interpretation that you are giving is different.
Please.
So now sit across and sort it out.
Hello, my lord. Now, my lord, insofar as students' examination is concerned, my lord, there is no problem. But, my lord, violation of
ಇರೋದು ಆರೇನಪ್ಪ, 6 ಜನದ್ದು. 3 ಜನದಂತೂ ನಮ್ ಪ್ರಕಾರ ಪ್ರಾಬ್ಲಮ್ ಇರೋ ಚಾನ್ಸ್ ಇಲ್ಲ.
ರೂಲ್ಸ್ ಇದೆ ಸಾಹೇಬ್.
What we saw yesterday also, 3 of them there cannot be a problem. 3 of them may be what you are saying, because that you sort out.
Even assuming, but not everything. These people, my lords, are also removed. I have 28 faculties, my lords.
Obligate
27. 28 faculties, they themselves say that, my lords.
ಇಬ್ರು ಮಾತಾಡಿ.
Lordship, serial number 23.
ಇದಕ್ಕೆಲ್ಲ ಎಷ್ಟು ಕಷ್ಟ ಕೊಡ್ತೀರಾ?
Serial number 1.
It's a waste of time.
The rules are very much clear, my lord.
Waste of time for them. ಅಷ್ಟು ಕಷ್ಟ ಕೊಡಬೇಡಿ ಅವ್ರಿಗೆ.
ಇಲ್ಲ ma'am. But insofar as students are concerned, my lord, let them write their exams, my lord. I don't have any.
The report is yet to be filed. In that view of the matter, the students of the Petition College are permitted to take up the examination scheduled from 3rd March 2025. The concerned respondents will make necessary arrangements to enable the students to take up such examination. The fees having already been paid.
Serial number 23, Lordship.
Adamil ನೋಡೋಣ.
Serial number 20. Serial number 23.
Both matters. Common order. Released on 26th March.
Serial number 23, Lordship.
Javalkar.
Serial 23 and 35 both are interconnected. ಅವರು ಡೆಮಾಲಿಷ್ ಮಾಡಬೇಕು ಅಂತ ಮಾಡಬಾರ್ದು ಅಂತಾರೆ, ನಾವು ಡೆಮಾಲಿಷ್ ಮಾಡಬೇಕು ಅಂತೀವಿ ಸರ್ 23 ದಲ್ಲಿ. Because there is urgency, because Lordship, almost 80 to 90% demolition of the complex has been done.
23 connect to 35 released on 27th at 2:30.
Please.
Serial number 34, my lords.
Interim order earlier granted is expired.
Serial number 34.
We are coming.
132, my lords. Serial number 34, my lords. I have filed an IA. Final order was passed on 12th of this month. In place of petitioner, plaintiff has been mentioned, my lords. I have filed an IA under one
correction,
my lords.
IA ಏನಕ್ಕಪ್ಪ ಆಗ್ತಿರ, being spoken to ಅಂದ್ರೆ ಮುಗ್ದೋಗಿರೋದು ಬೆಳಗ್ಗೆ.
Certified copy was already issued, my lords. That's why.
Yes, what is the correction?
My lords, at paragraph number 6, my lords. Last to a second line, my lords. Petitioner has been mentioned. It is to be mentioned as plaintiff, my lords.
Always call upon the IA 3 of 25 has been filed for correction of the judgment dated 12th February 2025. Accepting the reasons stated therein, the reference to petitioner in the penultimate line of para 6 is corrected to that of the plaintiff. Registry is directed to carry out necessary correction and issue fresh
My lords,
certified copy.
further, my lords, in paragraph number 7, before any other order is passed, order is being produced before this honorable court as the annexure D. Order was passed, my lords. This view will give ambiguity to the order. And before any order is passed, that portion is to be removed, my lords, to be deleted.
No, that should not be a problem.
Because the impugned order was already produced before this honorable court.
After this, if we pass, we are saying it would be any other order being passed. They have to pass orders, Alvapa.
Order passed to for the marking
Before
of the
any order is passed, they will have to look into these things.
Please, madam.
Otherwise, you will lose that
Please.
benefit.
Order. Serial number
Careful,
120.
Nimsha, madam.
Serial number 132. My lord has directed me to file an affidavit of disbursement of compensation for the A Kharab land. madam. For land is concerned, the compensation has been already paid. madam. For this only, I may seek some more time to disburse the compensation, which I have.
Yes, time back.
I have mentioned 6 months time. madam. Because award has been.
Correct again. Now, in one day,
For this Kharab land, there is no grant. That's why madam, we have made a representation to the head office several times. And we will take and pass our
8 weeks.
At least 3 months. madam. I have mentioned 6 months, madam. At least 6.
Learned counsel for respond about 2 to 10 has filed an affidavit stating that insofar as the A Kharab land is concerned, the respondent number 3 has corresponded with the head office KIDB for making arrangement for payment of the compensation amount. In that view, and sought for 6 months' time for getting the approval. And the considered opinion that such time of 6 months is not a reasonable time. Hence, 12 weeks' time is granted for the respondent number 2 to 4 to do needful.
Please.
Relist on 10th June.
Serial number 99 is also same. madam.
99.
Connect. Separate order.
Same order, connect to
99.
32.
Please.
Serial number 66, my lord. 66, my lord. Covered by judgment, my lord. So writ of mandamus. I'm seeking damages for the pass order, my lord. Series of
66.
Yes, my lord. Only, my lord, the representation made on different dates, my lord.
Petitioner is before this court. Claims to be sold.
Exclude only 66.2, my lord. It is wrongly listed some other. Excise 66.2 batches. 66.2, my lord. It's to be removed, my lord.
66.2.
To Sharad D. Name is mentioned. Excise matters on. Wrongly it is listed, sir.
66.2 D-link. And relist on 26th March. Baki ಎಲ್ಲದರಲ್ಲೂ same order. Same order.
Yes, my lord. Only representation is different dates, my lord.
Representation date?
Different dates, my lord. I'll mention.
Oh dear. Representation date.
Lord, serial number 129. In fact, my lord has dictated and some KS Patil has filed wakalat, my lord. It was detected at the end of dictation. It was waiting for all the time, my lord.
129 released on 27th at 2:30.
Please.
Serial number 128, my lord.
No, 130, my lord. Serial number 130, my lord.
We'll come to you.
7, my lord, passed over.
Come to you.
Serial number 7, passed over matter. Lord, it was passed over, my lord.
ಏನು ಮಾಡಬೇಕು?
Give it day after tomorrow, Thursday.
ಇವಾಗ ರೆಡಿ ಇದ್ದೀರಾ? ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್?
Petitioner, not respondent.
ಯಾರು ಪೆಟಿಷನರ್?
Santosh Raut.
Yes.
ಇಲ್ವಾ? 7/27.
Serial number 16 and 17.
ಹಾ.
Regards to 16, your lordship, a weeks of time to produce the rectification deed, your lordship. And the 17 one is, your lordship, there is a clear demarcation of boundaries. Your lordship.
16, 17 at the request of the petitioner. Released on 18th March.
Thursday.
Lords, serial number 64, serial number 60.
Yes.
Serial number 54, 54, but I appear for respond number 3.
Hmm.
My name may be debated because I appear for Karnataka State Bar Council.
54.
Yes.
My name may be
Registry that delete the name of Ms. Archana Magdum as that appearing for respond number 3. Yes.
My name may be entered.
Your name?
I undertake to file power on behalf of respond number.
ಅದು ಅನುಭವ ಶ್ರೀವತ್ಸವ ಬೇರೆ ಇದೆ.
ಅವ್ರದ್ದು even she is not.
ನೀವು ಬರ್ತೀರಾ?
Yes.
And ಅನುಭವ ಶ್ರೀವತ್ಸವ is that appearing for respond number 3. Rajshekar Burji submits that he would be appearing for respond number 3. Registry is direct print his name as such. Awaiting service on respond number 4. Awaiting service released on 28th March.
serial number 60, interim order.
Interim order.
Serial number 128, my lord.
Huh.
Kindly have it for next week, my lord.
Next week.
Worship 90 to 95. Interim order should be.
130 also. 130 will not.
We'll come to you, Mr. Kasturi. He'll first till ಮುಗಿಸ್ಬಿಡೋಣ ಇಲ್ಲಿ.
ನನ್ನ ಪ್ರೀವಿಯಸ್ ಕೇಸ್ ಎಲ್ಲ ಮೆನ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ ಇಲ್ಲಿ we are going back and forth. ಏನಪ್ಪ? ಇವಾಗ ಮೆಮೊ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಯಾವಾಗ ಇವತ್ತಿಗ ನಿಮಗ್ ಪ್ರೈಸ್ ಕೊಡ್ಬೇಕು. ಇಲ್ಲ ಶೀಲ್ ಅಂತ ಕೇಳ್ಬಿಟ್ಟು ನಿಮ್ಗೆ ಪ್ರೈಸ್ ಒಂದು ಅರೇಂಜ್ ಮಾಡ್ತೇವೆ. 27.
33, 27. 33, serial number 33.
33. 33 ಡಿಸ್ಪೋಸ್ ಆಗಿದೆಯಪ್ಪ. ಟ್ಯಾಕ್ಸ್
Double 33.
33 ನೇ. ಓ ಇದು ಲಿಸ್ಟ್ ಸಾರಿ. 33 ಏನು?
27.
What is the urgency?
Land
33, 27.
Lord, serial number 60.
ಆಯ್ತು ನೋಡೋಣ.
Lord, serial number 64. Lord, I am seeking status quo regarding entries. My lordship has directed R6 to serve the notice. I have served it, my lords. It has been returned. I have served, my lords. Now, my lords, by virtue of this, my lords, they are trying to. On the basis of application filed by respond number 6, my lords, the grant order has been issued to the petitioner that has been cancelled and directed, my lords, to enter the name of court.
Position ಏನಿದೆ ನಿಮ್ದು? What have you produced?
My lords, position report, my lords, as per my lords, the order in the reports, my lords, pursuant to annexure E and F. There, my lords, it has been stated that the grant has been allotted to the family of the petitioner in the year 1959. Since then, my lords, we are
The operation of the order date 12/12/23 passed by respondent number 3 at annexure G and 18/12/24 passed by respondent number 2 at annexure H is stayed till the next date of hearing.
Please.
Consequently, respondents are directed are injuncted are restrained from interfering with the possession of the petitioner.
Please.
Serial number 44, Lordship, 28.
Please.
3rd April.
Please.
44, 28.
ಏನಪ್ಪ 40?
Compensation is already, my share has not been disbursed, but whereas the shares of other owners already disbursed. Sir, KIDB compensation.
Execution ಹಾಕಿ.
Already in the, as per the FDP, other shares are already disbursed, keeping my share only, except my share. And liberty is also given by this honorable court in RSA, page number, Lordship.
44, 40?
46, Lordship.
46.
Page number 46.
Serial number ಏನು?
44, serial number 40. Page number 44, 46 nale. This honorable court in RSA has given a liberty to withdraw the compensation to all the parties. And in pursuance of that, others have also have withdrawn. As per the memo dated 12th February, Lordship, I filed memos wherein all other shareholders have withdrawn their compensation.
Respondent number 3 service ಆಗಿಲ್ವಲ್ಲ?
Notice order.
Notice ಹೋಗ್ಬೇಕು.
Notice order ಆಗಿಲ್ಲ.
Issue notice to respondent number 3, 4, 3 to 11. ಮತ್ತೆ 12 KDB. 3 to 11. Returnable
30 is
by
appearing not.
28th April. ಅವ್ರು ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಬೇಕು.
Private parties. Lord, serial number 60.
71. Serial number 71. Today the matter is listed for dismissal. One of the office objection was to production of OS number 33 of 1990.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ ಅದು ಅವೈಲೇಬಲ್ ಇಲ್ಲ, ಅದಕ್ಕೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ. I have produced the endorsement of the.
Give your counsel submission.
ಅದು ಕೊಟ್ಟಿದ್ದೀನಿ.
ARJ will deal with it.
ಅಲ್ಲ
88.
ಹೇಳಿ. ಆಯ್ತು ಅವ್ರಿಗೆ ಆಯ್ತು ಲಾಟ್ಕನ್ ಅವ್ರು
ಅಲ್ಲ ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಏನ್ ಮಾಡ್ಲಿ
ಪ್ಲೀಸ್
For extension of stay.
ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಇಂಟ್ರಿ ಆರ್ಡರ್ ಒಂದು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ ಅದರಲ್ಲಿ.
ಎಸ್ ಮಿಸ್ ಸಾವ್ಕಾರ್.
ಅದು 130 ಅವ್ರು ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ ಅದು ಲೇಬರ್ ಮ್ಯಾಟರ್ ಮಿಸ್ಟರ್
ಲೇಬರ್ ಮಿಸ್ಟರ್ ಕಸ್ತೂರಿ ಯಾವ್ದು 130
130.
130, my lord.
ಎಸ್ ಮಿಸ್ಟರ್ ಕಸ್ತೂರಿ ಏನಾಯ್ತು?
I have been waiting for matter to reach. Unfortunately, it could not reach. Could your lordship have it any time on 28?
ಸೆಟಲ್ಮೆಂಟ್ ಏನಾಯ್ತು? ವೇರ್ ಇಸ್ ಮಿಸ್ಟರ್ ಆನಂದ್?
Settlement ಆಗಿಲ್ಲ ಅಂತ ಅವ್ರು ಒಪ್ತಾ ಇಲ್ಲ.
The last time my lord will kindly recall 12 ಜನಕ್ಕೆ ಕೆಲಸ ಕೊಡ್ತೀವಿ ಅಂದ್ರೆ they were not ready for that. So my lord
you said you will better it, you will speak to Mr. Chidanandaya, sort it out. ನೀವು ಅವ್ರು ಮಾತಾಡೋದು ಕಸ್ತೂರಿ ಅವ್ರು ಕರ್ಕೊಂಡು ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ ನೀವು?
ಇಲ್ಲ my lord, I'm sorry. I will only.
Chidanandaya is a minor. He's a minor himself. ಅವ್ರ ಹತ್ರ ಮಾತಾಡೋದು ಬಹಳ ಕಷ್ಟ.
My lord will kindly recall last time ಫೌಂಡೇಶನ್ ಸರಿಗಿಲ್ಲ ಆನಂದ್ you go ahead with the matter ಅಂತ ಹೇಳಿದ್ರಿ ತಾವು. ಏನಂದ್ರೆ out of 68 workmen some have retired, some I said I'll give some.
We thought you will better the proposal instead of doing that.
ಇಲ್ಲ ಅವ್ರು ಕೊಟ್ಟದ್ದೇ ನಾವು ಇವ್ರು ಕೊಟ್ರೆ ಅವ್ರು ಮತ್ತೆ ಅವ್ರು ಬರ್ತಾರೆ.
ಇಲ್ಲ ಏನಂದ್ರೆ ಏನಾಯ್ತು, ಡ್ರಿಲ್ಲಿಂಗ್ ಆಪರೇಟರ್ಸ್ ಇಲ್ಲ ಅಂತ ಆಯ್ತು. My lord will, there were no drilling operators amongst those leftovers.
Therefore we'll give a date to your the
request. May I make one submission, my lord?
Yes, Mr. Chidanand.
These workers, my lord, at least 50% of the money is deposited by them. Let the RLC release at 50% of the money these workers, my lord.
No, we
because there is an interim order granted by your lordship.
This we'll have to hear you. ನೀವು ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಇದ್ರಲ್ಲಿ ಅಂದ್ರೆ ನೀವು ಇಬ್ರು ಕೇಳಲ್ಲ ಅಂತೀರಾ?
ಇಲ್ಲ
ಐಡಿಯಲ್ ಕೇಸ್
lordship here and dispose it of on 28 or Bangalore.
Prime Minister ಕಸ್ತೂರಿ
ಇಲ್ಲ ಬ್ಯಾಂಗ್ಳೂರಲ್ಲಿ ಮಾಡಿ ಸ್ವಾಮಿ.
ಬೇಡ ಇಲ್ಲೇ ಮಾಡ್ತಾರೆ. Due to your time. The
matter may be extended.
No, your lordships heard the matter, my lord. It can be heard in Bangalore, sir.
6th March interim order earlier granted is extended till next date.
Much obliged, brother.
My lords, serial number 116, my lords, may I please? 116, my lords.
50% is to be made.
In 116 ಏನಪ್ಪ?
My lords, may I request for next week, my lords, a date may be given, may I request, my lords?
Yeah, some date will be given depending on number of matters.
130 ನಲ್ಲಿ 50% amount, entire amount they have deposited. 50% is a requirement.
ಕಸ್ತೂರಿ ಅವರು object ಮಾಡಿದ್ರು ಅದಕ್ಕೆ.
It is lakhs together, crores together amount is lying without any interest for the last 4-5 months.
Here.
Anyhow, they are liable to pay, my lord.
Number 38, my lordship.
38.
Kindly have it next week, my lord.
Date ಬರುತ್ತೆ.
Lord, serial number 16 and 17 I accept notice. ಬರೀ ಅಜ್ಜನ್ ಆಯ್ತು, ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದ್ದಾರೆ.
16 and 17 ಅಜ್ಜನ್ ಆಗಿದೆ.
ಅಂದ್ರೆ ಆ ಸ್ಟೇಜ್ notice for all the respondents.
ತಪ್ಪಿಸ್ಕೊಂಡಿದ್ದಾರೆ. AGI for
all the respondents.
For the respondents.
Both the cases.
Please. Serial number 53, my lords. It was directions, my lords, to file the typed copies, and I have filed it. And I have served the copy of the writ petition to the trial court advocate. ನಂಗೆ ಒಂದು urgency ಇದೆ. My lords, I as an interim prayer, my lords, I sought to that HDMC authorities to verify that, to visit the suit schedule properties and clarify the things. ಅದೊಂದೇ interim prayer ಇರೋದು, my lords.
ಯಾರಿದೆ HDMC lawyer ಇಲ್ಲ?
I have requested him, requested the opposite advocate.
ಯಾರು ಇಲ್ಲ to be taken up. So okay, on Friday.
Please, in the fresh matters, my lords, please.
Friday, 28. 124, M. Shivprakash.
ಅವ್ರದ್ದು ಏನಂದ್ರೆ ಲೇಬರ್ಸ್ ವಿತೌಟ್ ಎನಿ ಪೇಮೆಂಟ್ ದೇ ಆರ್ ಸಫರಿಂಗ್.
Yes, Mr. Shuprakash, now we have no pressure of time at all. Up to you. ಏನೇನು ಓದ್ತಿರೋ ಓದಿ. Now we won't disturb you. ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
Now, may I audible, my lord?
Yes, you're audible. ಹೇಳಿ.
One more appeal and request, my lord. Now, my learned colleague is in the court hall before my lord, and I have sent about 4 or 5 decisions where my learned friend is unable to secure in the library of Dharwad High Court. There is no printout, and he could not get.
ಅದ್ 4 ಆಮೇಲೆ ನೋಡೋಣ, ಬಾಕಿ ಎಲ್ಲ ಮುಗಿಸಿ.
ಅಲ್ಲ, ಅದಿದೆ ಮೊದಲನೇದಾಗಿ. ಆಮೇಲೆ ಎರಡನೇದಾಗಿ, ಯಾಕಂದ್ರೆ ಬೆಳಗಿಂದ ನಾವು ಹೈರಾಣ ಹೋಗಿದ್ದೀವಿ. ಒಂದೇ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಅಂದ್ರೆ, ತಾವಿನ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ ಹಾಕೊಂಡು ನನಗೇನು ತೊಂದರೆ ಇಲ್ಲ, ನನಗೇನು
ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಎಲ್ಲ ಇಲ್ಲಿಂದ ಎತ್ಕೊಂಡು ಬರೋದು ಬೇಡ, ಇಲ್ಲೇ ಮುಗಿಸ್ಬೇಕು ಇದು.
ಅಲ್ಲ, ಇಲ್ಲಿಂದ ಎತ್ಕೊಂಡು ಹೋಗೋದು ಬೇಡ.
Spent half an hour the other day, 1 hour today.
ಅಲ್ಲ, we did not spend. It is valuable time of the sample court. Now, only request is that now if I quote these decisions, my learned friend is unable to place those decisions before my lord. That's one a bona fide request I am making, number 1. Number 2 is,
Prakash, today you finished rest of all the arguments. Friday, Thursday we will take up that for those citations.
Citations
we'll hear Mr. Raghavan, then only the citation ಬಗ್ಗೆ ನೀವು ಹೇಳಿರಂತೆ, ಏನು ಪ್ರಾಬ್ಲಮ್?
Citations ತೆಗೆದುಕೊಳ್ಳಿ.
ಮತ್ತೆ let's not eat into the time of the lawyers here on that day.
Citations ತೆಗೆದುಕೊಳ್ಳಿ. ಅದ್ರ ಜೊತೆಗೆ ರಿಕ್ವೆಸ್ಟ್ ಅಂದ್ರೆ ನೀವು ದಯವಿಟ್ಟು 2:30 ಅಂತ ತಕ್ಷಣ ತಗೊಳ್ಳಿ. ಐ ಆಮ್ ಫುಲ್ 2:30. ಐ ಆಮ್ ಪ್ರಿಪೇರ್ಡ್ ಟು ಆರ್ಗ್ಯೂ.
ಬಾಕಿ ಎಲ್ಲ ಮುಗಿಸಿ ಪ್ಲೀಸ್, ಎಲ್ಲ ಹೇಳ್ಬೇಡಿ.
ಅಲ್ಲ, ಹಾಫ್ ಹ್ಯಾಂಡೆಡ್ ಆಗ ತಿರ್ಗಾ ತಾವು ನಾನು ಬೈತೀರಿ. ಮತ್ತೆ ಹಾಫ್ ಹ್ಯಾಂಡೆಡ್ ಆಗಿ ಹೇಳಿದ್ರೆ ತಿರ್ಗಾ
ಯಾವತ್ತು ಬೈಯಲ್ಲ. ಯಾರು ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದೀವಿ ಅಷ್ಟೇ.
ಹಂಗಿಲ್ಲ,
ನಾವು ನಿಮ್ಗೆ ಏನ್ ಕೇಳಿದ್ದಕ್ಕೆ ಅದ ಹೇಳಿ ಅಂತ ಅಷ್ಟೇ.
ಅಲ್ಲ, ತಮ್ಮ ಪಾಪ ಯಾಕಂದ್ರೆ ತಮ್ಮ ವ್ಯಾಲ್ಯೂಬಲ್ ಟೈಮ್. ಮತ್ತೆ ನಾನು ಆ ಡಿಸಿಷನ್ ಅಂದ್ರೆ ನಮ್ಮ ಲರ್ನೆಡ್ ಕೊಲ್ಲಿಗ್ ಅಲ್ಲೇ ಇದ್ದಾರೆ, ಇದು ಲೈಬ್ರರಿಲಿ, ಆಮೇಲೆ ಇದ್ರಲ್ಲಿ ಪ್ರಿಂಟ್ಔಟ್ ಸಿಗ್ಲಿಲ್ಲ ಅಂತ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಾವ್ರೆ. ಆ ಕಾರಣದಿಂದ ಒಂದೇ ಒಂದು ಸ್ಮಾಲ್ ಅಕಾಮಿಡೇಷನ್ ಟಿಲ್ ಥರ್ಸ್ಡೇ.
ಜಡ್ಜಸ್ ಲೈಬ್ರರಿಯಿಂದ ತರಿಸ್ತೀವಿ ಕೊಡಿ. ನೀವು ರಂಗೋಲಿ ಕೆಳಗೆ ಹೋಗ್ಬೇಕು.
ಅಷ್ಟೇ ನಮ್ದು.
don't want to be doing all this. Please do this. Don't embarrass us and don't embarrass yourself.
ನಮ್ಗೆ ಎಂಬ್ರೇಸ್ ಇಲ್ಲ. ತಾವ್ ಯಾಕಂದ್ರೆ ಬಹಳ ಲೈವ್ಲಿ ಆಗಿ ತಗೋತಿರಲ್ಲ. ನಾನು ಯಾವತ್ತೂ ಎಂಬ್ರೇಸ್ ಮಾಡಲ್ಲ. ತಾವು ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ತಮ್ಮ ಮುಂದೆ ಅಪೇರ್ ಹಾಕಿ ನಮ್ ಖುಷಿ. ಆದ್ರೆ ಕೆಲವೊಂದು ನಮ್ದು ತಪ್ಪಿರ್ತದೆ. ಆ ಡಿಸಿಷನ್ಸ್ ಕೊಡಕ್ಕೆ ನನ್ನ ಕೊಲೀಗ್ ಪಾಪ ಪದೇ ಪದೇ ಫೋನ್ ಮಾಡ್ತಾವ್ರೆ, ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಾವ್ರೆ.
ಇಲ್ಲಿ ಇವರೇ ಬಂದಿದ್ದು ಲಾಸ್ಟ್ ಟೈಮ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳಿದ್ದು.
ಹೌದು.
ಸೈಟೇಷನ್ ಕೊಡಕ್ ಆಗಲ್ವೇನ್ರಿ? ರೆಡಿ ಇದೆಯಾ? ಕೊಡಿ. ಆಯ್ತು, ಬೇರೆ ಫ್ಯಾಕ್ಟ್ಸ್ ಮುಗಿಸಿ ಮಿಸ್ಟರ್.
ಅಲ್ಲ, ತಮ್ಮ ಮುಂದೆ ನನಗೆ ಆರ್ಗ್ಯೂ ಮಾಡಕ್ಕೆ ಬಹಳ ಸಂತೋಷ. ಆದ್ರೆ ನಮ್ಮನ್ನ ಈ ಎಂಬ್ರೇಸಿಂಗ್ ಇಡಬಾರ್ದು ಅನ್ನೋದು ನಂದಷ್ಟೇ.
ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದ್ರೆ 2 ನಿಮಿಷದಲ್ಲಿ ಇದೆಲ್ಲ ಇರ್ತಾರೆ. ಹಿಂದೆ ಪ್ರಾಬ್ಲಮ್. ನಿಮ್ಮಿಬ್ಬರದೇ 71 ಚಾಲೆಂಜ್. Yes.
My lord, I was taking the report of the Honorable Lokayukta, one part, where I pointed in page number 330 about the quantum of amount. The response number 10 has caused a huge loss to the government is one thing which my lord has to take into consideration. Number 1. Number 2, that the cabinet is not yet finalized and not yet taken decision, and the cabinet decision of the earlier government has been now put into acid test before this government, and they have not taken any decision. In the meanwhile, the very same 10th respondent has approached the sample court and sought for writ of mandamus. This sample court, subject to some riders where subject to the decision of the pending writ petition which was disposed with liberty. May I kindly take my lord to the decision of the the Honorable High Court of Karnataka, and it is, my lord will find it at page number 341.
341.
It's volume 2, my lord, annexure M.
Volume 2.
In ಯಾವುದು 367 ಅಲ್ಲ?
367.
367, my lord.
.367 is a photograph.
341.
Annexure M, volume 2. 241. 241, my lord. I am sorry, I apologize. 241. 341. 341. 341.
341. Yes.
My lord got it. My lord, only one or two paragraphs where I will try to write and impress upon the sample court, and demonstrate the page number is 345. 345. Para 5, my lord. If government had taken a firm stand or a stand by filing their objection, I would have been the most happiest person. They are not filing any statement. Para 5, my lord. Additional Advocate General representing the state would those seek to defend the action of non-registration of the sale deeds. But it is not in a position to dispute that the Cabinet has cleared execution of sale deed and would submit that if a direction is issued, state would take the issue to its logical conclusion. There also there is no firm stand by the state government about the points raised, and also the earlier about this the notification under Land Acquisition Act and as invoking section 3 subclass F, and also transferring to this respondent number 10 private entrepreneur. There also there is no firm stand by the state government. My lord, taking my lord further, para 7, the opposed narration of facts not in dispute. The link, change events and the dates of those events are necessary to be succinctly stated. The company becomes the beneficiary of the allotment of a huge packet of land, Sornagallu and Karakuppa of Bellary district. What was sought was 2,000 acres for establishment of steel plant in the year 2006. A government order comes to be issued allotting 2,000 acres on lease cum sale basis in favor of the petitioner company. Order reads as follows. So the statement made by the learned advocate representative respondent 10 is that a lease has been executed, not the sale deed earlier. Lease with a condition. That's where when there was a serious opposition by the local person as well as the elected members, then they said it is only for a temporary period of 10 years they are giving lease. Now, after completion of the 10 years, they have come up with this proposal of executing sale deed. This is the stand of the government, and this is how they have misused their power, and also their statutory power is my respectful submission, my lord. And further, the page number is 356, 256. ಅಂತಿಮವಾಗಿ ಸಚಿವ ಸಂಪುಟ ಉಪಸಮಿತಿಯು ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆಯ ಸಂಡೂರು ತಾಲೂಕು ವಿವಿಧ ಗ್ರಾಮಗಳಲ್ಲಿ 3,657.31 ಎಕರೆ ಭೂಮಿಯನ್ನು ಮೆಸರ್ಸ್ JSW ಸ್ಟೀಲ್ ಲಿಮಿಟೆಡ್ ಪರವಾಗಿ ಶುದ್ಧ ಕ್ರಯ ಪತ್ರಗಳನ್ನು ಜಾರಿಗೊಳಿಸುವ ಪ್ರಸ್ತಾವನೆ ಕುರಿತು ಪರಿಶೀಲಿಸಿ ಕೆಳಕಂಡಂತೆ ಸಚಿವ ಸಂಪುಟವು ಸಭೆಯ ಮುಂದೆ ಮಂಡಿಸಲು ಶಿಫಾರಸು ಮಾಡಿದೆ. ಮೆಸರ್ಸ್ ಸೋ ಅಂಡ್ ಸೋ ಅಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ಮೆಸರ್ಸ್ ಸೋ ಅಂಡ್ ಸೋ ಲಿಮಿಟೆಡ್ ಕಂಪನಿ ಸದರಿ ಕ್ರಯ ಪತ್ರಗಳ ಷರತ್ತುಗಳನ್ನು ಪೂರೈಸುವುದರಿಂದ ಮೇಲೆ ಸದರಿ ಕ್ರಯ ಪತ್ರಗಳಲ್ಲ, ಅದು ಕರಾರ್ ಇದು ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಇತ್ತು, ಕ್ರಯ ಅಂತ ತಪ್ಪು ಹೊಡೆದಿದ್ದಾರೆ. ಸೋ ಇವರಿಗೆ ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆ ಸಂಡೂರು ತಾಲೂಕಿನ ವಿವಿಧ ಗ್ರಾಮಗಳಲ್ಲಿ 3667 ಎಕರೆ ಭೂಮಿಗೆ ಶುದ್ಧ ಕ್ರಯ ಪತ್ರಗಳನ್ನು ಜಾರಿಗೊಳಿಸಬಹುದು. JSW ಇರುವ ವಾಣಿಜ್ಯ ತಕರಾರಿನ ಕುರಿತು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ನೀಡಿರುವ ತೀರ್ಪಿನ ಮೇರೆಗೆ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ SLP ಹೂಡಿರುವ ಬಗ್ಗೆ ಸರ್ಕಾರದ ಅಪರ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿ ವಾಣಿಜ್ಯ ಮತ್ತು ಕೈಗಾರಿಕೆ ಇಲಾಖೆಯವರು ಮಾನ್ಯ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಅವರ ಅಭಿಪ್ರಾಯವನ್ನು ಪಡೆಯುವುದು ಹಾಗೂ ಸದರಿಯವರ ಅಭಿಪ್ರಾಯದಂತೆ ಮುಂದಿನ ಕ್ರಮ ವಹಿಸುವುದು. ಈ ವಾಣಿಜ್ಯ ತಕರಾರು ತೀರ್ಮಾನಿಸಲು ನಿವೃತ್ತ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಾಧೀಶರ 3 ಸದಸ್ಯರ ಮೀಡಿಯೇಷನ್ ಸಮಿತಿಯನ್ನು ನೇಮಕ ಮಾಡಬಹುದು. ಸರ್ಕಾರದ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋನ್ಸೋಲ್ಲಿ ಮಾನ್ಯ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ನೀಡಿರುವ ಅಭಿಪ್ರಾಯದಂತೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಪಿಟ್ ಅರ್ಜಿ ನಂಬರ್ ಸೋನ್ಸೋ ಆದೇಶ ವಿರುದ್ಧ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ SLP ಹೂಡಲು ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಮಿನರಲ್ ಕಾರ್ಪೊರೇಷನ್ ಲಿಮಿಟೆಡ್ ಸಂಸ್ಥೆಗೆ ತಿಳಿಸಲಾಗಿದೆ. ದಿಸ್ ದ ಅಡ್ವೈಸ್ ಗಿವನ್ ಬೈ ದ ಲರ್ನೆಡ್ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್. ಸಚಿವ ಸಂಪುಟದ ಉಪಸಮಿತಿಯ ಸಭೆಯ ಶಿಫಾರಸಿನಂತೆ 27/5/2019 ನಡೆದ ಸಚಿವ ಸಂಪುಟದ ಅನುಮೋದನೆಯಂತೆ ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆ ಸಂಡೂರು ತಾಲೂಕಿನ ತೋರಣಗಲ್ಲು ಮತ್ತು ಕರೇಕುಪ್ಪ ಗ್ರಾಮಗಳಲ್ಲಿ 2000.58 ಎಕರೆ ತೋರಣಗಲ್ಲು, ಮಸನಾಯಕನಹಳ್ಳಿ ಮತ್ತು ಯರಬನಹಳ್ಳಿ ಗ್ರಾಮಗಳಲ್ಲಿ 1667.73 ಭೂಮಿಯನ್ನು ಮೆಸರ್ಸ್ ಸ್ಟೀಲ್ ಕಂಪನಿ ಪರವಾಗಿ ಶುದ್ಧ ಕ್ರಯ ಜಾರಿಗೊಳಿಸಲು 21ರಂದು ನಡೆದ ಸಚಿವ ಸಂಪುಟ ಮುಂದೆ ಪ್ರಸ್ತಾವನೆ ಮಂಡಿಸಲಾಗಿದ್ದು, ಸಚಿವ ಸಂಪುಟವು ಸದರಿ ಪ್ರಸ್ತಾವನೆ ಅನುಮೋದಿಸಿದೆ. ಅದರಂತೆ ಸರ್ಕಾರವು ಕೆಳಕಂಡೆ ಆದೇಶಿಸಿದೆ. ಸರ್ಕಾರಿ ಆದೇಶ 21/2021 ಮುಂದುವರೆದು ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆ ಪ್ರಸ್ತಾವನೆ ವಿವರಿಸುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕೆಳಕಂಡ ಪ್ರಸ್ತಾವನೆ ಸರ್ಕಾರವು ಅನುಮೋದನೆ ನೀಡಿರುತ್ತದೆ. ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆಯ ಸಂಡೂರು ತಾಲೂಕಿನ ತೋರಣಗಲ್ಲಿನಲ್ಲಿ ಕರೇಕುಪ್ಪ ಗ್ರಾಮದಲ್ಲಿ ಎಕರೆ ಒಂದಕ್ಕೆ ಪ್ರತಿ ಎಕರೆಗೆ 1,22,000 ಅಂತಿಮ ಬೆಲೆಯಾಗಿ ನಿಗದಿಪಡಿಸಿ JSW ಪರವಾಗಿ ಶುದ್ಧ ಕ್ರಯ ಪತ್ರ ನೆರವೇರಿಸುವುದು. ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆಯ ಸಂಡೂರು ತಾಲೂಕಿನ ತೋರಣಗಲ್ಲು, ಮಸನಾಯಕನಹಳ್ಳಿ ಮತ್ತು ಯರಬನಹಳ್ಳಿ ಗ್ರಾಮಗಳಲ್ಲಿ 1667.73 ಪ್ರತಿ ಎಕರೆಗೆ 1,50,50,000 ಅಂತಿಮ ಬೆಲೆ ನಿಗದಿಪಡಿಸಿ ಸ್ಟೀಲ್ ಪರವಾಗಿ ಶುದ್ಧ ಕ್ರಯ ಪತ್ರ ನೆರವೇರಿಸುವ. ಇದಕ್ಕೆ KPCLಗೆ 944 ಎಕರೆ ಪರ್ಯಾಯ ಭೂಮಿಯನ್ನು ಭೂಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳುವ ಸಂದರ್ಭದಲ್ಲಿ ಒಂದು ವೇಳೆ ಪರ್ಯಾಯವಾಗಿ ಭೂಮಿಯ ಭೂಸ್ವಾಧೀನ ವೆಚ್ಚವು ಮೆಸರ್ಸ್ ಸೋನ್ಸೋ ಹಂಚಿಕೆಯಾದ ವೆಚ್ಚಕ್ಕಿಂತ ಹೆಚ್ಚಾಗಿದ್ದಲ್ಲಿ ವ್ಯತ್ಯಾಸದ ವೆಚ್ಚವನ್ನು ಮೆಸರ್ಸ್ ಸೋನ್ಸೋ ಅಲ್ಲಿ ಸಂಸ್ಥೆ ಲೀಸ್ ಕಮ್ ಸೇಲ್ ಡೀಡ್ ಕರಾರು ಪತ್ರ ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ KDBಗೆ ಅದನ್ನು ಬರೆಸುವುದಾಗಿ ಮುಚ್ಚಳಿಕೆಯನ್ನು ಬರೆದುಕೊಡುವ ಷರತ್ತಿಗೊಳಪಟ್ಟಿದೆ. Here the not by the government. KDB has no at all.
First thing order. The last two, it also subject transcribing. It's also it was.
Raghavan, there's some this one from your end. Your discussion is being heard here.
I'm sorry.
Yes, Mr. ಸೌಂಡ್ ಹೋಯ್ತು. ಬಂತು ಹೇಳಿ. ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆಯ
ನಡುವೆ ಇರುವ ವಾಣಿಜ್ಯ ಅದು 3ನೇದು ಐಟಮ್ 3 ವಾಣಿಜ್ಯ ತಕರಾರು ಕುರಿತು ಮಾನ್ಯ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ನೀಡಿರುವ ಅಭಿಪ್ರಾಯ ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಮಿನರಲ್ ಕಾರ್ಪೊರೇಷನ್ ಲಿಮಿಟೆಡ್ ಅವರು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ನೀಡಿರುವ ತೀರ್ಪಿನ ಮೇಲೆ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ SLP ಹೂಡುವುದು. Now it is in the nebulous state where the Advocate General has recommended that the claim of this MMD, that is Mysore Mineral Corporation, the government established corporation, they have disputed and they have questioned about all these acts of the government. Advocate General has recommended to prefer special leave petition and to question the order of the Honorable High Court in the before the Honorable Apex Court. This is the opinion.
Where is that order?
Last paragraph that Messrs. 3ನೇ ಐಟಮ್ ನಲ್ಲಿ 3ನೇ ಎಕರೆ ಇವರು ನಾಗರತ್ನ ಮತ್ತು ಕರ್ನಾಟಕ ರಾಜ್ಯಪಾಲರ ಆದೇಶ ಗವರ್ಮೆಂಟ್ their excellent governance order. ಮೆಸರ್ಸ್ ಸೋನ್ಸೋ ನಡುವೆ 3ನೇ ಐಟಮ್ ಇದು ನಡುವೆ ಇರುವ ವಾಣಿಜ್ಯ ತಕರಾರಿನ ಕುರಿತು ಮಾನ್ಯ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಅವರು ನೀಡಿರುವ ಅಭಿಪ್ರಾಯದಂತೆ ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಮಿನರಲ್ ಕಾರ್ಪೊರೇಷನ್ ಲಿಮಿಟೆಡ್ ಅವರು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ನೀಡಿರುವ ತೀರ್ಪಿನ ಮೇಲೆ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ SLP ಹೂಡುವುದು.
ಯಾವ್ದಿದು ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ತೀರ್ಪು ಯಾವ್ದು ಮೆನ್ಷನ್ ಆಗ್ತಾ ಇರೋದು ಇದು?
ಇದು
Where is that judgment? Where is that judgment?
ಮೈಸೂರು ಮಿನರಲ್ ಕಾರ್ಪೊರೇಷನ್ ಅವರು ಹಾಕಿದ್ದಾರೆ. ಅದ್ರ ಮೇಲೆ ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಕೊಟ್ಟಿರೋ ಡಿಸಿಷನ್ ಮೇಲೆ SLP ಆಗ್ಬೇಕಂದ್ರೆ ಆ ಡಿಸಿಷನ್ ನನ್ನ ಅನೆಕ್ಷರ್ ಅಲ್ಲಿ ಇದೆಯೋ ನಾನು ಪ್ಲೇಸ್ ಮಾಡ್ತೀನಿ.
Where is the judgment of the High Court that you are relying on?
What it is, I applied in this matter, but not in respect of a commercial contract. In respect of a commercial contract entered into between Mysore Minerals and JSW, there was a dispute. Mysore Minerals could not find a suit. JSW has filed a suit. That was pending. In that, an order was passed. That came up to the High Court. High Court passed an order in favor of JSW. It is in respect of that they said go file a SLP to Supreme Court. That's all. It has nothing to do with this acquisition. I know this. It says so. It says, Manoj, that there is a.
Mr. Raghavan, let Mr. Shivprakash complete.
Answering your Lordship's question.
According to him, this is a judgment where the High Court has passed an order against the acquisition or against the transaction with JSW. He has to make good his submission.
Yes, I understand.
Yes.
Ma'am,
Mr.
The Mysore Mineral Corporation is a government established corporation where the rich resource of mineral which was in this land, in these villages, they have the right over this mineral as a government entity. Where this government has
that is para 3.
ಆ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಆ ಡೀಟೇಲ್ ಆರ್ಡರ್ ನಲ್ಲಿ ಇದೆ. ಇದು ಪ್ಯಾರಾ 3 ಇಷ್ಟೇ ಇದು ನಾನು ಓದ್ತಾ ಇರೋದು, ಯಾಕಂದ್ರೆ ಆ ರಿಟ್ ಪಿಟಿಷನ್ ಆರ್ಡರ್ ಇದ್ರಲ್ಲಿ ಅನೆಕ್ಸ್ ಮಾಡಿಲ್ಲ ಸುಮ್ಮನೆ ನಾನು.
ಅದು ಆ ರಿಟ್ ಪಿಟಿಷನ್ ಆರ್ಡರ್ ನಾಳೆದ್ದು ಕೊಡಿ.
ಕೊಡ್ತೀನಿ. ಅದರಲ್ಲಿ ಆ ಒಂದು ರಿಚ್ ಮಿನರಲ್ ರಿಸೋರ್ಸ್ ಗವರ್ಮೆಂಟ್ ಉಪಯೋಗಿಸ್ಕೊಳ್ಳೋಕೆ, ದಟ್ ಈಸ್ ದ ಕಾಂಟ್ರಾಕ್ಟ್ ಬಿಟ್ವೀನ್ ಗವರ್ಮೆಂಟ್ ಅಂಡ್ ದ ಗವರ್ಮೆಂಟ್ ಎಂಟಿಟಿ ಆಫ್ ಮೈಸೂರು ಮಿನರಲ್ ಕಾರ್ಪೊರೇಷನ್ that has been violated by the government. That's how the mineral corporation has questioned it. When they have challenged it, the sample court has passed order against that. The governor has ordered and Advocate General has also recommended to prefer SLP before the humble Supreme Court. Yes, I will show it now. Presently, the SLP is pending before the humble apex court.
Give us the order of the High Court.
I will place it, Mala. I will place it. Now, this is the background where the transfer of this land.
Mr. Raghavan, you can also place it on day after tomorrow. Yes.
This is how the things has happened, and now 1971 delay and other things my learned senior counsel is harping upon. May I kindly take my lad to para 18 of my writ petition. My lad is finding at page number 39.
Yes.
The petitioner has approached the Sambal court. There is a delay in approaching the Sambal court for the reason that the project of Vijayanagara steel plant is not implemented by the state government, union government till date. Villagers and landowners are assured time and again that since there is a lapse on the part of government, state of Karnataka, the possession and enjoyment of the petitioner would not be disturbed or dispossessed of. In the recent past, when there is a wide publicity in the daily newspaper that sale deed would be executed in favor of the respondent number 10, Mrs. So and so, then only an inquiry it is found that the state government taken an arbitrary and illegal decision to execute the sale deed. Respondent 10 is a very powerful and very influential variable so and so may cause a threat of interference with the possession and enjoyment of the petitioner's land in the village, namely Arabanalli, Musinayakanalli of Sandur Taluk. Hence the cause of action and also illegality committed by the state government in the matter of public purpose. In my clear words, I have stated, my lord, about why
public purpose, not
now,
your purpose.
Now the public purpose also will take my lord to that in the context of the decisions rendered by the humble apex court. My lord, so far as my learned senior advocate is making submission that they have put some plants and also it is established. My lord, I have produced many number of photographs also to show that the position of the land and also the way in which these lands are been in use by these petitioners, my lord. My lord, may I kindly take my lord to the in the volume 2, my lord. It page number is annexure G series, my lord. 300, my lord, page number 300.
Yes.
My lord, these are the present situation and present status of the lands which continues in portion of these petitioners, which was acquired, which was the properties of their forefathers. Page number 300, annexure G, my lord. 300, again 301, where cultivation is made with the installation of this borewell. Again, my lord, 302 is the village of Masinayakanalli. Yarabanalli, Masinayakanalli, and Karakuppa, these are all hamlets, villages, one by one adjoining villages, my lord.
ನಿಮ್ಮ ಫೋಟೋ ಎರಬನಹಳ್ಳಿ ಅಂತಿದೆ, ಮಸ್ನಾಕ್ನಹಳ್ಳಿ ಇಲ್ಲ.
ಇಲ್ಲ, ಎರಬನಹಳ್ಳಿ ತೋರಣಗಲ್ಲಿದೆ, 306ರಲ್ಲಿ ತೋರಣಗಲ್ಲಿದೆ. ಆಮೇಲೆ 305ರಲ್ಲಿ ಅವಿನ ಮಡಗು, ಎರಬನಹಳ್ಳಿ. ಹೌದು, ಎರಬನಹಳ್ಳಿ, ಅವಿನ ಮಡಗು. 306ರಲ್ಲಿ ತೋರಣಗಲ್ಲು. Again,
what is the purpose? This is the village.
Now these survey numbers, they say that we have taken possession and we have established this sheds or industries, their contention, and they have put forth before the Sambal court in their counter by filing some photographs. Now to show these things where we are now and where our families are there, and we are also in possession of these certain lands where we are cultivating. At that time, one more thing, my learned senior counsel has made a statement that we are given ex gratia payment. Yes. Now, ex gratia payment is not for this land acquisition. When they caused disturbance and when they made an attempt to take out this gravels from our land, ಗೊರ್ಜು ಕಲ್ಲುಗಳಿದ್ದಂತ ರಿಮೂವ್ ಮಾಡಕ್ಕೆ ಇವರು ಹೆವಿ ಲಾರಿಗಳು ಆಮೇಲೆ ಟಿಪ್ಪರ್ಗಳು ಬುಲ್ಡೋಸರ್ ತಂದಲ್ಲಿ ಅವಾಗ there was great protest by all these villagers. Then at that time they paid little amount for the gravels, not for acquisition, not for ex gratia payment. They have prepared some the receipts. Now they have placed it as if they have paid for ex gratia. No, absolutely it is false statement by respondent number 10. When they tried and made an attempt to take out the gravels in our land, at that time they have taken these receipts and now they have manipulated and they have created this document as if they are given for this land acquisition. It is absolutely, they have played a mischief. They have played mischief, my lord. This is one point. Now, as it is
where is that document? Where is that receipt?
They have placed it in their respondents
page number
counter, my lord. I would like to take my lord to that counter. In the counter,
we have produced it at page 128 to 142 in the connected with petition. That is in 726.
726. No, 726 all objections.
my lord, 128 in their in 10,726 of 24, the earlier equation, my lord.
Page 128.
128 receipt ಅಂತ ಹಾಕಿದ್ದಾರೆ.
128 to 142.
Are there any of them being represented by, this is all the petitioners or somebody else?
Petitioners. There are petitioners or their family. Petitioners and their family members.
No, I say there are third parties. No one is there in our petition and no one has signed it. These are the receipts they have created, and for the purpose of the petition, they have come and placed it, manipulated receipts which specifically I am making statement, Malad. And the other day in my agriculture lands, when they deployed these bulldozers and these JCBs to remove the sand, ಯಾವುದು ಕೆಮ್ಮಣ್ಣು ಮತ್ತೆ ಗೊಜ್ಕಲ್ಲು, ಆವಾಗ ಬಂದಲ್ಲಿ ನಾವು ಅಬ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿದಕ್ಕೆ ಈ ಅಮೌಂಟ್ ಕೊಟ್ಬಿಟ್ಟು ಈಗ ಇದನ್ನ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಅಂತ ನಾವು ದೇ ಹ್ಯಾವ್ ಮ್ಯಾನಿಪುಲೇಟೆಡ್ ಅಂಡ್ ಕ್ರಿಯೇಟೆಡ್ ದಿಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಮೇಲೆ. ದಿಸ್ ಇಸ್ ಮೈ humble and respectful submission. These receipts are not at all concerned with the either land acquisition or payment of ex gratia.
My lord, your lordship asked me a question as to whether those people who have received payment are petitioners. Please see page 125, all the details are available. Which petitioner and ex gratia details and survey number, everything is mentioned. And the subject matter, the notification. In addition, they have also given employment. That details are also forthcoming at page 126.
They still continue in employment?
Yes, yes.
No, a small employment of either helper or something, not to all the person. There are, I can place it on record, my lord. The way in which they are now misrepresenting employment is not to the persons of the land losers or the persons who are involved in these families. These persons I can place even in that count also. They are not placing true facts. The entire companies or entire states are filled up by the, with due respect, my lord, with due respect, are all from the either North India or Assamese or Biharis. I have not against those persons. I can place with the names also. Names also I can place it. Now, after filing of this writ petition, the employees of helper or a small job person, they cause a threat also, for which these persons have informed to the government also. This is how they are doing. This is also another thing which my lord has to take into consideration. I can place that record also. I can place that record also. My lord, this is the, in respect of the removal of the gravels and red soil. ಕೆಮ್ಮಣ್ಣು ಮತ್ತೆ ಈ ನೋರ್ಜಿಕಲ್ ರಿಮೂವ್ ಮಾಡಲ್ಲಿ ಈ ರೆಸಿಟ್ಸ್ ಎಲ್ಲ ಬರ್ಸ್ಕೊಂಡು ಈಗ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಅಂತ ತಪ್ಪು ಹೇಳಿಕೆ ಹೇಳ್ತಿದ್ದಾರೆ. ದಿಸ್ ಇಸ್ ಮ್ಯಾನಿಪುಲೇಟೆಡ್ ಅಂಡ್ ಕ್ರಿಯೇಟೆಡ್ ಡಾಕ್ಯುಮೆಂಟ್. my lord, this is my respectful and humble submission.
ಯಾವಾಗ ಗ್ರಾವೆಲ್ ಯಾವಾಗ ತೆಗೆದಿದ್ದು?
ಗ್ರಾವೆಲ್ ತೆಗೆದಿದ್ದು 2022-23ರಲ್ಲಿ. ಆಮೇಲೆ 2019ರಲ್ಲಿ ಒಂದ್ಸತಿ ಟ್ರೈ ಮಾಡಿದ್ರು. ಅವಾಗ ವಿಪರೀತ ಅಲ್ಲಿಯವರೆಲ್ಲ ಗಲಾಟೆ ಮಾಡಿದ್ದಕ್ಕೆ, ಯಾಕಂದ್ರೆ ನಾವೆಲ್ಲ ಬೆಳೆಯೋದು ಕಡ್ಲೆ ಜೋಳ ಆಮೇಲೆ ಶೇಂಗಾ, ಅದಕ್ಕೆ ಬೇಕಾಗಿರೋದೇ ಅಂತ ಮಣ್ಣು ಅಂತ ಒಂದು ಎನ್ವೈರನ್ಮೆಂಟ್. ಅದನ್ನ ರಿಮೂವ್ ಮಾಡಿದ್ರು. 100 ಲೋಡ್ಗಳು ರಿಮೂವ್ ಮಾಡಿದ್ರು ಅವರಲ್ಲಿ ಹಾಕೊಳಕ್ಕೆ. ಆವಾಗ ರಿಮೂವ್ ಅಪೋಸ್ ಮಾಡಿದಕ್ಕೆ ಈ ರೆಸಿಟ್ಸ್ ಇದು ಅಮೌಂಟ್ ಕೊಟ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಇವಾಗ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಎಕ್ಸ್ ಗ್ರೇಷಿಯಾ ಅಂತ ಬಂದು ಹೇಳ್ತಿದ್ದಾರೆ. It's a totally false statement and misrepresenting statement, my lord.
Yes, Mr. Raghavan, is this paid by check or by cash?
It is paid by check. It is paid by check. Paid by check. I agree. I do agree. It is paid by check. Towards what account is only to removal of the gravel and red soil, not for the land acquisition. Not at all concerned.
My lord, your lordship asked me a question. Can I answer it? Kindly turn to one receipt at page 128. Your lordship gets a check number also.
Yes.
I am admitting you are giving it through check because you have to send that.
Gravel was removed in 2019 antira. Check was paid in 2004.
ಅಲ್ಲ ಬೇರೆ ಇವರು ಡೇಟ್ ಹಾಕೊಂಡವ್ರೆ. ಮತ್ತೆ ಬೇರೆ ವಿಚಾರಕ್ಕೆ ಹಿಂಗ್ ಬಂದಲ್ಲಿ ಅವಾಗ ಬಂದಲ್ಲಿ ಇವೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ. ಅಪ್ ಟು 22 ಇದೆ ರೆಸಿಟ್ಸ್. 2007 ಇದೆ.
ಪೆಟಿಷನ್ ಏನಾದ್ರು ಹೇಳಿದೀರಾ ಅದ್ರ ಬಗ್ಗೆ?
ಅಲ್ಲ ಈಗ ಹೇಳಿರೋದು, ಈಗ ಬಂದ್ ಹೇಳಿದ್ರು. ಈಗ ನಾನು ವೆರಿಫೈ ಮಾಡಿ ಕ್ರಾಸ್ ವೆರಿಫೈ ಮಾಡಿದಲ್ಲಿ ಬಂದ್ರು ಆ ಪಿಟಿಷನ್ಸ್ ಎಲ್ಲ ಹೇಳಿದ್ರು. ಇದು 2006ರಲ್ಲಿ ಇದೆ. ಅವಾಗ ಹೇಳಿದ್ದು ಇದು ಈ ಗ್ರಾವೆಲ್ ರಿಮೂವ್ ಮಾಡಕ್ಕೆ ರೆಡ್ ಸಾಯಿಲ್ ರಿಮೂವ್ ಮಾಡಕ್ಕೆ ಕಳ್ಕೊಂಡ್ರು ಸರ್. ಈ ಚೆಕ್ ಅಮೌಂಟ್ ಆ ಗ್ರಾವೆಲ್ಗೆ ರೆಡ್ ಸಾಯಿಲ್ ಕೊಟ್ರು, ನಮ್ಮ ಬೇರೆದಕ್ಕಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದನ್ನ ನಾವು ನಾನು ಕೌಂಟ್ರ್ ಇದು ಹಾಕೋದಕ್ಕೆ ರೆಡಿ ಮಾಡಿದೆ. ಅಷ್ಟೊತ್ತಿಗೆ ಇದೆ ನಾವು ಬಹಳ ಅರ್ಜೆಂಟ್ ಅಂದ್ರು ಅವರು ಮೂವ್ ಮಾಡಿದ್ರು ಬಂದಿದ್ದೀನಿ. ಕೌಂಟ್ರು ರೆಡಿ ಇದೆ ಅಂಡ್ ವಾಟ್ ಸರ್ಕಮ್ ದೇ ಪೇಡ್ ಅಂದ್ಬಿಟ್ಟು. ನಾವು These receipts will not hold any legal sanctity or legal value for the purpose for which now they have filed it, my lord. And furthermore is now in the where what's the stand of government, my lord, in page number in the second volume, when this cause of action has arisen and when we have offered this number 310, my lord, 310.
310 of
310 ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಬಂದಿದೆ. ಅವಾಗೆ ನಮ್ಗೆ ಗೊತ್ತಾಗಿ ಅವಾಗೆ ಇಲ್ಲಿ
ಯಾವ ವಾಲ್ಯೂಮ್?
ವಾಲ್ಯೂಮ್ 2 ಮೇಲೆ.
ವಾಲ್ಯೂಮ್ 2 ಮೇಲೆ, ವಾಲ್ಯೂಮ್ 2 ಮೇಲೆ.
ಅವ್ರ ವಾಲ್ಯೂಮ್ ನಿಮ್ ವಾಲ್ಯೂಮ್
ಅಲ್ಲ, ನನ್ನ ವಾಲ್ಯೂಮ್ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 10367 of 25 ನನ್ನ ವಾಲ್ಯೂಮ್ ಅಲ್ಲಿ, ವಾಲ್ಯೂಮ್ 2. ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 310. This is the paper publication. There are about 10 or 20 papers. Only one paper I have placed it, my lord. All repeatedly, one by one, they have published it. Then only the way in which these persons are doing is to say shocking news, because we expected and we anticipated and we have a lot of hope that a public sector of government will be established like our BEML or BGML or Vizag, but they did not. They have turned back and now they are doing all these things. Well, now the very object of notification, as I have taken, my lord, in the beginning of my argument, is page number 60 is Gazette, where the Land Acquisition Act of 1894, my lord, may I kindly take, my lord, to the provisions under 3F.
LA Act.
This is under Land Acquisition Act. Now this KDB, how it has come, it is under different statutes. How it has come and how they are playing this role is a moot question which this KDB and this government has to answer. It is a moot question. It goes to the very root of the whole issue. Now the government, my lord, section 3, my lord. 3F, may I kindly take F, my lord? 3 is the definition clause. I take one by one, my lord, up to G. I will take, my lord. The expression public purpose includes the provision of village site zones extension plan development. The provision, so I will take, my lord, to the
24/1984. We are talking for notification of 1971. What was the law here?
Please mute yourself.
The provision, my lord, sub 3, provision of the land for the planned development of land from public funds. Public funds is very important, my lord. Public funds in the pursuance of any scheme or policy of the government, and subsequent disposal thereof in whole or in part by lease, assignment, or outright sale, with the object of securing further development of the planned. The provision of land for the corporation owned or controlled by the state. Kindly note, my lord. It should be owned or controlled by the state. The provision of land for residential purpose, so and so. And 6 is the provision of land for carrying out any educational, housing, health, or slum clearance scheme, so and so. Government for carrying any of such schemes are with the prior approval of the appropriate government by local authority or a society registered under the Society Registration Act 1860 or under any corresponding law for the time being in force in state, or a cooperative society within the meaning of any law relating to cooperative society for the time being in force in any state. Provision of land for any other scheme of the development sponsored by government or with a prior approval of the appropriate one by a local authority. The provision of any premises or a building for locating a public office, but does not include acquisition of land for companies. I stress on this point, company. The following persons shall be deemed persons entitled to act and to extend hereinafter, provided trustee for other person beneficiary interested shall be deemed to be person entitled to act with reference to any such case, and that to the same extent as the person beneficiary interested could have acted in previous so and so. No person shall be deemed entitled to act.
Shiv Prakash. This public purpose has undergone definition so many times.
Yes,
ನೀವು
my lord.
ಓದ್ತಾ ಇರೋದು ಸೆಂಟ್ರಲ್ ಎನ್ಯಾಕ್ಟ್ಮೆಂಟ್ ಡೆಫಿನಿಷನ್.
ಹೌದು.
ಕರ್ನಾಟಕ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ ನೋಡಿ.
ಅಮೆಂಡ್ಮೆಂಟ್ ಓದ್ತೀನಿ, ನಾನು ಓದ್ತೀನಿ. ಯಾಕಂದ್ರೆ ಈ ಪಬ್ಲಿಕ್ ಪರ್ಪಸ್ ಮೇಲೆ the Honorable Apex Court in Ketina of decisions has rendered judgment and public purpose and what is public revenue. Revenue, even the corporation or a local body or a local authority, if they have paid 1 rupee out of their fund, it is the government revenue. But now there is no provision. If at all, if they want to acquire this land for this company or a private enterprises or a private company, the provisions under Chapter 7 of the Land Acquisition is squarely applicable, not under this Section 3 of the Land Acquisition. That's what in Kedarnath, or the state of Union of Government, has stated repeatedly, referring about 120 editions, where a public purpose, when it has been notified, it cannot be diverted or divested. The principle laid down by the Honorable Apex Court.
Yes. Yes.
My lord, now may I kindly take 1 or 2 paragraphs in my read fiction, my lord?
Now 367
ಅಲ್ಲ 367 of 25 my lord. ಎರಡು ಆಲ್ಮೋಸ್ಟ್ ಸಿಮಿಲರ್ ಆಗಿ ಇದೆ. ಇದರಲ್ಲಿ ಪಿಟಿಷನರ್ಸ್ ಮಾತ್ರ ಬೇರೆ ಆದ್ರು. 367 my lord, ವಾಲ್ಯೂಮ್ 1.
Para?
I am taking my lord, I am taking my lord. My lord, para 7 onwards, I may take little time, my lord, lengthy para. May I kindly beg a pardon for taking para 7, my lord. The petitioner submits that the entire extent of land in the Taluka of Sandur, which includes the villages of Haribanalli, Masnayakanalli, Tornagallu, Korekoppa, the land with rich iron ore, one of the prime public sector proposed by the government, but failed to give effect to implement the project as notified. Thus, the very object of notification is defeated. The very purpose and intent of legislature in the enactment of Section 3F and 4 and 6 of the Land Acquisition Act, which prescribe public purpose, is misused and abused by the colorable exercise of power. It amounts to fraud on power and fraud on statutes. For the reason, since 1971-72 till date, there is no sign of implementing the project. Very strangely, change of political parties in the state government by political party headed by the then chief ministers to favor the respondent number 10, obviously for extraneous reasons, take an arbitrary decision in contravention of the purpose and object of public purpose. During that time, there was news of leasing the land in favor of the respondent number 10. At that time, there was serious opposition by the landowners, local persons, people as well as the political parties in the opposition venture. At that time, it was published that the lease in favor of respondent number 10 is for a limited period. The government is intending to establish Hospet steel plant and the supply of iron ore to the government established public sectors through the respondent number 12. The government institution Mineral Corporation, however, the unholy nexus between the government and respondent 10 did not fructify the object of notification. In the year 2020, again, matter news that the government had taken a decision to execute absolute sale deed. What could not be achieved directly, respondent government is making attempt to achieve indirectly by circumventing the legal hurdles. Again, there was opposition on the ground that land acquired for public purpose, more specifically to establish a steel plant, same has been diverted to a private entrepreneur for a song. It is not only illegal, it is a clear fraud on people of Ballari and a fraud on power. Para 8, submitted that respondent 10 is making an attempt to cause interference and to change the nature of land by putting up construction. Wherever there is opposition by the landowner, the respondent 10 by adopting dubious methods through the government official, particularly police, is causing threat to the owners to initiate criminal proceedings and certain cases through the officers of the KADB, making certain paltry payment, obtaining signatures through middle persons and land brokers. The government, due to opposition by the general public, did not execute said it. However, subcommittee which was appointed to establish and submit a detailed report, Honorable Supreme Court of India, in the matter of involving huge exploitation of iron ore and transportation illegally, commission was appointed, chaired by Honorable Judge of the Supreme Court, Justice N. Santosh Hegde. Detailed report is submitted wherein respondent is indicated that illegal mining, illegal transportation, and illegal utilization of huge quantity of iron ore. Thus, it is reported that respondent so and so is arraigned as party in main proceeding with serious act of illegality committed. This is para 9, my lord. Submitted that a subcommittee and the Ministry of Law and Heavy Industries opposed grant of any permission or lease in favor of respondent 10. The report of the committee and the statement made by the concerned ministry for the purpose of convenience and brevity, the lands notified and survey numbers, extent of land are indicated in tabular column. Same are here produced at annexure F and F1. My lord. My lord, para 10, my lord. The petitioner submits that the revenue records indicate the crop grown, possession and enjoyment by petitioner till 2004. Crop grown and active cultivation has been indicated, same is evidenced in the RTC extract. Due to change in the computer RTCs, names of petitioners have been either deleted, not continued. However, in Kata column, the names of the petitioners are continued. Few photographs evidencing the cultivation of land and dwelling houses in the village of Masinayakanalli, Yarabanalli are here produced and marked at G series. Department of Rural Development, Social Welfare, Health and Family Welfare, Revenue Department have rendered ample of support to the residents residing in the village in providing infrastructure. Few photographs are here produced, marked at so and so. In the recent publication, duly published in the newspaper, circulated in the district of Bellary, the petitioners are shocked to know that the lands notified for public purpose, to wit a location for Vijayanagara steel plant, is under process of transfer. The title deeds in favor of restaurant number 10. So and so. The petitioners made inquiry with the authorities, but authorities did not respond, nor given any information in this regard. Recent paper publication is so and so, annexure J. Petitioner, though their advocate made application and a right to information before the Chief Secretary State of Karnataka, respondent number 1, for which the respondent 1 has replied, directing the Secretary Industries and Commerce to issue the required documents, namely decision taken by the Cabinet Government of Karnataka. Copy of the communication issued from the Office of Chief Secretary is referred at annexure D. It is submitted that one another application filed before the Chief Secretary to furnish information and decision taken before the Government of Karnataka and the Cabinet from the Office of Public Information Technical Section, Commerce and Industry. Copies are issued in respect of Cabinet decision dated so and so. Authorities submitted parawise tippani, wherein several important issues are not clarified or noted. One such issue is writ petition pending before the Karnataka Steel and Mineral Corporation Limited and JSW, presently pending before the Honorable Supreme Court of India. The respondent Government of Karnataka, knowing fully well, ought to have awaited for the final decision, since the Karnataka Mineral Corporation Limited is a government established. The vested interested bureaucrats, at the instance of respondent number 10, have diverted the entire issue by furnishing distorted notes, distorted facts to obtain cabinet decision. Further, the opinion expressed by the learned Advocate General is not forthcoming. Copy is not available. Thus, a serious doubt and suspicion in the entire process of decision making by the government. More particularly, respondent number 10 finds its name in the report of Lokayukta in illegal mining. Copy furniture so and so. So and so, my lord. My lord, I am taking next para. Para 12. Petitioner submits that during the year 2006-7, there was a much publicized mining scandal in the Bellary district. My lord, this is also about by the commission headed by the Lordship Justice N. Santosh Hegde. Taking my lord to para 13. It is surprised that the governance in the state of Karnataka was earlier ruled by one political party initiated for transfer. The opposition party in the state of Karnataka opposed for transfer of as well as on the value of the property. But presently the situation is vice versa. That earlier opposition party now is in power, have under the lame excuse of earlier cabinet decision. Honorable High Court in WP so and so have decided to transfer the land in favor of respondent number 10. The value for which lands are proposed for transfer is rate 1,25,000. It is for a sum the government is prepared to transfer is not only illegal but a colorable exercise by government in favor of respondent number 10. The subcommittee constituted by cabinet to look into the illegal mining chaired by the then Home Minister in the year 2019. No signatures subscribed. The subcommittee and Home Minister, it is a deliberate act by suppressing or overlooking all these vital issues aspect, and also the report of Justice N. Santosh Hegde Commission. The respondent authorities have totally misled and placed distorted facts before the cabinet for approval to execute sale deed in favor of respondent 10 JSW. Also pertinent to state that special leave petition is pending before the Supreme Court of India. Ignoring this fact, the government in the cabinet dated 27/5/21 did not approve the execution of the sale deed, and same has not been affirmed. The SLP before the Honorable Supreme Court in SLP so also is pending for consideration before final adjudication. The government fixing the price of 18 lakhs so rupees 18 crore 10 lakh for an extent of 2,000 acres, and further there is one other public interest litigation filed before the Honorable High Court of Karnataka and WP so and so. Operative portion of the order passed before this Honorable Court reads as under. Decision taken by the earlier government headed by the then Chief Minister so and so and subcommittee headed by Shri so and so has not been reaffirmed, and the entire matter shall be relooked into by the Honorable Chief Minister. However, we make it clear that all contentions are kept open, and in the event the government takes decision in this regard to subject matter is always open for petitioner to seek revival of the order. By suppressing all these facts, respondent 10 so and so approached this Honorable Court, filed writ petition so and so and sought for mandamus. The present government, knowing fully well pendency of the matter before the Honorable Supreme Court of India and report submitted by Justice so and so Commission, did not place true and correct facts before the Honorable High Court of Karnataka and WP so and so. In fact, and in circumstance, this Honorable Court issued writ of mandamus by virtue of the order passed through though on the factual matter, government differs with the opinion in the matter of transferring by way of sale deed in favor of the respondent number 10. Have not assailed the order till date. It indicates the political favor and benefit to respondent number 10. The government, by act of colorable exercise of power, has fraudulently caused a diversification of purpose for which land is notified. For acquisition, more so land acquisition for public purpose. Transferring to a private company entity is not permissible in law. Honorable Supreme Court in the decision law laid down in 2011, 10 SCC Royal Orchard Hotel Limited, and another was Jairam Reddy, and other diversification is not permissible. The present government, it is a doctrine of convenience adopted by all the political parties, whether past or present, for extraneous reasons and extraneous benefits, have permitted to execute the sale deed in favor of respondent number so and so. Thus, there is a total illegality and malafide. It is a colorable exercise of power by the state government. This petition before the Honorable Court. In the village of Erbanalli are facing serious health hazard solely on account of the unit paint and tar establishment by so and so. The entire area and village is endangered with a pungent smoke and polluted air with huge industrial dust. The entire village and surrounding population is suffered with the chronic diseases of lungs, heart, skin. Despite a resolution passed before the Gram Panchayat and several complaints registered, state government and pollution control board are maintaining silence. Obviously, it indicates the amount of influence by respondent 10. Few photographs evidencing the polluted water, dust accumulated during the daytime, and the chronic severe health disorders suffered by the people are produced and marked at annexure L1 to L9. For a minute, I pause it at this paramela. Annexure L and annexure 9. May I kindly take my lord to the annexure L and 9? L1 to L9. At the second volume. My lord, it is in second volume, my lord. 332. The second volume, page number is 332, my lord.
Yes.
My lord got it. My lord. Now the manner in which this so-called respondent 10 has caused havoc in the health hazard to these infants and children. My lord, these are the photographs, and the manner in which the polluted things in the entire environment of this village and the habitants, they cannot. And every time there is a protest by these persons that this also becomes one of the Union Carbide, which is a classic historical incident which has happened. This government is allowing and almost destroyed, and they are to say persons who, though of course living, it's a dead atmosphere they have created. My lord, annexed 335 and again my lord 336. My lord, for one to say 10 minutes or half an hour in page number 337, my lord. 337.
Yes.
For 10 minutes or half an hour, the manner in which this carbon is accumulated on the people and in the vehicles